Hello, everyone. Thank you for joining us once again here on Immigration and Jobs Talk Show. I'm your host, Nipasa Pradhan, and it's seriously an absolute pleasure to be here once again with another very insightful webinar lined up for you. But before we move ahead with today's discussion, I have this very important disclaimer, and that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, friends, thank you once again for joining us here on Immigration and Jobs Talk Show. And this is a great place for you to be in, especially if you want to know more about U.S. immigration and business opportunities, because we are going to dive into a topic, that has definitely sparked significant interest. So, how entrepreneurs and investors can be on the ground doing business in the U.S. in under 6 months. And yes, to help us, dive deeper into the key insights on E2 and L1 visas, we are going to be honored by the presence of none other than our guest for today, um, Mr. David R. Fulmer, an exceptional immigration attorney and a leader in his field. So, Mr. Fulmer is a partner at WR Immigration with over 2 decades of exclusive practice in immigration law. He's been recognized as Immigration Lawyer of the Year and is celebrated for his expertise in assisting companies, entrepreneurs, and even entertainers, navigate immigration challenges. So, for all our viewers, whether you are an entrepreneur, dreaming of setting up a shop in the United States or your business, or maybe an HR professional overseeing visa processes. Well, thank you so much, all you immigration enthusiasts, for being here. And without further ado, please help me welcome our guest, Attorney David Fulmer. Thank you so much for joining us.
Thank you very much for having me, Napasa. I'm thrilled to be here.
Absolutely lovely. And I'm so excited because this is the first time you're here. And we would love to get to know you better. Maybe tell us more about yourself and anything else is something interesting to share if you have any.
Well, I'm lucky enough to live in Los Angeles, and it's an amazing place to live. Our offices are steps from the beach, and I also live about 5 minutes from the beach. So it's an amazing place to be. It's an amazing place to welcome immigrants from other countries, and I think it really exemplifies the best that the United States has to offer. So I'm really happy to be here.
It's an absolute pleasure to have you here. And I can only imagine what a great vibe you must be surrounded with. I mean, the beach always gives you good things, I think, the sunshine and a lot of palm maybe. But yes, I can only imagine. So thank you so much. And well, with regard to today's topic of discussion, how entrepreneurs and investors can be on ground doing business in the US in under 6 months. So, what can folks out there who have joined us or will be joining us in this session, what can they expect from us today?
Well, today we're going to talk about e visas and L visas, and these visas really do present an opportunity for people to kind of direct their own destiny. A lot of times people think about coming to the United States on an H1B visa, which is amazing and it's great, but it requires them to find a job offer. Or they think about maybe being petitioned under EB2 or EB3, and those are amazing as well, but it requires both a job offer and a very long wait. But E2 and L1 are really opportunities where if you're from the right country, in the case of an E2, and if you have the funds and if you have a business plan, that you can actually direct your own destiny and move to the United States, bring your family to the US. It's an opportunity for people's spouses to work or for their kids to be part of the US education system, all based on their own funds, their own business plans.
Absolutely, friends. Today we are going to discuss about E2 and L1 visas, and especially all you folks out there who are businessmen and who want to maybe expand your business go start a business, great place to be in. So, yes, I think without further ado, I have my first question for you, David. And this is with regard to this change of administration. How might President Trump's immigration policies impact pathways for entrepreneurs? and the processing of L1 and E2 visas, considering the administration's historical focus on stricter visa regulations?
That's a very good question, and the answer is not necessarily straightforward. There's two things we can look at. First of all, we can look at the prior Trump administration and what they did, and then we can look at some other issues relating to the incoming Trump administration. So, first of all, looking back historically, the prior Trump administration implemented a policy called Buy American, Hire American, and the idea of that policy was that in relation to any visa or any immigration process, they wanted to make sure that um, issuing a visa for that individual would not hurt the wages and working opportunities for U.S. citizens. So it was always a part of, during the Trump era, we always had to demonstrate that jobs would be created. With E&L visas, that's already part of the program. So that's one thing. Next, over the last few years, a lot of U.S. consulates have been waiving in-person interviews. And what that's done is, I wouldn't expect that interviews would be waived for E&L visas, but waiving of interviews for, say, people who are getting extensions of their H1B visa has kind of opened up resources for quicker processing of other visa types like E2s. And so getting rid of interview waivers will probably cause some delays. If you'd want, I can talk a little bit about another interesting aspect of it, Napasa, which is
Sure.
everyone knows that Donald Trump has been very close to Elon Musk. Now, Elon Musk is a
Right.
business leader from Silicon Valley, and so we're also hoping that Elon Musk will have President-elect Trump's ear, and he might influence him to be a little bit kinder and gentler and a little bit more efficient when it comes to visa issuance. So on one hand, we can expect things to be stricter and slower, but we're hoping possibly that Elon Musk might have some influence and might be able to influence things in a positive way.
Absolutely. And looking at how close they are, I think he might as well. And both of them business minded, they would love to soar with regard to business. So I'm sure this is going
Absolutely.
to be good. And right, right. But yes, on the other hand, like you were saying, like stricter rules, and maybe they are going to just make the situation even harder, that they, finally drain out or give up and just go away to their own countries. Who knows?
Absolutely.
So,
I mean, I think that we will have more RFEs. Normally, when you file an L1 petition, there's always going to be a chance that you could have a request for additional evidence. During the prior Trump administration, there were a lot more requests for evidence. And so I think we can
right,
expect more requests for evidence, which will cause processing times to extend a little bit.
right, right. All right. So, folks, we have mixed things to look forward to, but I think it's always best to stay on the right path and do the right thing and keep your documents right. And there is no limit to your dreams. So keep dreaming high and work for it. Yeah. All
Absolutely.
right. At this moment, I would like to say hi to Sneha. Thank you so much for joining us here on YouTube. I can already see your comments. Stay with us. All right. We are going to address your questions a little later in this webinar. Now, moving on, David, I have the second question, and this is, for entrepreneurs looking to establish their presence in the United States, quickly, especially, they don't have time to wait or don't want to wait that long. What are the critical steps to secure an E2 or an L1 visa within 6 months? Is it possible?
It is possible. So first of all, the key point with relation to an E2 visa is um, the individual needs to be from a treaty country. And the US has E2 treaties with many countries, but not every country. We have E2 treaties with about 85 countries, but we do not have them with the BRICS countries. So not Brazil, Russia, India, China, or South Africa. But if you are from an E2 country, then the E2 is a possibility. Otherwise, you have to go through an L1 visa, which has additional requirements. So if you're from an E2 treaty country, the first thing you'll need to do is really set up a business plan, decide what type of business you would like to be in the United States. Then you'll have to set up an entity in the United States. You have to set up a corporation or an LLC, register it with the Secretary of State in that state, get a tax ID number, set up a bank account, and then you can fund the company, and that's really the first step.
All right. Thank you so much. Thank you so much, David. I think that makes us hopeful at least. And maybe, are there any tips or maybe additional things that folks can keep in mind when they are in a hurry to be out there in the US?
Well, I think it's good to be in a hurry, but more importantly, to be in a hurry is to make sure that they're in a business that's going to be successful in the United States. So first of all, I recommend that they look at themselves, look at their history, look at what they're good at, and look where they could be competitive in the United States because the business environment in the US is very competitive. And so rather than being in a rush, I think people should analyze where they think they can have an impact, where they can be successful in the United States. Once they've done that, yes, then they need to connect with advisors in the US, both an immigration attorney, a business attorney, to set up the US entity. And then another key thing is to find a general manager in the US that can kind of help them be um, feet on the ground because there's a lot of things that they may not be able to do from overseas before they obtain the visa. And even if they come to the United States, they wouldn't be allowed to work until they obtain the visa. So hiring a general manager to be really feet on the ground will also be very, very key thing to help them to be able to move this ahead quickly.
Right. Thank you so much. Thank you so much, David, for, walking us through and giving us tips on how to quickly, get yourself ready for an E1 or an L1, for an E2 or an L1. Thank you. Thank you. So now moving on to my next question is, how can, a startup entrepreneur from a treaty country, demonstrate a substantial and non-marginal investment for an E2 visa while meeting current USCIS standards?
Definitely. So really, that's two questions. There are several requirements to obtain an E2 visa. One is the investment needs to be substantial, and then the regulations say that the business cannot be marginal, which is kind
Mhm.
of a strange word. What does marginal mean? Well, they go on to explain that a marginal business is a business that only generates enough revenue to support the investor and his own family. And so the rule says the business cannot be marginal, which means that it needs to be successful enough and generate enough revenue to hire US workers. So, really, what it should have said is that the business will support US workers. And so I believe that goes back really to the business plan. The government needs to be able to review the business plan and see that the businessman makes sense, business plan makes sense, see that it's logical and believable that the company will be able to generate revenue so that it can employ US workers. So that's marginality. You asked me about substantiality. The regulations also say that the investment needs to be substantial. And I have my clients all the time ask me, David, how much is substantial? And I wish that the government would tell us exactly what they want. In another context, in the EB5 program, the law specifically says 800,000 or 1,050,000. But in the E2 context, the rules only say substantial. So what is substantial? It really goes back to the same thing that I said relating to marginality. And that the investment needs to be enough so that the government believes that the business will be successful and generate revenue both to support the investor and the U.S. workers. However, I think there are some limits to what is substantial. Sometimes have people asking me, David, can I apply for a visa with a $20,000 investment or $50,000 investment? Lately I haven't seen E2s being issued with under $100,000 investment, and I'm often seeing people investing, around 200,000. Again, the law doesn't say, doesn't give a specific amount, but usually lately I'm seeing people investing at least a couple $100,000.
Right, right, David. And that's a lot. I mean, for folks out there who were just expecting to start something within 20, I mean, they have to go 5 times more. So
Well,
there you go.
I
And
think we're gonna get
yes,
to that
it's
later, I believe. But sometimes if somebody doesn't have that type of funding, then an L1 visa would probably be a better route.
right. So we're getting to that. Thank you, David. Thank you for, telling us about USCIS standards and the E2 visa bit. And also, Vikas has joined with a few questions. Vikas, please stay with us. We are going to address your questions a little later, but thank you so much for joining. And now moving on, David, what are the key industries or business models that are currently seeing faster approvals for E2 and L1 visa applications?
So, what I can't tell you is what models are being approved or being approved more quickly because it's really wide open. What I can tell you is models that won't work. And models that won't work are the passive um, businesses. I have a lot of people telling me, David, I want to buy a house. I live close to Malibu. I want to buy a house in Malibu. It's going to cost $10 million. That's a substantial investment. Can I get a visa with that? The answer is no.
Mhm.
It is an investment. It is substantial, but it's not going to meet the marginality requirement. It's not a business at all. It's not going to generate income for anyone. I have other people asking me if they can be passive investors in minority interests in companies. So, can they be essentially investors and get visas? And the answer is also generally no, because that is not an active business that generates employment for U.S. workers. So, what we're looking for is active businesses. Some common ones are restaurants. Restaurants require a lot of human capital and require a lot of funding. So that's a very common business. But I've seen people obtain visas from almost every industry. It simply has to be an active business and not a passive investment.
Okay. Okay. Thank you so much for telling us about that as well. And anything important about USCIS standards to keep in mind? Maybe something, when people out there are trying to fit themselves within E2 or L1. Anything else to keep in mind?
There are a lot of things to keep in mind. The focus really is on will the business support the U.S. workers? That's a
Right.
very key point to always keep in mind. A lot of people think, yeah, they can invest and get to the U.S. and kind of figure it out from there. But when they invest, they need to when they apply for the visa, they need to submit a pretty detailed business plan, and the
Yes.
business plan needs to spell out, their business model, how they think they're going to be able to generate business, what they're going to do in the U.S., and how they're going to, generate enough revenue to create and maintain U.S. jobs. So I think that's a really key point, and it's going to be more important
Right.
during the Trump administration.
Right. So the question is it going to benefit the United States? And that's what you
Absolutely,
should keep in mind.
absolutely. I mean, I know that it will benefit the foreign investor, but what does the U.S. government care about? How it's
Exactly.
going to
Yes.
benefit the U.S. They want to see that those funds have been put into the U.S. economy and spent. So it's not just that they take that 100 or 200,000 and put it in their U.S. business bank account. They want to see that most of that has been utilized and spent and pushed out into the U.S. economy, and that U.S. workers are going to be hired. So it's a win-win. The foreign investor will be able to live in the U.S. Their spouse will be
Right.
able to work. Kids will be able to go to school. They'll be able to do business in the U.S. and the U.S. will benefit quite a bit from each E2
Exactly.
or L1 that comes into the U.S.
Absolutely. Thank you, David. Thank you so much for the detailed explanation. And now moving on, if a new entrepreneur already has an operating business abroad, what documentation is critical to establish the connection needed for an L1A visa?
Absolutely. So if they already have a business operating abroad, that's a huge head start, and so they will be able to obtain what we call a new office L1. But before they can apply, they need to set up their U.S. Entity, and the U.S. entity has to have a qualifying relationship with the foreign business. So that can be that the U.S. business is a wholly owned subsidiary of the foreign business, that it's a sister company of a common parent, that it's at least a 51% subsidiary, or that the U.S. business has the exact same ownership in the same percentages as the foreign business. So we call this a qualifying relationship, and this is a very very key initial issue that needs to be addressed each time.
All right, David. Thank you so much for that and for the detailed explanation. I think now we should move ahead to our next question. And That is, what factors should an entrepreneur consider when selecting the US location for their new business under an E2 visa?
Absolutely. So a lot of people just want to do business in the United States. Other people understand that the US is a very large, very diverse country with really 50 different jurisdictions inside of it. Each of the US states have their own cultures, their own laws, and they even have their own taxation systems. So before they set up business in the US, I believe that people should talk to a tax advisor to determine if one state will be better than another. I have a lot of people that want to do business in, say, Florida or Texas because there is no state income tax. I have other people that don't really care about taxation. They want to be by the beach. And so they're going to live in Los Angeles or Florida, some even in Hawaii. And so really it's a personal decision taking into consideration the business climate, taxation, and personal preferences.
All right, David. Thank you so much for, getting us through, for establishing a good connection that is required for an L1A visa. Now, moving on, I have another question, and that is about E2 visas. So, how can small businesses, now, especially after the pandemic, I think we see a lot of new businesses coming up. I think during that time, almost every household, or many households, they started their new businesses from home, from online and everything. So I think that trend is still on. And nowadays, everybody shopping online, I think it's become a very big thing, startup businesses and everything. So how can small businesses, and first time investors overcome the common challenges of proving their business viability for an E2 visa?
That's a very good question. You talked about people doing business, kind of side gigs from home. The new E2, the Foreign Affairs Manual relating to E2 visas says that an E2 visa can't operate out of a home office. But how can they do a good job of establishing that they are a viable business? I believe number one, even though the regulations say they can have a home office, they need to have physical presence. Next, a lot of businesses nowadays are service businesses. Even me as a lawyer, this is service industry. It doesn't take a lot of capital to set up a law practice. It takes a computer and a good connection to the internet. But and many other businesses are like that. They don't require much capital investment. But to be a good E2 business, in order to obtain a visa, it has to be the kind of business that does require capital investment. So it has to be the type of business that requires an office or a plant or a facility and inventory. So these are some key points. That physical space, and it has to require that investment, and it has to be invested in the right
Okay.
thing. Yeah.
Okay. No, you were saying you can
Okay.
continue.
Yes. I was contacted by some people from Canada, and they had invested about 100,000, and they wanted to open up a business where they were going to set up Airbnbs. And it sounded good because I know in order to set up Airbnbs, they have to either purchase or lease a property. They have to outfit it with furniture and technology. And so I thought it could be good. When I looked at what they put their money into, they put their first 50,000 into courses on how to be successful in the Airbnb industry. And while those might be tax deductible according to the IRS, I didn't believe that those would be considered to be proper investments for the E2 visa. So the investment has to go into the right area.
Right. And well, when you say right area, like that has to still benefit US and only then they can be considered, right? So if in case they do not benefit the US or, there is like a chance that the US does not need this kind of business. There are chances that they can never start that business, right?
Well, so first of all, you ask, what if the investment does not benefit the U.S.? So I've seen some scenarios where somebody sets up a business, so they make an investment, they set up a storefront, and they
Hmm.
purchase supplies and equipment, but then they purchase the inventory from a foreign country. And I'm asked, well, does that purchase count as part of the investment. It does, but I believe that it might not get full credit. I believe that the U.S. government will probably favor purchases that come from the United States, especially under the Trump administration, where we're going to have the Buy American, Hire American policies. And so, yes, if the government, if the U.S. consulate does not believe that the investment is substantial, and this is, again, the numeric number is not set in stone. They don't feel like it's enough. If they don't like it, they can deny it. They have a lot of discretion to deny the visa application.
All right, David, thank you so much for, walking us through, L1A visa and how important is it, for an entrepreneur to prove that they are going to benefit the US, and of course that they are doing the right kind of business, and maybe they are very innovative. So yes, thank you so much. And now moving on, I have
quick point. Oh,
sorry. Yes, David, please say.
if it's okay, one other quick point. The business that they're in the United States needs to be legal according to US federal law. And I've seen a few people from countries like Canada operating in an area that's technically legal in some other countries and legal according to some states, but not legal according to US federal law. What I'm talking about is anything related to cannabis or marijuana. In California, according to state law, it's generally legal to purchase and if you have the right licenses to sell. But according to US federal law, it's not legal. So people, if they want to obtain a US visa, they should stay 100% away from any industry that has the taint of being connected to something that's illegal, even according to US federal law.
Right, very important thing to keep in mind. So, folks, thank you so much, David, for highlighting that. And folks out there, that's a very, very important thing. So, Vikas, thank you so much for more questions. We are going to come to that. But I think at this moment, it's time for a short break. So, folks out there, you can also have a one-on-one discussion if you're loving David's ideas, advices, and knowledge, and maybe you want to consult him with regard to your case. Why not contact him as well? You can call him on his number, and his phone number is 310-570-4065. And you can even email him dfulmer@wolfsdorf.com. DFULLMER at WOLFSDORF.com. And yes, go visit www.wolfsdorf.com. Don't go anywhere. Stay tuned to Immigration and Jobs Talk Show. Well, I'm Napasa Pradhan with none other than attorney David Fulmer. Hello and welcome back, everyone, to Immigration and Jobs Talk Show. This is the second half of the webinar we are having, and I'm Nipasa Pradhan with today's guest, none other than attorney David Fulmer. Yes, he is an amazing immigration attorney who is based out of Los Angeles, and it's such a great honor and a pleasure to have you here with us. Today, we're discussing about how entrepreneurs and investors can be on the ground doing business in the US in under 6 months. So it's been a great discussion so far, and we have a lot more questions to cover. And also, folks out there who have questions for us, Vikas and Sneha, we are going to take up your questions. And I would also like to ask you folks to also join us in this conversation. You can participate by asking your questions in the comment section wherever you've joined us from. We are streaming live on YouTube, LinkedIn, Facebook, and X. And yes, David, it's been a great discussion so far. Thank you so much for doing this.
Thank you for having me. It's been a lot of fun.
Thank you. So, I have another question, and that is what are the primary differences between E2 and L1 visas that we are discussing today? Both for entrepreneurs, and how should one decide the best fit based on their business goals?
Absolutely. So first of all, the first thing to look at is whether or not an individual is from a treaty country. So if they're from a treaty country, then both possibilities are on the table. But if they're not from a treaty country, then the E2 can be dismissed. Secondarily, the the business needs to be majority owned by individuals from the treaty country. So if we have a transferee from a treaty country, but the business is majority owned by his partners who are from another country, that's not going to work. So first we look at the treaty country. If the individual is from a treaty country, then E and L are both on the table. Next thing we would look at is whether or not the investment is substantial. As I mentioned before, E2 does require a larger investment. And so if the investors were thinking that they were going to set up a business with a lower amount, let's say $40,000, $50,000, then they would definitely they should definitely go toward an L1 instead of an E2. Now, if the investment is substantial and they're from a treaty country, then which is better, E or L? There's some factors to consider. First of all, for a new office L1, they're only going to get a 1-year visa, where with an E2, depending on where they're from, they might get a visa that's valid for up to 5 years. And so if they're looking at saving costs and kind of getting it done and not having to worry about it in the future, then perhaps an E2 is better than an L1. However, with an L1, the L1 new office rules do allow them to apply essentially based on a business plan. And so theoretically, maybe it's a little bit less work in the business setup to obtain an L1 than it is to obtain an E2. Now, the other big difference is that an L1 visa is a dual intent visa, where an E2 is not technically a dual intent visa. That means that when you obtain an L1, you can have the plan and intention to obtain permanent residency in the United States. Where with an E2, you need to have the plan to depart from the United States once you're done doing business in the United States. That's a big difference. Finally, an L1 visa allows for an opportunity for applying for immigration or green card under the EB1C category, where E2 does not necessarily present that opportunity. So these are some factors to consider when you're trying to determine which is better, E2 or L1.
Thank you so much for highlighting the differences, David. And I'm sure, folks out there who are in a dilemma where to categorize themselves, they have a clearer picture now. Thank you so much. And moving on, now I have another question, and that is, if an entrepreneur, if an entrepreneur's visa is tied to a new business that faces unforeseen challenges or restructuring, what options do they have to maintain compliance and their immigration status?
That's a good question. And this comes up a lot because plans are great. But once they obtain the visa and arrive in the United States, sometimes business does not go according to plan. In fact, maybe it never goes exactly according to plan. But what happens if, they get to the United States on their E or L visa and it's really slow. It's hard to get customers. And so First of all, on an E2 visa, if they obtain a 5-year E2 visa, they do have a little bit longer to turn the business around. Maybe they can't maintain all of the employees throughout the whole 5-year period, but they need to make sure that they have been able to turn the business around by the time it's time to renew the visa. And secondarily, they cannot close the business. So let's say that somebody has an E2 visa and it's tough and they can't maintain all of their employees. If it's a retail store and they close the store and they're no longer in business, then they're no longer in status. So they need to keep on trying. Sometimes that means reinvesting, investing more capital. It might mean changing the business model slightly. It might even mean changing the location slightly. But they need to stay in business, to stay in status, and stay in compliance in the United States. If somebody gets a new office L1, they only get a 1-year visa. And so the pressure is on to be successful and to step up within the first year. And if business is tough, if the contracts aren't coming and the money isn't flowing in, they do have the option again to invest more money to maintain the business and to be able to get that extension after the first year.
Okay. Thank you, David. Thank you so much for, walking us through. And now moving on, I have this next question, which frequently comes in mind, and we find them a lot in our groups also. And, folks out there have this question. So how can entrepreneur, transitioning from a visitor visa to an E2 visa ensure that they meet the strict timeline requirements for operating the business in the US?
That's a good question. So first of all, I would hope that if someone is entering the US as a visitor with the plan of obtaining an E2, that they enter on B1 instead of B2. Because usually when people obtain a B visa, it's B1/B2. So if they enter the US on a B1, then they're going to have 6 months to either depart from the US, or technically they may be even able to file the change of status in the US from B1 to E2 status. So if they know what they're doing, and if they have 6 months, that should generally be long enough to go through the steps of, again, setting up the entity, registering with the Secretary of State, getting a tax ID number, opening a bank account, transferring the funds, and then setting up shop. So if they know what they're doing, 6 months is long enough. If they have no idea, then it's going to be more difficult. If someone has no idea what they're going to do, they should probably look into a franchise, because a franchise will kind of have the business plan spelled out. So they should probably talk to a franchise broker and see if there's an opportunity that they're interested in an area that they're interested in, and that's within their budget. And then a franchise should offer a way for them to be able to kind of roll forward pretty quickly, even if they don't know quite what they want to do.
Okay. All right. Thank you so much, David, for that advice and tip, I would say. So now moving on, I have this next question, and that is, for investors planning to use an L1 visa to expand their company into the US. So what strategies can help them build a stronger case for a new office, for a new office petition while ensuring the timely approval?
Absolutely. So first of all, it's really important to look at the foreign business and the person's role within the business to make sure that they're going to be able to be categorized as a manager. So, the L1A visa is the visa for foreign executives or managers that are transferring into the United States to be managers or executives in the United States. It's very important to kind of look at the position abroad first before you launch the case into the United States. So is the person a manager? A manager has 3 subcategories. It can be an executive in a large company, a C-suite executive. It can be somebody who is what's called a personnel manager, who manages 2 levels of staff beneath them, or it can be a function manager who doesn't necessarily have direct reports, but who manages a very essential function of the business through indirect reports. So first of all, do they qualify based on their current position? And that's really the first step before even thinking about launching that business in the US. If they don't qualify, they need a year of qualifying time. Maybe they should adjust their position and wait 1 year so that they qualify, and so they will not have any problems when they launch the business in the United States.
All right. All right. Thank you so much, David. I think that would really help all of us, and it has definitely given us a clearer picture on how to go about either E2 or L1 or where can they actually fit themselves in. And I think now we should definitely go address these questions we have from our viewers. And I will take up Sneha, our first viewer, and her questions. So she says, I've already set up a business in my home country, but I want to expand to the US. How quickly can I establish a US branch under the L1 visa? And what steps should I prioritize to ensure a smooth application?
So, first of all, again, it's great that she has her business set up overseas. That's excellent. The question is there enough going on in that business to support an L1 visa? So, it's going to have a number of employees in order for her to be deemed to be a manager. So, in an ideal world, I'd like to see it have 10 or 12 employees at least, and a structure that's with a hierarchy where she's at the top, there are mid level managers beneath her, and then the workers below her. That would be what's called a personnel manager. So before she thinks about setting up in the US, make sure she's built up her foreign business. Also, the foreign business needs to be strong enough that when she transfers to the US, it continues to be in business. Because if she gets the L1 visa and the business outside of the United States, winds down, then the L1 visa is no longer valid. So it needs to be really built up and strong enough to be able to support the transfer. Next, the procedure of setting up the entity in the US is really quite easy. But the first thing she should do is talk to tax advisors and see if they have any suggestions on the structure and the location. There are a couple of ways it can be done. It can be done as a subsidiary of the foreign business, as a sister company of a common parent, or the shares could even be owned by her individually as long as the foreign business and the U.S. business are owned by the same shareholders in the same percentages. So strengthen the foreign business, get tax advice, and then get an attorney to help you set up the U.S. entity.
There you go. It's always best to have a US attorney, to help you navigate or, guide you through any of your visas because they are the experts and they know that each case is different and every case is special and every case needs special attention. So, yes, thank you so much, David, for taking that up for Sneha. And, I would like to share my screen now because we have more questions in our groups. So, I think I'd like to take them up first before we take up Vikasa's question. So, let's take this one. This is from an anonymous participant asking, my L1B petition was approved on 15th of August in premium processing. Still, I have been waiting for the approval petition, and my company visa team is saying they are yet to receive the petition documents from attorney. Usually, how long does it take to receive the approved petition? That's the question.
So the question says that the application was filed through premium processing. And so when something is approved through premium processing, generally the attorney who filed the petition will receive the approved I-797 within about a week. And if it's not received within about a week, then the attorney or the petitioner should contact USCIS. Because premium processing was utilized, there's a little bit more customer service. And so the attorney or the petitioner can email premium processing to tell them they have not received the approved I-797. It should not take long. If it was approved in August, here we are in November, that's a problem. And that should be aggressively followed up on because there's no reason for that to happen these days.
Right, that means that is not a good scene. But thank you so much, David, for taking that up and for
Absolutely.
the answer. Now I have this next one. This is also from an anonymous participant asking, when looking at the wait times of interview waiver for L1 visa, it doesn't give any information on wait times. It's just blank. Also, when looking for an appointment for Dropbox for L1, it doesn't show any slots. Are there any changes to the process for L1 visa renewal stamping? Also, did anyone get it done in Mexico instead?
Okay, so we have a few questions here. First of all, I think first of all, they're asking about interview times for an L1 under visa wait time. So the Department of State has a web page that's called Visa Wait Times. So you can Google it, you can find it. It says Visa Wait Times. You type in the city, and it will tell you the common wait times for each different type of a visa. And for some, and from consulates in some categories, it'll tell you the waiting time for interviews and interview waivers. So if it doesn't list it for interview waivers, sometimes what we have to do is kind of analogize it. So if it doesn't say L1 interview waivers, perhaps you can look and see what it is for H1 interview waivers and get a general idea of what it's going to be. Apostle, can you bring it up on the screen so I can see the rest of the question?
Sure.
When looking for an appointment, Dropbox L1 doesn't show any slots. It could be that they're not allowing for Dropbox appointments for L1s. If it's not showing any slots, or you may have to email the consulate and see if they'll respond to you about that. Processing in Mexico. So processing in third countries may be a possibility. I can't say I have done too many in Mexico lately, but it may be a possibility. What you want to make sure is if you're processing in a third country, you have a visa to get into that third country. That can be an issue sometimes. And you may want to contact the consulate to make sure that they're open to processing the visa there if it's a third country.
All right. Thank you, David. Thank you so much for that insight, and that was really helpful, I'm sure. Now, moving on, I have this next one. This is from Naluri asking, is it okay to apply L1A extension in premium now? Bunch of thanks in advance for your response here.
There's no reason to not apply for an L1 under premium processing right now. It's available, and generally these days people utilize premium processing whenever it is available. Sometimes there are strategic reasons when you won't want to, but in most cases people are utilizing premium processing on any category that's available, and I don't see a problem with it in general.
All right. Thank you so much, David, for taking that up. Now, I have another question, and this is also from another Facebook group from an anonymous participant. What are supporting documents required for converting L1B to L1A category?
Okay, so that's a good question. L1B is for someone with specialized knowledge. L1A is for a manager, and so the assumption is that you were probably in your home country were working in specialized knowledge. When you transferred to the U.S., you were working specialized knowledge, and now you've been promoted into a manager, or you will be promoted into a managerial category. And so you'll have to prove that the employer does have a position for you that fits the managerial category. And so what does that mean? Usually you're going to have a detailed job description. You'll have to have an organizational chart to show the people that are going to report to you. And you usually have to demonstrate what titles and what duties those people have so the government can see that you really are turning into a people manager from a specialist.
All right. Very interesting. Thank you so much for taking that up, David. And thank you, anonymous participant, for the question. Well, I have another one. This is also from another group. Another anonymous participant asking, has anyone recently got their L1A extension stamped in Canada? Please share your experience. We don't want to travel all the way to India. So this person is from India originally.
Absolutely. Canada and Mexico technically have jurisdiction over people who are physically present in the United States. And so it is theoretically possible. I'm not seeing it happening a lot these days, but it is possible. Obviously, it's a shorter trip. A lot of people still want to go back home because if they stay in Canada, they're going to have to probably get a visa to get into Canada. They're going to have to stay in a hotel for a week or 10 days. And there's usually a longer wait time if you're applying in a third country. So people from Canada will have priority over people who are third country nationals. So even though it's theoretically possible, a lot of people would rather go back to their home country.
Oh, that's very, very interesting, really. Maybe could you tell us more about it?
Well, yeah. So, if someone's on assignment in the United States from India, they're away from their parents, their siblings, and A lot of times there's a need to kind of go back and see family. So if they go back home to India, they're going to be able to see all of their family, kind of check that box off, and they're probably going to be able to stay with their family for free. But if they're applying in a third country, again, they're going to have all the expense of a trip, and they're not going to be able to see family. So a lot of times people prefer going back home instead of and kind of making it into the annual family visit while they're getting visa stamped, as opposed to doing it in a third country.
Right, right. Very interesting. Thank you so much, David, for taking that up. And moving on, I have more questions. So let's take this one out. Another anonymous participant is asking, Hi everyone, I'm heading to India for my L1 blanket visa stamping and currently see Chennai as the only available option for scheduling. Has anyone managed to book appointments at other consulates recently? Also, is it possible to schedule both for OFC and consular appointments on the same day since I see that option in the portal? Thanks in advance for your help.
So I can't say I have all of the information on exactly what the appointment booking is in India.
Yes.
Um,
But I
yeah, so
think we
maybe
didn't speak about the blanket visas, no? L1 blanket. So maybe if you have anything to say or especially highlight the important points about blanket petitions, it would be
absolutely.
great.
Yeah, I mean, blanket petitions are an excellent tool. Employers should definitely obtain a blanket if they qualify because they don't have to submit every single application to the USCIS. Instead, they
Mhm.
can apply directly at the US consulate. However, at the US consulate, there will be a little bit more adjudication, and the standard for adjudication of an L1 blanket at a consulate is a little bit higher than it is at the USCIS. And so you want to make sure you have a very strong case if you're utilizing the blanket.
All right, that's very important. Thank you so much, David, for taking that question up and also telling us about blanket petitions. Now, moving on, I have another question, and this is from another anonymous participant asking, Hello, this one we've taken actually, right? We just took it. I think that's it. Okay, this is one last one. Hi, guys, I need help. My husband's L1 extension petition and my L2 extension I-539 have been filed together on October 2024, while L1A extension is filed in premium processing. Mine is not. So it's still under process. My I-94 is expiring on December 20th this year, but I have a valid stamped visa till 2027. My husband received his approval notice. My questions are, if I travel outside the USA, will my I-539 be abandoned given it's the extension of the same visa category? Let's
So
take
the
this one
answer to
first.
that is yes. The I-539 is abandoned when you depart from the US.
Okay. And the second question is, can I re-enter USA with my husband's L1 approval notice and current visa?
Yes, you should be able to. Um, you have a visa, you have your husband's L1 approval notice, he's still employed, you're still married. There shouldn't be a problem with that.
All right. Now, the third question is, if my I-539 is abandoned, do I need to apply for extension again with USCIS?
No, you do not. You will be admitted on a new I-94, so you do not need to file a new
Extension.
I-539.
All right. I think the last question is, I heard about flag polling where I get my I-94 extension using my husband's L1 approval. That's right. Will it
Correct.
affect my I-539 if I cross border to extend my I-94 based on my husband's approval notice?
So I think that's really a combination of questions one and two and three. And so, yes,
Right.
I-39 will be abandoned, but yes, they should be admitted on a new I-94.
All right. All right. Thank you so much, David. I think with that, we have covered most of the questions from our groups. And well, we have another live audience who has joined us on YouTube. This is from Rajesh. Hi, Rajesh. Thank you for joining us. He's saying, I am a Canadian and would like to know if I can apply for E2 visa based on my rental properties in USA and start a rental and property management business. Does this business apply under E2?
Yes, it could. So while just owning one rental property probably would not qualify, if someone had a number of rental properties and perhaps contracts with other companies to manage their properties, and if that business, again, meets the other requirements, substantial investment, if it had employees, so it met the marginality requirement, absolutely, this could be a valid E2 business.
Okay, there you go, Rajesh. I think that's good news for you. All the best. Now, let's take up Vikas. I'm so sorry, Vikas. I kept you waiting for so long, but here we are now. Let's take up your questions. He has a series of questions actually. So Vikas is saying, if I already have a tourist visa and want to explore potential business opportunities before applying for the E2 or L1 visa, are there restrictions I should know to avoid complications during my transition? Let's take this one first.
Absolutely. So number one, as I mentioned, they should enter on B1. So when they get to the airport, they'll be asked business or pleasure. They should say business. And if the government, if the customs officer asks them what kind of business, they can be honest and say, I'm thinking about applying for an E2 or L1 visa. I'm here to explore the opportunities. Next, if they get here and if they find the right business opportunity, they can do things like meet with a lawyer, meet with a corporate lawyer, meet with an accountant. They can do business meetings in relation to setting up the business, but they cannot work in the business. So once they've set up the company, if they want to do a soft launch before they obtain the visa, which is a good idea, they need to hire a general manager to perform the day-to-day management until they obtain their visa. Getting that first key employee to manage is very important in obtaining the visa. It also keeps them in compliance because it shows that they're not working illegally in the United States.
Right, right. Thank you. Thank you for taking that up. And he has more questions, so let's address them. If I apply for an L1 visa as an executive, how do I prove my role in my current company and show that my position in the US branch is necessary? And can you give examples of supporting documents that work best?
So it's really two questions. So first he's asking, how do we prove the position in the US is necessary? The government is generally not going to ask you to prove that it's necessary. If the company wants to launch an office in the US, obviously it has to have a genuine, profit motive. And if you have a business plan that shows that it will be profitable, that's all you have to prove. You don't have to prove that it's necessary, only that it appears that it'll be profitable and that it will be able to sustain business in the United States. So the next question you ask is examples of documents. Can you read the question again, Nipasa?
Can you give examples of supporting documents that work best?
hmm Well, again, I think that the question might not be accurate, but the main supporting document to show that the business in the U.S. will be again generate profit will be a business plan. So that's the key document. It should be pretty detailed, and in the business plan, there'll be sections that will spell out, who the principals of the business are, who are the founders, what history they have, what plans they have in the United States. That's where you really make the sale to the U.S. government that this business will be successful, will be sustainable, will hire U.S. workers.
All right. Thank you for taking that up for Vikas. And Vikas, I think we've covered all of your questions. But if you still have any more further questions, you can keep commenting. And now let's take up Ganesh's question. So, what are the most effective and cost effective visa options for entrepreneurs and investors seeking to establish a business presence in the US within a short time frame under 6 months? And what are the key requirements? I think we've covered this in this
I think
entire.
that's the whole topic, right? But I think the
Exactly.
answer is this. There in the U.S. there are two investor visas. First, we have EB5, which is an excellent program. It requires a minimum of $800,000 investment, and if somebody's not already in the United States, it's going to take them a number of years to get to the United States on the EB5 program. So the cost-effective option is the E2 because it does not necessarily require 800,000. It could be, 100, 150, 200,000. So that is the answer. It's E2, which is the topic of our discussion today.
Absolutely. And I think with that, it also helps us wrap up a bit and probably summarize rather in a nutshell this whole topic for today. But before we go, David, I would really like to say thank you first. But also, if you could, end this session with an end note and maybe some key pointers to keep in mind so that you can leave folks out there with some bullet minds they can think about as they leave this session.
Absolutely. Yeah, thank you very much for having me. I think that the key point is that, you don't have to beg a friend for a favor or for a job in the United States. Sometimes it's very hard to search for jobs from overseas. So if you have the funds and or if you have a business, then you can kind of um, you can direct your own fate. You can make a plan to be able to move you and your family to the United States within a reasonable amount of time using either an E2 or an L1 visa. And it's not going to cost 800,000 like the EB5 program would. Now, if you have the 800,000, EB5 is definitely a wonderful route. And if you're in the United States already as a foreign student or on an H1B visa, and EB5 is a great route. But if you're not, then you might want to look at an E2 or L1 as a way to move you and your family to the United States within a reasonable amount of time.
Wow. Absolutely. Thank you so much, David. And I wish we had a lot of audience. I mean, live audience, I would say, like, please give a round of applause for our guest today, none other than David, our filmer, who joined us from WR Immigration and also, like, folks, to add to how incredible David is. Well, he's a top rated immigration lawyer and the past immigration section chair of the LA County Bar. So he was selected for inclusion in 2023 edition of the Best Lawyers in America, and in 2021 he was recognized as Best Lawyers Immigration Lawyer of the Year in Los Angeles. So I think that is a very great achievement, and thank you so much, David, for joining us and for sharing your very I mean, your time with us and all this knowledge that you could impart in this session. I'm really looking forward to have you join us again very soon.
Thank you very much.
And here's wishing you a very, very happy Thanksgiving, happy holidays to you and your family out there. Thank you so much for joining us. All right, so friends, thank you so much for joining us in this session. It was really great. Do not forget to check out David Fulmer and contact him if you want to have a one-on-one consultation, and also visit his website and send him an email. Yes, and these are his contact details. You can call him in this number 310-570-4065. You can also email David. I think it would be best to email. So note down this email address, dfulmer@wolfsdorf.com, and go visit www.wolfsdorf.com. Thank you for joining us today. You can also email me, by the way. You can contact me if you have any questions with regard to immigration or jobs in the United States. And my number is 408-335-6444. You can email me, nipa@staffingly.com. And I have another great news, and that is Monday to Friday, 4 p.m. Eastern Time. Me and my co host, Sam, we join you with daily immigration dose here on Immigration and Jobs Talk Show. So I would like to say, please join us there in less than an hour. And until then, of course, don't forget to like, share, and subscribe to our channel. And also hit that bell icon so that whenever we have discussions and webinars like these, you are notified and you can join us. Thank you so much once again. Here's wishing you a good day ahead. Bye bye.
And welcome to Immigration and Jobs Talk Show. I'm your host Sam, and before moving ahead, let me read out this very important disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys including comments and replies from users, is not legal advice, so use of information is at your own risk. All right, once again, guys, welcome to Immigration and Jobs Talk Show. And today, our topic is ready to start your American dream. Which immigration options are right for you? So, folks, millions of people around the world are actually dreaming of making their way to America. And for many, that dream is actually stuck, not because of the confusion or fear of the process, but also not knowing where to start. But you know what? It actually doesn't have to be that way. In fact, you just have to discover the right immigration options that are easier, clearer, and obviously more accessible than you think. So, today we are here to change the way you see your American dream and guide you through the process step by step, making it all less daunting. And to help you navigate through these choices and find the best for your dream, we have a very, very special guest with us today, joining us for the very first time, one of the best immigration attorney in America, Karen Lee Polak. Karen Lee Polak is the managing attorney of Polak P. LLC, an award-winning immigration boutique with offices in Dallas, Texas, and Florida. Polak PLLC provides full service legal immigration counsel to large corporations, small businesses, families, and individuals too. So, welcome, Karen, to Immigration and Jobs Talk Show. It's truly a pleasure having you with us today. And obviously, an honor to have you. So, how are you doing?
Hi, thank you, Sam, for having me on your show. It's an honor and privilege for me to be here today, and I'm excited to talk to you about all things immigration.
Absolutely, me too. Well, folks, I would also like to share that Karen is truly an all rounder. She is a frequent speaker, writer, author, and of course, highly skilled immigration attorney. So, Karen, you grew up in South Africa, right? And you did your schooling from there as well, if I'm not mistaken.
Yes, that is correct. I was born and raised in South Africa. I went to law school there. I then came to America. My father had he had been transferred for a job to Germany and then to America. I came over and I didn't actually intend to live here, but then I met my husband, who is an American, and the rest is history. And we now have two adult children who are American citizens. So our life now is here in America. So I've been through the actual immigration process myself. So I know what a daunting task it is, not only from a legal perspective, but from an emotional perspective as well, to immigrate to another country.
Absolutely. So, Karen, I think you are one of the best person, who can share with our viewers, like, what were the major challenges that you actually went through when you actually migrated to America?
I think the biggest thing is really getting the information up front to know what the process is going to be like to immigrate. What is the legal process? What is the mental process to go through? What paperwork do you need to get ahead of time? In certain countries, it can take a long time to get birth certificates, marriage certificates, name changes, things like that. So I think it's very important to know upfront what is the process like, what is the time frames that you can expect to go through the process, and what are the documents that are required.
Right, right. So, Karen, I think it's a great start. We have got to know about your background and also the challenges that you faced too when migrating to US. So, Karen, let's begin with our very first question of today's episode. That is, what are the main immigration options available for those looking to start their American dream?
Well, there are a number of options available, and different visas have different alphabet numbers. So we like to call it alphabet soup. There's visas that start with A all the way to the end of the alphabet. But the most common visas that we see in our practice is, first of all, family-based immigration, where a parent, spouse, or child over 21 can sponsor a family member for citizenship or permanent residency. And then there is also sibling sponsorship. Depending on the relationship between the sponsor and the beneficiary, that can take, if you're sponsoring a spouse and you're a US citizen, that can take a year. If you're sponsoring a brother or sister, that take right now it's at least over 10 years to get citizenship through a sibling. So that's the first way we see immigration. We get a lot of cases which are marriage-based green cards, where a US citizen or permanent resident is sponsoring their spouse. We see parents sponsoring children, or adult children sponsoring parents. So that's the most common family way of immigrating to the United States. The next way we see job offers, where a US company offers a job to a foreigner. Those classifications are called EB2, employment based 2, or employment based 3 categories. Employment based 3 categories are if you have a bachelor's and less than 5 years of experience, or you're a skilled worker, which has 2 years of experience, or an other unskilled worker for somebody who has less than 2 years of experience. That's the EB3 category. The EB2, or employment based 2 category, is for people who have a bachelor's degree and at least 5 years of experience, and or a master's degree. Then also on the job realm is the intercompany transfer, which is an EB1 visa, employment based 1. That is if the person is in a managerial position, they can be sponsored by a company in the United States that has a branch in a foreign country, or if the foreign company wants to open up a branch in the United States, they can sponsor somebody who is in a managerial position or has specialized knowledge or is an executive to come over to the new branch in the United States.
All
So
right.
that's the job aspect. There is also the diversity visa lottery, where you can win a green card. That is only available to certain countries. India is not on that list. It opens every year in October. It's a lottery system. You can win a green card. Then the other common way that we see immigration is through the investment green card or permanent residency. That is called the EB5. You would invest $800,000 into your own business located in a rural area or high unemployment area. If you're investing in your own business and it's in a regular area, the amount is $1,050,000. There is also an investment in a regional center where the amount is 800,000. You would have to work with the regional center, which is a partnership with the government, where you would essentially be loaning them the money for a period of time. And that way you can purchase a green card. That is a permanent green card. And as I said, you'd be loaning them the money. There is also something called an E2 non-immigrant investment visa that's only available to certain countries. And that is if you invest $100,000 into your own business in the United States. That is a way of getting in. It does not lead to a green card in most circumstances. Visas are generally valid from 2 to 5 years and can be renewed indefinitely as long as the business is operating. So those are the most common ways that we see immigration to the United States. We also deal with aliens of extraordinary ability or national interest waivers, where people have risen to the top of their field and it's in the national interest to bring them to the United States. They don't need a job offer from an employer. So if you can satisfy the criteria, they're very tough criteria, that is a way to go for aliens who are of extraordinary ability. Some of the evidence that we would show is presentation at conferences, media about the beneficiary, publications in leading journals, high impact scores on Google, things like that.
All right. So I think Karen, you have already, given us in a very great way about the overview of the main immigration options, and I'm sure our viewers are literally getting an idea of how and what are the options that are available for them. So I think, Karen, it was really great, and you also touched all the little details about each and every visas. So it was great, and of course, you're a great speaker. So it's very obvious that you literally spoke so good. And now, Karen, I would also like to know some of your political view. So as we know that Trump has won. So firstly, I would like to know that were you expecting Trump to win?
Um, well, I thought he had a good chance. I thought he had a good chance of winning. I did not believe he would win by an overwhelming majority that he did. And so that was a surprise to me that he won by that. In total candor, I will tell you up front, I'm not a Trump supporter. So my answers may be biased in this presentation. But I did think he had a good chance of winning.
All right. So, Karen, how do you see America's future now in terms of immigration? Will it be a new era under Trump's administration, or will the immigrants has to have some kind of nightmare effect? What it will be?
Well, I think pros and cons, we've been through a Trump administration before. So we have had 4 years of Trump. We know what to expect. And he is very knowledgeable. The people who he has placed under him who are going to head immigration are very knowledgeable about the procedures and the processes. That could be a good or bad thing depending on where you are in the spectrum. I do believe that he is going to make it a lot harder for immigrants. I think there's going to be a lot more paperwork involved, a lot more scrutiny. And there's going to be a lot more scrutiny, a lot more paperwork, and a lot more delays. Having said that, he's also has promised on day one to provide green cards to immigrants with master's degrees from U.S. universities. I'm not a betting kind of person, but I'm pretty sure that's not going to happen. But I hope he proves me wrong.
Absolutely, absolutely. And I think an immigration attorney obviously want more and more green cards to be available for immigrants. But let's see what happens under Trump's administration, and we should hope for the best. Okay, so also, Karen, I would like to ask that you have given us the overview of different types of visa types, family-based and marriage-based green cards. So, out of these, is there any specific visa type that Trump that we should look that there will be some kind of major backlogs or that will be restricted under Trump's administration?
Well, in the last administration, in the family-based category, he required what was called public charge documents. It was called an I-944, I believe. My team will know the numbers better than I will, but I think it was an I-944 public charge document. You had to prove that you will not be a public charge or burden on the United States. We still do have an affidavit of support, but it's not as rigorous. I believe that he's going to bring that 944 back or something similar to it, which is going to require a huge amount of financial information from the sponsor to show that they have the ability to sponsor the beneficiary and that the beneficiary is not going to be a burden on the United States. I don't do much immigration with undocumented immigrants, but I think that any relief that is available to them is going to go away in the next administration.
Right. And Karen, also we have seen in the recent news that we have been through that Biden is actually trying to help the immigrants, I mean, the undocumented immigrants by, launching some ICE app or something like that. So I would like to know that, with the Biden administration's recent moves to loosen some immigration restrictions and also Trump's some potential second term promises, how this is going to impact people who are looking to start their immigration journey right now.
Well, I think it depends on, are you already in the United States? And if you are, what is your status in the United States? If you are legally in the United States, I would start your process as soon as possible, or if you're outside the United States, start the process as soon as possible. If you can, in the next 60 days, I would do that. If you are in the United States without lawful status, I definitely would not file anything right now. I would stay under the radar, because anything that the Biden administration has done to grant relief to the 11 and a half undocumented immigrants in the United States, or portions of that demographic, will be taken away. And I think it's better not to put your name and your details on any government website.
All right. I think that's very insightful, and that is something that our viewers should know. So, thank you so much, Karen, for taking that up. And, as you also mentioned, that some of the potential, I mean, impacts that the people are going through. So, what are some key strategies or tips that you would like to give to people who are looking to immigrate to US successfully?
I think the first thing is to really understand the process. What category do you fall into? What options are available to you in terms of visa processes? Is there more than one possibility available? What are the pros and cons of that process? What are the timelines or expected timelines for the process? Do you have deadlines? For example, do you have children who are turning 21 who may age out and not be able to be included with you? I think it's important to talk to an immigration attorney to really understand what your goals are, what the time frames are for your goals, if it is doable, and to understand what documents you would like. Often we get cases that we take over from other attorneys, and there are delays in getting documents that make people lose precious time, children age out, all sorts of scenarios. So I think it's very important to know upfront what you are getting into, and for the beneficiary to really understand the process and be an active participant with the lawyer in making that process go smoothly.
Absolutely, and it's really important to stay, updated with all the news that is happening right now. And also, guys, we are live on YouTube, LinkedIn, Facebook, and Twitter as well. So, in case if you still have any questions or doubts that you want to ask regarding the topic or anything related to immigration, then me and Karen are here for an hour. So please utilize this opportunity as much as possible, and we are definitely going to take them up. So, Karen, also, I would like to ask now some questions related to family based immigration. So,
Sure.
yeah, that, family based immigration has really been a hot topic in recent years, especially with the debates around chain migration. So, what are the most important things that families need to know when they are applying for visas like the K1 fiance visa or family sponsored green cards?
Well, I think we also need to look at the administration that's coming in and what they have said. They are very anti what they call chain migration. I don't like to use that word, but that's a term that they've coined. And chain migration means that you're in the United States, so you can now bring your family. Um, I don't believe that they can just get rid of it on day one, but President Trump can sign an executive order. I believe that there would be litigation. So it would take really an act of Congress to do away completely with family sponsorship. I think it's relatively safe to say, although I don't have a crystal ball. If I did, I'd be in Vegas. I wouldn't be a lawyer. But I think it's safe to say that you still will be able to sponsor your parents and children. I think it is possible that Trump will take away the sibling category of sponsorship. But, the devil's in the details, and I don't think that an executive order alone can change immigration laws without there being a fight all the way to the Supreme Court.
Mhm. And Karen, I would also like to ask you one more question that we know that Trump is trying to implement a new law where if the parents are illegal immigrants, but if the child has been born in the US, then he won't be recognized as a US citizen anymore. Whereas earlier it was completely vice versa. So I just want to know your views. Do you think it's fair enough, or do you think that it should be? I mean, it's correct. Just that. Yeah.
Okay, well, there is a concept which is called anchor babies, where people are coming to the United States, where they have no ties to the United States, using taxpayer money to give birth to children in the United States for the sole purpose of having babies, and that has been abused. And I understand that there is some cause for concern. You can't come to another country, have your baby here, expect the taxpayer to pay for your hospitalization and everything else, and then leave the country just so the child can be a US citizen. Having said that, it is our law that if you are born on US soil, you are a citizen. I think it's going to be very tough to get rid of that.
Absolutely, and that is something that is literally very shocking and very different as well to understand. But let's see what happens. And okay, so Karen, let's move ahead with our next question. That is, what are the current status of the H1B visas, and what changes can applicants expect as competition for H1B visa rises? So, what strategies can applicants use to improve their chances of approval?
Well, there's no way to, I get asked this all the time, there's no way to actually improve your chances in the lottery system. The H1B is a lottery, it's an electronic, as far as we know, it's an electronic lottery system. So being picked in the lottery, there's no way to really improve your chances unless you have a US master's or higher degree. You'll have an extra chance in the lottery. That's a way to improve the lottery, increase your chances by having a master's or higher degree from a US university. But the actual system is computer generated, or that's what we've been led to believe, that it's computer generated and it's random. So there's nothing you can do to improve the actual process of getting selected. Having said that, once you're selected, it is very important that you work with a seasoned immigration lawyer, that you can have all your documents together for a successful H1B application. Make sure that the job description is in fact a professional occupation, that the person has the education and experience, that their degree is related to the occupation. If the degree is from a foreign country, that you have the degree evaluated ahead of time by a authorized credential agency that is recognized by United States Citizenship and Immigration Service. Having a support letter that thoroughly addresses the H1B regulations, that it explains what the company does, why the company needs this employee, how the employee relates to what that company does, and that finally the employee has the education and experience for the position. So the key, we see a lot of mistakes. People are lucky enough to get selected in the lottery, but then their application doesn't pass muster. I think under the Trump administration, there is going to be more scrutiny of H1B applications. So it's very important that you work with a seasoned professional who is going to be able to get together the best application possible.
Absolutely, absolutely. That has to be. So I think folks out there, I hope you're loving our session and you're loving all the insightful words that is delivering by Karen Lee Polak. So thank you so much, Karen, for taking these questions and answering all them very patiently. So Karen, there's another question. What are the biggest challenges that people face right now in terms of green card processing, and how they can stay informed about the delays?
I think you've hit the nail on the head. The big problem right now is the absolute big delays in immigration processing. Processing times for certain countries have almost doubled. In fact, they have doubled. For countries other than India, the average wait time has gone from 2 years to 4 years. with India thinks wait times can be up to 10 years waiting for a green card. And I don't anticipate that that's going to get better soon. I think, if anything, there are going to be further delays. We've also heard rumors that a Trump administration will freeze filings of green cards because of the delays. So certain categories may not be available at all to file in.
Oh my God, this is really shocking. But is it somewhere that Trump has said it, or is it like people are assuming?
That he speaks in code, for lack of a better word. So we don't know. He hasn't outright said,
Right.
I am going to freeze the visa bulletin, but he has alluded to the fact that there is a huge backlog, and he may stop immigration in certain categories until that backlog has been remedied. But we just don't know. We don't know. We have his architect of immigration is a guy named Stephen Miller. He is very knowledgeable of the immigration process and how it works. And he is the mastermind behind immigration. And he is very, very anti-immigration. He is a nationalist, and he believes we've got too much immigration. So he's got a clean slate board to do whatever he wants to do, unfortunately.
Absolutely. And also, Karen, as you mentioning about Stephen Miller, I would also like to know about the picks that Trump is picking for his administration. See, we obviously know that all of them are nationalist, very vocal, and obviously they will be loyal to Trump. But do you think that the way they are, the way they deliver, or the personality they are having, is this going to benefit America?
It depends on which side of the fence you're on. If you're anti-immigration,
Mm-hmm.
um, then yes, that's going to be, and you don't want any immigration to the United States, any anti-immigration administration is going to be advantageous. Just
Absolutely.
depends on which side you see. The Trump administration campaign ran on millions of people coming in daily to the United States illegally, and he's going to stop that. And that's his primary concern. His primary concern is not legal immigration. It's not business immigration. It's not job sponsorship or investment into the United States. So if you are undocumented, I would be very concerned.
Absolutely. And I think they need to be updated, and they need to be thorough with all the information, all the policies that is being updating. So, also, Karen, is there, I mean, we obviously know that there's going to be a very tough time for illegal immigrants. So, what about the legal immigrants? Are they also going to be affected by Trump's administration, or they'll have a normal, how they are having now?
Definitely going to be affected if the laws don't change for legal immigration. I do expect delays. I do expect daily executive orders coming out. Whether they'll be enforceable or not, we'll have to see, which will change the laws and the way and the processes and procedures for filing for non-immigrant and immigrant visas. So, there's a Chinese curse and it says, may you live in interesting times. And we definitely will be living in interesting times. I know in the last administration, I'd have clients calling me and go, what does this executive order mean? How does it impact me? And I'd have to say, hang on one moment. It's 3,000 pages. I'm on page 3 and it came out 5 minutes ago. So we will definitely have our work cut out for us.
That might be so hectic, right? To answer all of them at one. And I think people are so much restless now. They all are like, what is going to happen? Are their identity is going to be safe, or is there something new? So I think, Karen, you have to answer, and you have to go through these situations, I think, very often, right?
Right, right, right. So he will definitely make our work cut out for us. But on the positive side, he has said, as you know, I've already told you, it doesn't make sense to have people educated in the United States and then afterwards they've got to rely on a random lottery or they've got to leave the country. So basically, we are educating these people in America, and then they can't stay. So they take some of the best and brightest are not allowed to stay, and they've got to leave the country, and they start businesses in other places of the world. So we lose those businesses. A lot of US companies saying we can't rely on a workforce that is determined by a lottery. So they're offshoring a lot of work. So it's actually taking jobs away from America. And President Trump has alluded to the fact that he understands that and will rectify it for people who get degrees in the United States. But again, proof is in the pudding. We'll have to see.
Absolutely. And with Trump, it's completely unpredictable. We can't rely on him completely. We just have to, keep our fingers crossed and see what's going to be the next step of Trump. All right. So, till now, I think we have almost touched a good amount of portion of today's topic. And Karen, we also have, some of our viewers who has joined us on today's episode. And hi, Riz. Hi, Ritika. Hi, Sahil. Welcome to Immigration and Jobs Talk Show. So I think, Karen, let's take one question from Riz. So,
Okay.
so Riz is asking that I'm Australian citizen and my partner is American citizen. We plan to marry in America. I'm wondering when she file a petition for me, how soon will this be approved and when do I get working rights? I think it's somehow similar situation to you as well, right?
I'm sorry, can you repeat that?
I'm saying that you were also earlier in South Africa, then you get married, want to get married from American citizen, and then you, right? It's almost the similar process.
Well, I went through a roundabout way in that I did H1Bs as well. So,
Mhm.
but yes, I understand the question. You're an Australian citizen and you immigrating. Sorry, that's my associate, my dog who's in the background. So forgive me on that.
Okay.
So you're marrying a US citizen and you're going to do that in the United States. Generally, the process is taking a year. You would file the application. I'm sorry. I've got to just let this dog out. I apologize.
That's absolutely fine. So, guys, in case if you still have any questions or follow up, then Karen is here, and I think your dog is not in your room, right?
Sorry about that. So I'm working from home today. So that's my associate. My senior associate is my dog. So, but my real team is my dream team, and they're located in Dallas, Texas. So coming back to your question, my apologies, is if you're an Australian citizen and you get married in the United States to a American citizen, the process is taking about a year, is the typical timeline that we have advised clients. Within a month of filing, you will get receipts and a notice to go for fingerprinting. At the 6-month mark, you will be given work authorization, so you can start working 6 months after filing. At the 9-month mark, you would be issued a travel permit, and at the year mark, you would be scheduled for an interview. That is the typical timeline. However, lately, under the Biden administration, we have seen that people are getting their green cards in 6 months. So they are not issued a travel permit and they're not issued work authorization. They're going straight to getting a green card after 6 months. So that has been exciting. I don't expect that to carry on in the next administration, but I may be wrong.
Absolutely. All right. So thank you so much, Riz, for your question. And in case if you still have any follow up or would like to share any topic that we would like to have discussion in next videos as well, please go ahead and we are happy to have them all. Okay, let's take from Sahil another question. So Sahil is actually saying I'm currently on an H1B visa, but I'm considering starting my own business. What are my options for transitioning to an entrepreneur visa, and what are the key requirements?
Well, that depends, Sahil. First of all, you can open up your own company on an H1B visa. You can own shares in a business on an H1B visa. You can earn dividends on an H1B visa, but you cannot work for the company on an H1B visa. You can only, as you may know, work for the sponsor of your H1B. So options for you will also depend on where you are from, where you are a citizen of. A possibility could be an EB1, Alien of Extraordinary Ability visa, where if you can show that you are an alien of extraordinary ability, you can open up your own business, as long as it's in the field that you're an expert at. There is the EB5 investment visa if you have the funds to invest in a business and get a green card. Depending on where you are from, there is also the E2 non-immigrant visa if you invest $100,000. And then there is also a startup visa if you have funding from a US entity.
Right. Okay, so thank you, Sahil, and thank you, Karen, too, for your answer, and Sahil for your question. Also, Karen, I would like to ask a follow up question from this. Like, we have seen more interest in the E2 investor visas. People look to build businesses in the US. So, can you explain the types of businesses that typically succeed in securing it? And of course, with the current state of the economy, how might changes in investment opportunities affect the E2 visa process?
I think as long as we have the NAFTA and North American Free Trade Agreement in place and agreements with the various countries, I don't think that will change, because the E2 is creating jobs for US citizens or people lawfully in the United States. We have seen E2 success across the gamut with all sorts of businesses, from cleaning businesses to franchises to restaurants, real estate, B&B, bed and breakfast. All sorts of businesses qualify for E2 visas. We've seen people who are personal trainers, that kind of thing, all have been able to get visas.
Right, right. So I think that's really great, and that's really insightful. Okay, so let's take our another viewer's question from K. Vishwanathan. So he's asking Karen that I'm currently at L1 petition stage. Is that difficult now with Trump? And what's the next option or steps cliff my GC with family?
I'm sorry, can you repeat the last part? He's on an L1?
Yeah, I'm repeating it again. Its question is I am currently at L1 petition stage. Is that difficult now with Trump? And what's the next option or steps cliff my GC with family?
Okay, well, first of all, you have to get the L1 petition approved first. I assume that he meets all the criteria for that. Once he's in the United States, then if he likes it, depending on the strength of the company, how many employees they have, what their revenues are, they could immediately sponsor him for a green card. If he's in a multinational managerial position, we often get L1 approval and then go immediately and turn around and file the green card. It will depend, though, on how many employees are in the business already, if it's an existing US entity already, or if if the business is only starting up. Then the L1 if the business is only just starting up in the United States, the L1 will be issued for 1 year. We like to get the L1 renewed after that 1 year, so that the person has 3 years in L1 status, and then we turn around and apply for the green card immediately. Because if they satisfy L1 renewal criteria, then it's likely that they'll satisfy the EB1 criteria. We don't typically do an EB1 for a company that hasn't already set up and established offices in the United States with at least some employees, at least 10 employees.
All right. So thank you, Vishwanathan, for your question. And Karen, we have another question from Cable Cross. So he's asking, good day. I am a Jamaican citizen, F11 visa category, and documentarily qualified since February 2023. So how long does it take to get an interview?
So I'm not sure what he means by F11. I think he means F2 category, or I'm
I also,
not
yeah,
sure.
maybe.
But generally, once you documentarily qualified, it depends on the consulate, but you're waiting at least 6 months to a year for an interview.
All right. So I think Abel has got his answer. And Karen, we also have questions from Facebook group as well. So we would love to take them as well.
Sure.
Yeah. So I hope my screen is visible. Yeah, it does. Okay.
Okay.
Yeah. So Karen, here's the question that is asked from Ritesh. Hi everyone, I'm preparing my docs for EB1B myself. I need some information regarding filing information in ETA 9089. What parts or sections in ETA form we need to fill specifically for EB1B? Yeah.
Well, for an EB1, you don't need to file Form ETA 9089. For the viewers, an ETA 9089 is a labor certification form. So that's a permanent labor certification. It typically is required to be completed by the employer and the employee in the EB2 or EB3 category. In the EB1 category, there is no ETA 9089 or labor certification. What he may be filing is an EB2 national interest waiver. And in an EB2 national interest waiver, he does need to fill in parts of the ETA 9089 form. That will be his biographical details, name, address, his education, his work experience. All needs to be completed to show why he's an expert.
All right. So I think now we should move ahead with our next question. That is from Kiran K. Rao. Okay, I think we should take some other questions as well. So let's take from Zachary Winston. So here's a question that he's asking: help to immigrate to US by EB4.
Okay, well, I think what he's meaning is a religious worker visa. And a religious worker visa, there is two visas. One is called an R1, which is a religious worker non-immigrant visa that is valid for 2 years and can be renewed again for 2 years. Then there is also a religious worker green card. There's severe backlogs in that category. You would have to be employed in a religious position, so such as a pastor, priest, imam, or in a religious related position. So we've even done religious workers for graphic designers, but they have to be well versed in the New Testament, have to be very familiar with Catholicism because they will be doing graphic design. So you don't always have to be an ordained minister. You can be in a secular job, but that it has religious undertones and requirements.
All right, all right. So I think thank you so much, Karen, for taking these questions up. And I hope our viewers are also getting such information from you, so they are loving it. Okay, so here's another question that I am a 23-year-old software engineer with a bachelor's and master's degree in software engineering, with 5 years of experience, four in remote work and one in office. I specialize in software design, development, and optimization. I'm committed to contributing to US technological advancement and economic growth, and I'm also exploring the EB2 NIW pathway. So, could you please provide the insight into my chances for approval along with any suggestions to strengthen my application?
Okay, that's very, very broad. I would need a lot more information, but things we want to see with a software engineer are, do you have any patents? what programs have you developed that are very unique, that will benefit the national interests of the United States? Um, have you spoken at preeminent conferences? Have you published articles? Do you have 7 to 10 reference letters from experts in the field who can explain why they are experts and why you are an expert in your area, why you have risen to the national interest and are an alien of extraordinary ability? We want to see citation publications to your work, that you've reviewed peer journals, that there are citations to your work. So it's not just that you're a software engineer. There's hundreds of software engineers in the United States. What makes you better than a US citizen who's a software engineer with a master's degree? And what will you do in the national interest of the United States that is required?
Absolutely, absolutely. That's great. And I think, Karen, you literally mentioned it in a very good way that one has to be best in that particular field. And after all, when Trump is under the administration, it's too becoming very difficult, for most of the applicants to apply. So I think the one who will be the best among the rest, I think the competition is too high. So they need to be very much, confident and need to be filled with lots and lots of information. So I think with this, we have another question from Chloe. And she is saying that I have seen too many posts where people request to share the format of the petition, and I have not seen anyone sharing the sample of petition. Is there any format, or just we can use the guidelines of USCIS and write a petition accordingly?
Well, I don't know what petition they're talking about. There's hundreds of
Yeah.
petitions. So different petitions have different formats, but if you're doing it yourself, regardless of which class the petition falls into, I suppose, follow the USCIS format that they put on their website and follow what they require. But I really can't opine to that without knowing what petition. I kind of get upset though with questions like this. It's not a matter of filling in forms, it's a matter of a package. The form, although has to be completed thoroughly and correctly, your supporting evidence is just as important as the form. Using legal counsel to help you draft the form is important, but the legal counsel can assist you with strategy in showing what are good documents that will help your case and those that may even harm your case.
Right, right. So I think, Chloe, it would be great, if you could let us know that which type of petition you're actually talking about, so that Karen can literally guide you. Okay, so here we have another question that, hi, I'm currently working on L2S. Shall I apply for EAD, or do you think the new government will continue to allow people to work on L2S, which does not require EAD?
I see no harm in getting an EAD if they apply. But whether they get an EAD, are they talking about getting an EAD through some other type of visa status, or are they just saying that they on L2S and can get an EAD? I don't think a new administration is going to impact whether, if they get rid of L2 being able to work, it's not going to matter whether you have the L2S, which is evidenced on your I-94 card, or if you have an EAD. If they get rid of that class of document, then they get rid of the class of document, and it won't matter whether you have an L2S or EAD. If you're saying that you qualify for an EAD in some other category, for example, you've in the process of adjusting status, then I would say go ahead and get an EAD, because a Trump administration may get rid of work authorization for spouses of H1B holders or L1 holders.
Right, right. Okay, so I think we are really getting so much information from you, Karen. I think we should pick few more questions from Facebook too as well. So yeah, here's the question. that I'm doing a follow to join for my spouse. I finally got the NVC welcome letter for him. I was asked to fill a DS-261. So, how long did that take to invoice? Also, did you upload documents or were asked to post to NVC? I'm wondering if this is peculiar to EB2.
No, it's not peculiar to EB2. First of all, the form is called a DS-260.
Mhm.
You should get, my team is experts at this, but you should get fee invoices within 2 months of requesting them. You then would pay those pay the fee invoices, and then you would submit your DS-260. Different posts have different requirements. Some posts require you to upload documents. Other posts require you to mail documents to the National Visa Center. So it depends where the consular interview will be.
All right. Okay. Uh, I think we have few more, but let me just check and go through once. All right. So I think Karen, we have almost gone through so many questions, and then we have different questions from viewers too. So I think
Okay.
let's take those questions because I don't want to upset my viewers as well. So here we
Okay.
have received from LinkedIn. Oh God. Okay, it's fine. I hope Karen, you don't mind if we are going to hide you from this.
No
For
problem.
all right. So he's asking, hi, for EB3, what are the requirements? I have exact 2+ years experience and my old company is no more and very small company. Nobody is responding. If I get signed from my colleague, will it cause an issue and whether DOL will do verifications?
And it is possible the Department of Labor will do verifications or ask for additional information, but highly unlikely. In situations like this, it's not ideal. Uh, for the EB3 category, you do have to show at a minimum that you have 2 years of experience as a skilled worker. So it's not enough that you have 2 years experience, but it's the job that requires 2 years of experience. You can get affidavits from colleagues or supervisors who were at the firm if the company is no longer in existence, and provide proof of payroll records that you worked there for 2 years. It's not ideal. We always prefer to have a letter on letterhead from the company, but sometimes it does happen that companies close down. You're unable to get an employment experience verification letter, and we do get affidavits from supervisors, colleagues, and show payroll records or bank statements which show the deposit of your salary in bank accounts for at least 2 years.
All right, all right. So this is the question that we received from Tarun. Somehow I can't see his name, but that's okay. Thank you so much, Tarun, for participating. And if in case you still have any follow-up question or any other question that you would like to ask from Karen, then please go ahead. We would love to take those questions from you. And also, Karen, we have few more questions from. Let's take from Ritika. I have a degree and 8 years work experience in my home country. What are my options for obtaining a work visa or green card in the US? And what documentation do I need to provide?
Okay, well, first of all, it's very vague. We would need to see if you qualify as an alien of extraordinary ability for an EB1 visa or an EB2 national interest visa. In that, if you do qualify for either of those visas, you would not need a job offer. If you don't qualify for those visas, then you would need a job offer from a US employer who's willing to sponsor you and pay you a prevailing wage, which is the required wage for the job position. You could then apply for a temporary visa called an H1B, which is for professionals who have a degree if the job is in a professional position, in a specialized occupation. The employer could also sponsor you for an EB2 green card or EB3 green card. From what you're saying, you have a degree and 8 years of work experience. So if the employer is willing to pay you the prevailing wage for the job, I would go in the EB2 category.
All right. So, Karen, we also have a reply from Tarun, and he's saying that this is like 10 years ago, madam. All right. Okay. Thank you so much, Tarun, for sharing this information. And okay, we have also response from Vishwanathan, and he's saying thanks for adding that question, and sorry for the typo. That's completely okay, Vishwanath. That's okay. And thank you so much, for participating, guys. We are really loving this conversation. And control, I would request to just display the previous question that we have also received from. I think I can't pronounce the name, but okay, let's read it out. That is, trust this mail finds you well. Notice that you an expert in H1B visa issues. Please, what is the implications of not entering US after 1 year of H1B visa stamp? The reason is that the US facility has a delay in resumption time, which has prolonged beyond expected time. Would to this delay after the employee?
Well, if you don't have the job available, then you can't come into the United States. You don't want to be here not earning a salary. So I don't think a delay of a year, though, will impact the H1B as long as you enter within the 3 years of the H1B stamp. I think you will be fine. You don't need to enter immediately. It often happens that particularly with staffing companies, the projects go away. So you may come in 6 months or a year or even a year and a half later. But as long as you come in during that duration that's stamped on your H1B visa, I don't see there being a problem.
All right. So I think that is very much clear from our side. And next up, also, Karen, we have a follow up question from Vishwanathan. And he is asking that I am part of MNC company with its location in 7 states in US land. Should I take the EB route with the employer sponsor and that too not takes 10 plus years?
Well, it depends where he is a citizen of, but if he's a citizen of India, it is going to take 10 years, but he could also apply for an H1B visa now, and he could come in sooner if he's selected in the lottery.
All right. So I think Vishwanathan, it would be great if you could let us know where you are watching this session and actually where you are trying to apply the application from, so that we could be little specific and could answer it well. Okay. So also I think we have few more questions. So I think let's take them up. And yeah, let's take it from Ritika, the another question. So, Karen, Ritika is asking that what are the key difference between temporary and permanent immigration options, and how do I determine which one is right for me?
Well, first of all, it depends on what your long-term goals are. Do you want to permanently live in the United States, or do you want to just come here for a couple of years and then go back to your home country? A temporary visa or non-immigrant visa is a temporary visa that allows you to stay in the United States only for a certain period of time. If you want to continue staying here after that time, you will have to renew the visa. And certain visas, like an H1B, have they have an expiration time. So you can only live in the United States on an H1B visa for a maximum of 6 years, unless you have also been sponsored for a green card and have an approved I-140, which would allow you to extend the H1B past 6 years. So if you only planned on being here for 3 years, then an H1B may be an ideal visa for you. If you are planning on living here, after a period of time, you want your employer not only to have sponsored you for an H1B, but you want them to sponsor you for permanent residency, which is an immigrant visa, which allows you to live and work in the United States indefinitely.
All right. So thank you, Karen, for taking these questions. And I'm really sure that our viewers are definitely, getting so much information from these questions. And also, we have received a follow-up from Vishwanathan. He said that he's from India. So, yeah, Karen, I think it will take 10 plus years longer, or yeah,
Yes,
can you please go ahead?
unfortunately, I'm so sorry, and it's probably wait times are going to get longer. So, if he doesn't have a non-immigrant visa, I would recommend that he apply for an H1B visa.
All right. So I hope that Vishwanathan, you understood this session, and it would have been really grateful for you too to go ahead and attend this session completely. I'm sure you will definitely understand and go through so many things on this topic. So, Karen, we have almost touched an hour and we didn't realize. That's a great thing. So, Karen, from my side, I really enjoyed this discussion and, is really looking forward to continue these discussions and have more and more sessions together in the future. So, from my
Like,
side, it was great. Yeah. How was you? I mean, how was your experience?
thank you very much for having me on. I really enjoyed it, and I'm happy to do another session with you. Next time, my little associate dog will not be interrupting us, so I do apologize for that.
No, that's all right. After all, he's your associate, so he needs to keep an eye on what Karen is doing. But that's
Right.
completely all right. That happens. And any last message, Karen, that you would like to share with our viewers about the topic, how they can, have their American dream come true.
Do as much research as you can on the type of visas, on attorneys that you're going to use. Make sure that you thoroughly understand the process before embarking on it. It's a relationship with your lawyer, and especially in the case of India, you are going to be working with that lawyer for over a decade. So it's important that you understand each other, understand your goals, that you understand timelines, and just do a lot of due diligence. Immigration website, the USCIS website, which is uscis.gov, has a lot of interesting, very informative information on the various types of visas. We also have videos and blogs and information on our website on all the visas that we've discussed today.
Wow, that's great. And that's absolutely fantastic. So, Karen, thank you. Thank you so much, for making this session an amazing one. I really loved it. Our viewers too. And thank you also, guys, for participating in today's session. Sahil, Ritika, then Riz, Cable, and Tarun, and also Vishwanathan. Thank you so much, guys. It was lovely, lovely answering to your questions. And also to our viewers, guys, if you still have more questions or want to connect with attorney Karen Lee Polak, then please feel free to reach out on the given contact details. That is, the number is 214-504-1227. The email ID is karenlp@polakimmigration.com, and the website is www.polakimmigration.com. All right. So thank you so much, Karen. It was really lovely, lovely having you, and honored to have you with us on Immigration and Jobs Talk Show. Thank you so much.
Thank you, Sam.
Yeah, wish you and your family happy Thanksgiving. So,
Happy Thanksgiving, and thank you for the privilege of having me on your show today.
oh, pleasure, pleasure. Thank you so much, Karen. And guys, don't forget to like, share, and subscribe to Immigration and Jobs Talk Show. We will bring you more insightful sessions, and we are definitely going to cover a lot and lot of different topics related to immigration. So don't forget to like, share, and subscribe to Immigration and Jobs Talk Show. And thank you so much, everyone, for joining us. See you next video. Thank you so much. I'm Sam signing off for now.
Good afternoon, everyone. Thank you so much for joining us. Welcome to Immigration and Jobs Talk Show. This is Nipasa Pradhan, and I'm going to be your host for today. And it's lovely being here. So, sorry, it's not just good afternoon. It may be good morning or good evening. So, thank you so much wherever you've joined us from whichever time zone. So, welcome to Immigration and Jobs Talk Show, and I'm really happy to be here. We are streaming live right now on YouTube, LinkedIn, Facebook, and X. And I'm really glad that you have joined us. And before we proceed with today's webinar, I have this very important disclaimer, and that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, yes, and you can also participate, by the way, in this session, friends, by commenting whatever questions you have, especially with regard to today's topic of discussion. And that is Trump's new team, a fresh start or a nightmare for immigrants. I'm sure all of you folks have many questions and are probably in a dilemma whether it's going to be good or it's just going to get worse for you. So, today, here in this webinar, we are going to discuss this further, and joining me is someone who needs no introduction, who has been a part of Immigration and Jobs Talk Show, makes it a point to be here. So I'm very happy to welcome once again none other than employment based immigration law attorney, but also a true advocate for the immigrant community, from defending H1B RFEs and NOIDs to guiding students on F1 OPT visas and offering expertise on TN and E3 visas. Justin has been a beacon of hope. So please help me welcome him back to the show. Hello to Justin Rivera from Wasden Immigration Litigation. Thank you so much for joining us.
Thank you for having me. That was a very nice introduction. I appreciate it.
It's been a while, I mean, I take it for granted sometimes, and maybe I don't say good things about you or let folks out there know. So maybe we have new friends. This is none other than Attorney Justin Rivera, today's special guest, and he's going to help us today on this topic. We're going to talk a lot on Trump's new team. So before we head start, Justin, what do you have to say to everyone out there?
Well, anybody that's here that's celebrating, an early happy Thanksgiving to you, because that'll be coming up this week. If you're here in the U.S. celebrating that, happy Thanksgiving. I hope you have a short work week. But yeah, in regards to today, we'll just try to delve into, I think, a lot of what many people are doing right now, which is trying to kind of wrap our heads around what a new administration is going to look like and the impact that it's going to have on immigration in the country. And you can do that kind of by looking at who's being put in influential positions within the administration, and what have those people said about immigration, and what that possibly means they'll be actually doing moving forward.
Absolutely, friends. Thank you so much, Justin. And yes, don't forget to participate. And before that, if you have friends who would be interested in getting to know this more about today's topic, Trump's new team and its effect on immigration, please feel free to share this link with everyone or your friends out there and ask them to join in this discussion. So, yes, thank you so much once again. And let's go ahead, Justin. I have this first question. This is regarding Pam Bondi, and she has a history of aligning with Trump's agenda, including her role in his impeachment defense and her work with America's first policy institute. So, how do you foresee her policies impacting immigration cases, especially regarding federal prosecution priorities?
So I think, obviously, it's a fortune teller argument here of what are you predicting or what can be done. But I definitely think that there is an avenue to go after criminally, go after people that are found to have committed visa fraud. Usually that's something that's applied to companies, organizations, usually the higher up individuals within the organization. And so, could they use that avenue moving forward more liberally than they have in the past? I definitely think it's an option. In regards to Pam Bondi, just kind of reading up on her and looking at kind of her record, I think she's probably going to be basically doing what Trump is asking her to look into. And from her perspective, I think the immediate things are probably not going to be immigration and that enforcement of, maybe fraud allegations against individuals. Now, that's not to say that that couldn't happen, because honestly, it would be a pretty interesting tool for them to try to utilize if their goal was to actually start trying to crack down on the companies rather than the individuals, as a method of kind of limiting how some of the organizations that have been able to get away with using H1Bs would be able to use them moving forward. So I definitely think it's something to look into and think about. I do know that, from my understanding of Pam Bondi, her relationship with Trump had something to do with I guess the fact that he gave a donation to her of like $25,000 or something like that to her reelection campaign, and not as a direct result, allegedly, but maybe the fraud investigation into Trump University in Florida was no longer something that was being discussed or put on the docket. So that's on the Washington Post. You can see the inference formed there. But what that really kind of tells me is it's like you're going to see with a lot of these appointments, it looks like it's more of a loyalty issue rather than a skills issue. It's, is this person willing to carry out what it is that he wants to put forth with his administration? And so, yeah, I would say, would it shock me if there were more cases brought against people for visa fraud, especially the employers, the people who are actually signing the H-1B forms? No, it wouldn't shock me at all. And honestly, if I were them, it would probably be something I would utilize.
All right. Thank you so much, Justin, for giving us a sneak peek into your thoughts about Pam Bondi, and thank you so much. You can also go check out the post on Washington Post, and the news is out there already. So thank you. On that note, Justin, we also have Amay on YouTube asking a question. Amay, please stay with us. We will take up your question in a bit. Hang on. For now, I have another question, and this is about Matt Gaetz. Although he withdrew his nomination, the controversy surrounding his potential appointment raised concerns. So, does the consideration of such a figure indicate a shift in how the administration might handle immigration related ethical and legal matters?
So, yeah, I don't know really if we're going to be able to frame it specifically through the prism of immigration, but I think what we saw with Gaetz's attempted appointment was the fact that there are still guardrails in place, regardless of how tenuous those guardrails are. There's still going to be some level of qualification required for these people being put into these positions. And the fact of the matter was that Matt Gaetz, he wasn't really qualified for the position that he was going to be put into. That being said, as well, would he have gotten the position were it not for his ethical issues? It's very possible. But what it really kind of does show me is that there is still going to be pushback on appointments, which is a positive thing, that people still should be held to a high standard. But in terms of immigration and kind of how I think it's kind of interesting, you could maybe draw this small parallel from it, but the fact that Trump was even willing to try and appoint Gaetz in the first place, it's not that surprising, and it's a bit indicative of his strategies. A lot of times they just kind of throw stuff at the wall and see what sticks. So if I'm looking at it from that way, I wouldn't be that surprised if you see a lot of quick changes to immigration that come in, and a good amount of them end up being invalidated by the courts. Just because they don't hold legal muster. So that wouldn't shock me. I definitely think that they are more willing to act and then just kind of see whether or not the court will let them act, rather than make a prepared, concise, well-researched change that's going to stick. So that would be my thought process, would be, don't be surprised if you're seeing, within that first month of the administration handover, changes, fairly drastic changes in proposals that may or may not actually hold up in a court, but are still going to cause hiccups in the immigration system.
All right. It's scary how the situation is for many immigrants out there, I think. And with all these new picks, I think it's the situation is getting even more tensed. What do you say, Justin?
Uh-oh.
Can you hear me?
Yeah, sorry. The quick little hiccup right there.
No worries. So,
I'm here.
yeah, I was just saying, like, with these new picks, it's just getting scary. So, what do you think?
Actually someone just commenting about, I think it's Dr. Oz was allegedly being given an appointment. No, I know, Sakshi, I know. Yeah, it's not ideal for me. I think for a lot of people who are looking at the individuals that are being named to these positions, there is a little bit of a wow factor to it, because I think in the first administration, I think Trump was a little more reeled in just by the nature of the fact that, like, it was fairly surprising for most people that he won. And I think there was a little bit of period where the Republican Party was kind of like, we're going to put we're going to put guardrails up. We're going to have people appointed, Rex Tillerson. There's going to be people put in positions that are experienced and qualified and know what they're doing. What we did learn, though, from that administration was there was a pretty high level of turnover, and that turnover basically correlates to, if you're not doing what he wants, you're going to lose your job. We saw it with Jeff Sessions, and then he even ended up having problems with Barr, which was, another person he had appointed himself for the AG spot. So the other thing to think about, too, with this is kind of a shelf life. How long are these people actually going to hang in these positions? And actually stay and deal with kind of the turmoil that this administration is inevitably going to bring. So that'll be something I think we're going to have to consider as well.
Right. Right, Justin. Thank you so much that also was a very good insight, I would say. And we have Malutek USA and even Sakshi joining us with their questions. And I think that we can take Malutek's question for now, if you don't mind.
Yeah,
So
sure.
it's asking, Canada, Australia, and UK reducing temporary issues and student visas. Why Republicans act more left than Canadian Trudeau? 10,000 of American tech workers are unemployed, desperately need job. Okay. What do you have to say?
Okay. I think so. I've been kind of monitoring the Canada situation pretty closely because I found it very interesting. So during the initial Trump administration, Trudeau, who is still in a position of authority, Trudeau was very open to immigration. He was basically saying, oh, if you're not wanted in the United States, come to Canada. We want you here. We're more than willing to take people on. They looked into expanding their immigration regulations to bring in a higher influx of people. That may have come back to bite them. About probably around last year, the middle of last year was where I started seeing it. That's not to say it's not something that's been existing before, but I did start seeing a lot of attention on it in the middle of last year, and it's at the forefront this year. Trudeau's already made statements that he's reversing course. They are taking steps to curtail and limit immigration moving forward. He has made the spigot argument, which he's claiming that the spigot, the water spigot, has been turned too far one way and needs to be turned back the other way. That's his stance.
I've been playing through my 34 years.
What's up?
Sorry.
Oh, it's okay. But anyway, that's he's a politician. He's dealing with the vibe of what's going on in his country presently. But as a result, yes, I think you're seeing Canada move towards more restrictive immigration policies. Australia, I think I've also seen, is possibly trying to reduce immigration. I'm not as well up on the UK. Why Republicans would act more left than Canadian Trudeau. If you're saying why would the Republican Party embrace immigration, legal immigration in the United States? Because legal immigration in the United States is beneficial to the United States economy. It's been well established. So there wouldn't be really any valid justification. I think that the whole point of these programs like the H1B program are to create the necessary guardrails that prevent U.S. workers from being kind of left out in the cold by, allowing there to be people who are going to be able to do the same job for less money. That's why you have the labor condition application that establishes the wage levels. These things are stringently enforced both when someone applies for the H1B and through FDNS's site visit systems when they actually go out and make sure that the person's complying with the conditions of the H1B. So that all being said, it would not shock me if the Republican Party acts differently than the Biden administration. I know people are very quick to jump the gun and say, well, what has Biden actually done for legal immigration? Like, how is it that different than it was under Trump? I will tell you firsthand, as someone who practiced under the Trump administration, it was significantly different. You were dealing with an entity in USCIS that was borderline adversarial. You know, it wasn't more so our job is to process these applications. It was, we're looking through these applications almost with an assumption that there's something deniable in what's being presented to us. And I think that's what you're going to see as the biggest difference. And it will show you that the Republicans are not more left than any of those other countries. They are going to seek to draw out the time it takes for an application to be processed. They're going to do that using requests for evidence that I'm sure will become more detailed and require more information than is currently necessary. They're going to do that by attempting to limit validity periods any way they can, meaning, you know, they're going to probably go back to trying to find ways to cut down people's requests for 3 years. Whether or not that will hold up in court, we will have to wait and see. But I'm sure that they'll be taking from the pages that they've used previously in order to grind the system as slowly as they possibly can. On top of that, yes, it's completely possible that they're going to be introducing new ideas and new ways to try and make the system even more difficult than it is presently, with the underlying goal being that they want employers to just not have to deal with the program, you know, and if they do things like increasing the wages, making it to where you have to pay even more to have someone employed on an H-1B. That's one avenue that they may look at. They may look at curtailing the definition of specialty occupation, making it more stringent to where it's more difficult to qualify for the position. They might make it harder for the employees to qualify with their degrees, unless their degrees are absolutely one-to-one correlated to the job duties being performed. So these are all things that they're going to do. And if they didn't do them, it would surprise me. But these are all things that I definitely think they want to do. And with Stephen Miller, who I'm not sure if we're planning to talk about today or not, but with Stephen Miller in probably a more influential position in this administration than he had been previously, all of these things are going to be on the table. And it's not really, to me, a matter of if, but when, and whether or not they've now also decided to find new things that they're going to be putting forth. I believe I saw last week, towards the end of the week, something about the dismissal of a case that had been backed by a Miller group where they were going after, once again, the H4EAD. So it was another attempt for them to go after some part of immigration to curtail it, to make it more difficult for people that are here on that H-1B visa if their spouse can't work. That didn't hold up in court. But you got to remember, they were challenging something. They're moving into a situation where they're going to be taking part in the rulemaking process. And that's going to change how they're approaching it and what they're trying to do. So all of that is to say, for Malutech, I don't think that the Republicans are going to be acting more left than the Canadians. I don't think that that's going to be the case at all. I think you're definitely going to see them crack down on legal immigration. It's not going to be the forefront of, what gets people's attention, especially initially. Where everyone's eyes are going to be drawn is where the election seemingly was decided on in a large part, and that's the border. And, the actions that are taking place at the border to curtail entry. And I think that's going to be what gets the headlines. But at the same time, it wouldn't shock me if they're able to walk and chew gum at the same time and also move forward with making those changes to legal immigration.
Right, right. Thank you so much for taking that up for Malu Tech USA, and thank you, Malu, for participating with your question.
Yeah,
But
no, I
Justin,
think it's a
yeah,
good question. I think it's also indicative of, in a lot of places, you're seeing a protectionist shift. I think you're seeing people in countries that are moving more so towards not maybe being outright anti-immigration, but being more selective in their immigration process. I think to say that is something that's moving forward in Western countries, I think to say that it would be realistic.
Right, right. But yeah, coming back to Stephen Miller, I mean, talk about his first term family separation, including travel ban and all that. So, what do you foresee? I mean, this could also, influence this term as well. So,
Mhm.
how's it going to be, you think, for immigrants?
So I think, I apologize. I think we have a question on him. I don't remember the name of the border czar that has been appointed, but I remember I've heard about him. Tom Homan. Thank you.
Tom, yes.
So Homan has really talked about his ability to enforce actions at the border, right? And it's when you really think about it from an immigration perspective, when you're reviewed for admission to the United States, that's a pretty big part of a process, because at that time you're being, assessed by an officer who makes a determination as to whether or not you are admissible to the United States, right? So for most people that are legal immigrants, this is a very quick part of a process. You know, if you've been in before, you come in, you know what you're doing, you go through CBP, it's no problem, right? It wouldn't surprise me if the enforcement activities being promulgated at the border begin to bleed out into other facets of entry. And so what I mean by that is this: I've already actually seen it. I was reading about it before our discussion today. Homan has already come out and made a point about illegal immigration at the Canadian border. Basically saying, yeah, there's problems at the southern border, but what about the northern border? We have issues there too. We need to be, we need to be more stringent in how we're reviewing people there as well. And so I think for a lot of people that are, that travel between Canada and the US, maybe people that are on intermittent L visas, TN visas, things of that nature, I think you're going to see a heightened level of scrutiny. I think it's going to be created initially under the guise of trying to curtail illegal immigration, but it's going to bleed into the other facets of immigration as well. And I think that that's going to be, it's going to create a difficulty where one previously hadn't existed. So I would say it's pretty imperative for people moving forward when you're getting ready to really consider traveling and how you're going to re-enter, where you're going to re-enter, what documents you're presenting when you re-enter, and being prepared for detailed questions being asked in relation to not only that, but any of your previous immigration history in the United States as well. Because, we've already seen things that are popping up under the Biden administration that have been popping up for a while now, but issues with, people who have been on their H's for years that are now being questioned about F1 employment with, companies that have been blacklisted, basically, that USCIS has now come out and basically said, if you worked with this company, if you worked with this company, then you're basically de facto fraud. Like, you've committed fraud based on the connection to the company. So I think that is something that's going to need to be very well thought out by people when they're immigrating or coming into the US, looking at what is it that you could be asked about in your immigration history or about your current job or any of those things that could lead to additional questioning or additional scrutiny. Because all of that, I think, is going to be on the table. Because if you're not readily prepared, you put yourself in a bad situation. You put yourself in a situation where you're going to be questioned by an officer. You may not remember some of the facts. You may misspeak one time. That's really all it takes. Is one misstatement or one slip up, and it's enough to put you in a circumstance where you could be an expedited removal and end up having your visa canceled. So I don't say all of this through the desire to fearmonger. It's not my intent to make people scared to travel. I've also seen, people online already are starting to get upset. They're saying, "Oh, my attorney's telling me if I have any travel, it needs to be done before January." Mid-January, because they don't want people stuck by any changes that are made. This is ludicrous. I've never done anything wrong. You have to understand that as an immigration attorney, our job is to advise. And usually when we're advising, we're trying to take the most conservative approach or strategy possible, because what we want to do is minimize risk. That's our goal. We minimize the risk that an individual has, either when they apply for something, or they go to a visa interview, or they re-enter the U.S. That's the goal. Not to make you scared, just to make you informed. And I'll put it this way: if we didn't say these things, and then in the middle of January you travel and something happens and you're stuck out of the U.S., who are you going to blame? You're going to blame us for claiming that we didn't tell you not to travel. And so that's why that's happening right now. It's really not because we want to make people fearful. It's more of we don't know exactly what's going to happen. And the best idea when that's the circumstance is to just minimize the risk as much as possible. But yeah, to just kind of button that question about Homan's leadership, the border policies, I think you're just going to see a lot more difficult issues with entry that you probably weren't dealing with in the past couple of years. I just think it's going to be a lot more scrutiny. They may bring back some of the issues that had existed beforehand, which were things like, did you do a second master's degree and do day one CPT? Did you go to some of these universities that are looked at as maybe less than compliant with F1 requirements, just things like that. And then there, obviously employer issues and stuff like that. So I just think all of that's going to be on the table.
Yes, absolutely. And talk about the borders are. We can expect a lot of difficulties for sure, as we've already spoken about. Maybe RFEs getting more and more. Maybe they would want more evidence than already required. So, stuff like that is what we have been discussing. And I think there's more to discuss on this. There's so many new picks. And well, I would just like to say thank you to Pavan also for joining us with your questions. Just stay with us. We will take up your questions. All right. And yeah, Justin, getting back to our questions, earlier I had asked about Stephen Miller also, because we have seen a lot of family separations and also, travel ban as well. So I think this is going to be a little more tough on immigration, immigrants now, right?
Yeah, and I mean, obviously, I think if you're sitting on this call and you're somebody that's on, a non-immigrant visa, you're sitting there thinking, well, what is the applicability of that to me? I'm not entering the country illegally. I'm not doing anything wrong. I'm not doing anything illegal. Okay, so that's fair. It's a fair assertion. But aside from the fact that there's a whole human rights issue regarding the family separation issues. I think it was Tom Herman is his name. I think Tom Herman, when he was asked about family separation, he said something along the lines of like, well, no, we're not going to separate them. We'll make sure they're deported together. That was the solve to the Homan. Thanks. I'm going to see what's going to suck is that I'm not going to remember his name. And then he's going to be the bane of my existence for the next 4 years. And so he's going to make sure I remember it. But yeah, so I get that, okay, well, maybe it's not applicable to me, but I'll have you look at it from this perspective. From this perspective. I remember during the last Trump administration, something that they had tried to do at the outset was deny people's extensions and then say you're now unlawfully present, which means you're subject to, you can be deported basically. Yeah. And then there kind of became a quick run where we were kind of running around like, are they issuing notices to appear for these people? Are they going to be coming after them to put them in deportation proceedings? Because people need to understand this. If your status, let's say your H1B extension gets denied and you're no longer lawfully present in the U.S., you can depart. You have an opportunity where you can leave the U.S. You have a timeline where you're able to leave. And, outside of having to admit that you had a prior denial and maybe explain the denial, there's not going to be that wide reaching of a problem that comes back to bite you on that. If you were to get placed in deportation proceedings, that completely changes the game. That's a situation where if you leave without appearing in court, there's implications, and then there's implications of how long do you have to stay while everything is waiting? How do you sort things out? Can you apply again to get yourself back in status? So I do understand people being like, I don't know how that's going to affect me. It can affect you because the policies, like I've kind of been reiterating on this call, that are initially utilized for people that are illegally immigrating, they can bleed out and subsequently be used in the future against people who have come into the country legally and then lose their status because, they've had a denial or something like that. So while I'm very hopeful that that doesn't happen, because it would just really complicate our jobs even more, it's not to say that they can't utilize that. And so just thinking backwards from that, I just think that, if it does happen, it's horrible, but I hope it doesn't. But I think people should be aware that it's something that I know they have on their table. It's in their arsenal of things that they might want to do.
I mean, imagine being like the second or the third generation in the country, and suddenly, like, you and your family are having doubts if you can still be in the country or not. So,
Yeah, I mean, all that stuff's frustrating. I mean, I would not be shocked for a second. During the last administration, they really cracked down on the F1 program. They did. They went a lot harder at STEM OPT than they had ever done before. It wouldn't surprise me at all if they went after that again. I think that it's something that because you got to think about it this way. If they want to curtail immigration, what's one of the easiest ways they can do that? They stop people from coming in and doing F1s and working in the U.S. on OPT and STEM OPT. If you cut that out of the process, then those people have to leave the country. And yes, they may still go into the lottery, but it's probably going to be harder for them to get sponsored because they're no longer working in the U.S. They're working overseas in their home countries. So yeah, I think that that's definitely on the table. It wouldn't shock me at all if they tried to come out with basically new enforcement mechanisms for the F1 program.
all right, let's just hope for the best and look forward. All right.
Mhm.
Well, now, Justin, let's take up Rag's question. He's here on YouTube. He's saying, "Hi, Napasa and Justin. With a flurry of cases coming in, will the attorney's efficiency be compromised, resulting in more RFE or rejections?"
So I don't know if it'd be the attorney's efficiency that creates the issue with RFEs. The issue with RFEs are you prepare a petition as best you can. You try to cut off all lines of inquiry where they reasonably exist. But if you're dealing with a circumstance where the goalposts are being moved constantly and in real time, it's going to create problems. And that's what creates the increase in RFEs. Things like changing how you look at specialty occupation or how you make that definition. Things like how you look at how someone qualifies for a position, trying to reintroduce things like, project documents or proof of specialty occupation work. Those are all the things that are, in my opinion, are going to lead to an increase in requests for evidence. That's really the big issue with it. I think that the goal is not only to just increase the probability of denials, it's to increase the time that it takes to go through the process. It's to draw this out and make it more difficult so that it becomes a circumstance where employers just don't want to deal with it. I think that's really the underlying goal. And that comes from mucking up the system by making things harder when they shouldn't be. When it comes to, rejections, rejections are circumstances where when you're filing a case, there's something missing in the case or deficient, or it's sent to the wrong location. Those are things that typically an attorney should be able to deal with, regardless of what administration is in a position of authority. Where that could become problematic, just speculating here, because we've already seen it with Biden in some regards, is just changing things. Making quick changes to forms and saying, actually, you know what? You got to use this form edition. And we're not going to backdate it, so you got to start using it as of December 1st. And the form came out on November 26th. Well, if you're a normal, business immigration attorney, you've probably got X amount of cases pipelined that have already gone through that process, went to the client for signature, and they're in line to be filed. If you don't catch those before they go out, those will be rejected. So that's definitely something that could happen. Just making constant, updates and alterations to the forms. But at the same time, if that's going to be something that they do, then it's going to become incumbent on the attorneys to make sure that they're doing their due diligence at the time of filing, to make sure that everything that goes out is correct and proper. Because that's really the only way you're going to combat it. The other thing they can do too is they can move around the mailing locations, which is annoying but we do
Mhm.
try to stay on top of that as much as possible. That's a lot. Ayla deserves credit for that. Ayla does a lot with making sure that any of those changes that happen are kind of blasted out to the attorney so that we're aware of it. But those are avenues that they could take to
Right.
increase rejections.
Yes, I mean, changes and updates, these are very, very important things, and it's very important to stay updated. So, folks out there, just keep on researching and keep looking out for new changes. Because, I mean, I remember we had a lot of fee changes, and like you said, address changes, Dropbox location change, and stuff like that.
Right.
And this led to a lot of, I mean, cases becoming invalid because of the wrong fee and etc.
Right. And so that's another one too, that obviously, like when you talk about mechanisms to make the process more difficult, fees are such an easy one, you know. Fee increases are always a great way to hit the bottom line of the sponsoring petitioner. So
Mhm.
if they're able to kind of combine increasing fees with shortening validity periods, that's
Yes.
a win-win for them, because it puts them in a circumstance where they're really making it harder for the employer.
Right.
But yeah, that would be my answer to that, Raj. Thank you for your question. I appreciate it.
Yes, thank you so much, Rag, for participating. And if you have any more questions, we're still here. So, Justin, my next question, this is about Pete Hexet's political appointment as Defense Secretary. You know, this brings attention to his hardline stance on national security. So, do you think this could lead to increased militarization of immigration enforcement? And what might that mean for immigrants at the border?
So I will say this. This is actually something I've really been thinking about. Maybe not necessarily for the border, but it's something that has been crossing my mind. And that is, what is the impact on legal immigration of increased conflict abroad, whether that be in Europe or in the Middle East? You know, do we see some sort of proclamations coming out as a result of those conflicts, limiting immigration for people from those countries, or limiting immigration overall? I say that as someone who, we had a discussion before this call, for something I had just been dealing with, where it looks as if that there are people from a certain country that's engaged in a conflict right now that are basically just being denied U.S. visas under a very interesting strategy, where they're being told that they cannot overcome a presumption of immigrant intent. And by doing this, it's kind of almost become this blanket justification for a denial, where they're just saying 214B, no presumption of you have not overcome presumption of immigrant intent. Therefore, you are not able to qualify for, let's say a B visa to the United States. My wonder is that a strategy that could potentially become weaponized moving forward as the conflicts in the Middle East increase? Hopefully they don't increase, obviously, but it's pretty hard to watch the news every day and see what's going on, and think that the next 4 years are going to be really chill, and not involve more foreign conflict. But does that conflict create an even higher inclination, desire in the United States for this protectionist nature, where you're basically saying, like, we're severing ties, we're keeping Americans in their bubble, and we'll let people in from a couple different countries, but other than that, we're just staying with what we're doing? Maybe, I don't know. We'll have to wait and see. But that's
Yes,
something I've now been worried about. I'm starting to
yes,
think
I can
about,
only imagine.
right, what is the impact specifically of what country you come from and your immigration, not even how you qualify for something, or is it a valid petition? That, I think, is going to be on the table as well.
Right, right. And I mean, we've seen a lot of cases and a lot of announcements about becoming anti Muslim and not allowing, I mean, countries with major religion as Muslim, not to allow them to come in to the country.
Right.
So, and plus, like what you were saying about the case, I mean, imagine, you being denied a visa in spite of doing everything right, having all the
Yeah,
documents
I
correct.
mean, I'll just come out and say it. It's pretty much being talked about already. I'm talking about people from Russia, just specifically.
Yes.
There's been
Yeah.
a big increase in 214B visa refusals, specifically for people from Russia. It's a blanket denial, basically, that's being issued. And I'm kind of wondering, how is this strategy employed moving forward with other countries in the event that those people from those countries, their country is embroiled in a conflict? So we'll have to see. But like you said, the so-called Muslim ban is another issue that's something that's probably going to get attention coming in day one. So we'll have to see the impact of that as well.
Right, Justin. Thank you so much for taking that up. I think we should get back to Malu because he has another question for us on YouTube asking wage levels won't get enforced for H1B. I know H1B visa employees working for $70,000 per year, whereas citizens working for client for same position has double the salary.
Yeah, so I mean, if you're asking about wage levels being enforced, the wage levels should be enforced because you have to pay a specific wage level based on where somebody's working and residing. You know, where they sit is what's going to dictate the amount of money that they're paid for the position, based on what kind of position that is in the labor condition application. There's really two ways that USCIS and DOL can attack and attempt to undercut wage levels. The first of which is when you apply for a position, you have to determine what the wage level is at the outset of the filing. There's 4 wage levels. Wage level 1 is entry level, experienced, quasi-managerial, high level, four across the board. USCIS has the ability to question whether or not the position qualifies for the wage level provided. They've done that pretty stringently when it comes to what's called level 1 wages. So that's the lowest wage level. Basically, that level 1 wage level is only applicable at this point to absolute entry-level positions. People just out of college with degrees that are maybe just now starting to work in their specific industry, they maybe have internship experience or something like that. But as a result of that, you can't use level 1 to go in and undercut a position that doesn't meet that standard. So that's the first way in which you're really not able to game the system as much as it could have been gamed in the past. The second issue is if the company is actually paying someone under what's in the labor condition application, that's a DOL violation, and that can be reported. So not only would I tell you, Malu, if you see this going on, not only would I say feel free to report it to the Department of Labor, tell those people that are employees, if they're being paid under the amount of money that's in the LCA, to report this to the Department of Labor, because this is a violation. And those companies should be held accountable for what they're doing, because what they're doing is illegal. So that's kind of my opinion of how you fix a system that even has like some small issues in it, rather than just kind of make this blanket proclamation that like the H1B system is bad. Understand that there are ways that you can work within the confines of the system. I will tell you this, I file H1Bs all the time. It's been very rare for me to see anybody getting paid $70K a year. I think that is a tough beat at this point to find people that are going to be getting paid around $70K. Even when you're paying on the lower end of wage levels, I think that obviously location matters. If you're in California, you're getting a very high salary. If you're in Iowa, the wage levels might be a little bit lower. So it does depend on where you're located. But that being said, yeah, I think I've done 4 or 5, maybe 6 LCAs last week. And I can't remember one of those LCAs being for $70K. I think probably the aggregate among those was close to $115 to $120. And some of those were even higher. So yeah, I mean, look, is there a notion that the H1B is utilized as a way to undercut wages in the US? I think that, yes, that's an assertion that's been made. Can you do that now in the current 2024 iteration of the H1B? I don't think so. I think it would be very, very difficult to do. And I'll do you one more, Malu. I will definitely tell you this. On top of that being reported to the DOL if someone's violating and paying under that wage level, I definitely think you're going to see a big increase in FD&S visits. I think you're going to see people coming in now. I think you're going to see more officers getting paid to do site visits all across the U.S. to go to client locations or employer locations or even home locations if they're on the LCA. And they're going to be asking those kinds of questions. Things like, what are you being paid? Seeing if that complies. All of that stuff, if it's a violation and the company is violating the conditions of the LCA, they need to be held accountable. They absolutely need to be held accountable because that should not be the underlying purpose of why someone is utilizing an H-1B.
Right. Right. Thank you so much for taking that up. And I'm sure Malu is very happy with your answer, very detailed. And thank you, Justin, for taking that up. See, he has something to say already. Many of us have been replaced by H1B visa employees. So H1B wage level need to increase to 120,000 to minimum.
Okay, well, I mean, that's
I hope
what you're
so.
asking. You're asking me, you're saying, do H-1Bs undercut the wage level of U.S. employers, of U.S. employees? I've come back and said no, and now you're saying, well, the wage level has now gone up to 120K minimum. Well, that means that the wages are higher. So I'm sorry, I don't really know how else to answer your question. The underlying purpose was to prevent wage abuse, right? By hiring people that are paid less money to do the same job. So if that's no longer the case, then it seems that the program is being implemented in the way that the people wanted it implemented in.
They say they need to increase it to 120K minimum. So okay, I think that's what he. But yeah, thank you so much, Justin, and I hope that Malu, you have your answer to your question. But anyway, Justin, I have my next question, and I think without discussing about Elon Musk, we this wouldn't be complete. So,
Yeah.
with Elon Musk advising on government efficiency, do you think his involvement would lead to changes in how immigration processes are streamlined? Or do you think his focus will be on wasteful spending, which will result in reduced resources for immigration service?
So I would definitely say this, USCIS is fee based, meaning that the money that they get is generated by fees that come into them. So in that regard, I don't think you'd see much of a change because they're just going to basically do the same, pardon my language, but they're going to do the same crap they always do. If they're going to say, we don't have enough money. And then, we need to raise fees because we need more money. And then processing will stay almost exactly the same. And we'll wonder where the money's going. But in that regard, I don't foresee it being that big of an issue. Musk, I'll be honest with you, he confuses me to a little bit because I don't really know what his long term goal is. For example, my understanding was that the Trump administration wants to get rid of electric vehicle incentives, which would seemingly be directly harmful to his own organization. And then I've also seen that, one of the agencies that they want to cut funding from is NASA, which I think, again, would negatively impact his SpaceX program. So I don't know if his goal is to somehow put himself in a circumstance where, like, his companies benefit from these changes, but then other people don't. I'm really not sure. Yeah, I mean, maybe he does want to be president. Who knows? Well, I don't know if he can be president. I don't think he was born here.
Yes, I don't think.
So I don't know, maybe, but I definitely think that he's enjoying the amount of sway that he has presently.
Attention, yes.
Because he's in every picture, basically seated at the right hand of Trump. So yeah, I think he's enjoying that. I think him and Vivek, what they're actually able to do and what they say they're going to do are probably going to be two different monsters. Because this really kind of gets back to the whole appointment issues with Trump. It's almost never a matter of just if that person's going to quit. It's a win, Eventually, it's a situation where the person gets worn down and just leaves. So we'll see what he's actually able to do versus what the impact of it'll be. When it comes to like immigration, I've never really heard Musk come out and have any sort of anti-immigrant sentiment. I mean, I can definitely tell you through the grapevine that Tesla utilizes a lot of employees that are on NIV visas.
Yes.
So I definitely think that he's, someone that benefits from the H-1B program. So it'd be odd to see him kind of, bite off his nose to spite his face or whatever the term is. But yeah, we'll have to kind of wait and see. I would be surprised if it has long-ranging impact on immigration. The things that could have an impact on immigration for him from a business immigration perspective are what are the implications of these kind of cuts to government contracts, and government projects? Because I will say that I've worked with companies that, there may be a consulting company who the third party is actually a state agency. and what is the impact of that funding that's coming from the federal level to the state level for that project? And does it mean that they cut employees or whole cloth get rid of that whole project in the first place? That's something that I think could be a problem. But it's going to have to just be kind of wait and see. I mean, I know that they introduced a couple of policies that they want to talk about, but it's all broad strokes. There's no actual how-to of it. And until that really comes forth, we're not going to have the full scope of the picture. But yeah, I mean, hopefully out of everybody, Elon's at least the only person in Trump's ear saying, hey, immigration's a good
thing. Yes. Thank you so much, Justin, for that view. Well, I have a few questions on, our Facebook groups and also our YouTube channel. So let me see.
Yeah, I could try to do like one or two, but I am cutting time pretty closely, to be honest.
Sure. So let's go with quickly. I mean, these are just comments. Maybe you can just tell us your views on these. So this was on our channel saying, so conservative Republicans support people immigrating legally, but the border has been invaded by unwanted and the poor. We cannot financially support people who never put into our tax system, but want the financial benefit as a worker recipient. Yeah.
I think there's a pretty easy way to just say what this person's saying. Trump wants to block illegal immigration from coming in. People validly understand that undocumented immigration is a problem in the United States. The system does not operate efficiently, and it doesn't operate the way that it's supposed to. I personally will even go one step further and say when people that are immigrating to the United States come in and they're working on work visas, I think that it's a little bit ridiculous that part of the employer's job now is to throw an extra $600 into their petition specifically to deal with issues at the border. The so-called asylum fee that has been added into these employment-based applications, I think is unfair. I don't think that it's necessarily appropriate for legal immigration for people who are sponsoring people here in valid non-immigrant statuses to have to take on the additional burden of dealing with problems that are occurring at the border. I understand that frustration. I also think that it must be incredibly frustrating for someone who has been in this country legally for 10 or 15 years that is still sitting here waiting for an opportunity to apply for a green card, be told that, the big issues in this country aren't you. The big issues in this country are people coming in from the southern border and, claiming asylum. And that's really where everyone's attention is going to lie. So I understand that anger. I get it. What I don't understand is this disconnect that seems to exist for some people that are here legally, that have immigrated here legally, this disconnect that Trump only has issues with illegal immigrants and Trump's only going to be creating enforcement activities that only goes after people that are in the country illegally. Donald Trump may believe that in his heart and soul. Stephen Miller doesn't. And Stephen Miller is the person that's going to be architecting the policies that are going to dictate the next 4 years. Yes. That's where the disconnect I see gets frustrating for me. Because I really don't want to hear people complaining when we're a year and a half into this process and legal immigration has gotten more difficult. I don't want to hear the complaints about, oh, well, I didn't think this was going to happen. We were telling you it was going to happen beforehand.
Yes.
So I don't want this head in the sand crap that is inevitably going to spew up as a result of that. So yes, to this person's point, I get it. The southern border is a mess. It needs to be addressed. Honestly, it looks like it was pretty high on the list of reasons why Trump won. And that's something that he's going to be tasked with fixing over the next 4 years. We'll see how he does. I hope he does well. I hope that we're able to create avenues that create positive results where we're able to curtail this problem and make it better. I also hope at the same time he does things that benefit legal immigration. But we will see. Is it likely? No. So yeah, that's kind of all I have to say in relation to that comment.
Thank you so much, Justin. That was really valuable. And this next one is, I hope Trump bans sanctuary cities and ban illegal immigrants from getting any benefits from America.
Okay, we're kind of we're spinning on the same wheel that we were on previously.
I hope so also.
And look, I get it. Like, there's definitely going to be a lot of showdowns that happen over the next 4 years with illegal immigration. There's going to be issues related to state government versus federal government. The enforcement of immigration by local officers, I've already seen as an issue that people are bringing up. The idea of sanctuary cities being challenged or being brought up as well. All of this, in my opinion, really comes back to this notion that of people who came here the right way are frustrated that people who didn't come here the right way are getting benefits. And they're getting, it's a feeling of animus that I'm trying to do things correctly. I see people not doing things correctly, but those people not doing things correctly seem to be getting more attention and a better break in terms of benefits than what I'm receiving. Okay. I hear that frustration. I understand it. All I can say is what I do professionally, and what I've done professionally over the past couple of years, dealing with this exact administration and what we're going to deal with its new iteration. You're not going to just escape the impact of immigration policy changes merely by virtue of entering the country legally. It's not going to mean, do I think that Trump's going to hunt down everyone that's on an H1B and deport them? No, of course not. That's not going to happen. But we are going to see a tougher 4 years play out than we have seen under the Biden administration. And that's just a fact. It's going to be what we deal with. And that's regardless of what they do with illegal immigration.
So true.
So if you are happy that these changes are being made in relation to illegal immigration, okay, that's great. But do understand, if you are an immigrant and you are in the United States right now, or you want to immigrate to the United States, the world that you're going to be looking at by the middle of next year is going to be very different from the world as it is what we're speaking about presently.
Mhm. Right. I think, thank you so much, Justin, for that. Last but not the least, if you would just like to take up this last comment from Rag, will legal immigration get a day one surprise, or could there be a bit leeway?
I genuinely don't know. I mean, I don't think it really makes sense for them to come out and make drastic policy changes in relation to legal immigration on day one. I think they're going to want to serve the master, which is the masses, in their desire to make changes at the border. So I really think that's going to be what policy A is for them, is going after making whatever changes they think are necessary. I think they're definitely going to reinstitute the Remain in Mexico program. I have heard that they are trying to institute a similar program in Canada. So that'll be interesting, because I didn't know that there was a lot of people trying to come in through Canada to claim asylum. Usually you hear about it coming from Mexico. So I know that those are going to be things that they're probably putting in at the outset. I definitely think that, the family separation thing is going to be big. And then how they handle different policies with removals and stuff like that. That's all going to be big. That's going to be, like I said earlier in our call, that's going to be what gets the eyeballs. What's not going to get the eyeballs outside of the immediate community that handles immigration on a day-to-day basis are going to be the policy changes that they implement throughout the duration of the 4 years that they're in. Because I think obviously don't agree with the things Stephen Miller does, but I have to give some level of credit where credit's due. He's had 4 years to sit on the things he did last time, and he's had an opportunity to probably make changes and corrections to things that he was not able to get done before. So you're going to see, you're going to see somebody that's coming in with plans and ideas that he's going to want to implement. But yeah, maybe day one, will there be 150 RFEs issued the day Trump takes office? No, I don't think so. I think you're probably looking at more of a slow burn.
All right. Thank you. And Rag already says, thanks to Pasa and Justin. Great updates. Thank you, Rag, for participating.
Thank you for your time. I'll try to come on next time we get together with just something more positive. Just
sure.
But
Justin, it's really, but it's seriously always a pleasure to have you here. Thank you so much. Today was great. I mean, it was a great and interesting discussion about all these picks that Trump has made in his new team. So thank you so much, for doing this today.
Absolutely. Thank you very much for having me. You guys have a great week. Have a great Thanksgiving. And I'm sure I'll talk to you soon.
Yes, me too. And here's wishing you and your lovely family a very happy Thanksgiving as well. Happy holidays.
Happy holidays. Bye.
Bye-bye. So, folks out there, thank you so much today for joining us in this very important discussion. And it was great having you. Please don't forget to like, share, and subscribe to Immigration and Jobs Talk Show. We are on YouTube, LinkedIn, Facebook, and also on X. So, thank you so much. And stay tuned because we have more webinars lined up. And I think in just 15 minutes, we're going to have another. So, yes, watch out. Immigration and Jobs Talk Show. It's Napasa saying bye for now. Hello and welcome back, everyone, to Immigration Talk. I'm your host, Pastor Pradhan, and today we have an exciting and highly informative session lined up for you. But before we move ahead with what our topic of discussion is going to be, and I even introduce you to our guest for today, I have this very important disclaimer, and that is by watching our videos, you agree and understand that the information provided to you by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. Once again, friends, thank you so much for joining us. We are streaming live right now on YouTube, LinkedIn, Facebook. And let me tell you that you can also participate in this session by commenting. So, whatever questions you have, especially with regard to the topic of discussion for today, it'll be very nice if you can comment them. And we will definitely make some time later in this session to answer to your questions. So thank you so much for joining us. And definitely, I mean, the 2024 US presidential elections have really stirred up a lot of discussions, and people are really anxious also, especially when it comes to immigration policies. So, with potential changes on the horizon, many of you are wondering maybe what will happen to US study and work permits in 2025. So, to help us, navigate and dive into this really very critical topic today, I'm really thrilled to introduce you to our esteemed guest who is going to join us today for the first time on Immigration and Jobs Talk Show. None other than Attorney David Garson. David is the founding partner of Garson Immigration Law, one of Canada's premier immigration firms, and he is a certified specialist in citizenship and immigration law, recognized by the Law Society of Ontario, and is ranked among the top 9 immigration lawyers in Canada by Chambers and Partners. So, David's extensive knowledge and expertise and experience in this field definitely makes him the perfect expert to help us in this topic today. So, without further ado, please help me welcome David Garson for the first time on Immigration and Jobs Talk Show. Thank you so much, David, for joining us.
Thank you so much for having me. It's a pleasure to be here.
Absolutely lovely. And maybe you would like to tell us a little more about yourself, something you may want to highlight or tell us about yourself, anything at all.
Sure. I've been practicing immigration law for over 30 years. I'm dual licensed in Canada and the United States. We help individuals enter Canada and we help them go to the United States. So, I mean, we've seen a lot of what has been going on over the years, and immigration has, as it's been influenced by politics, and frankly speaking, politics has been influenced by immigration. So it's a very interesting time that we're facing right now, without a doubt. There's an old curse, though, may you live in interesting times. So I imagine that there's a lot of anxiety and a lot of questions that people have, including me, because I know we're going to get into questions and you may hear this a lot from me going forward, but we really don't know much yet. We know what the intent is. We know what this administration had done previously when it was in power, or this president, but we don't know necessarily what is going to happen in the next 4 years. But there have been some indications. There's been some statements on the campaign trail, and I think we can try to piece together or guess, prognosticate as we go. So I look forward to it.
Me too. And definitely with your expertise and experience, I'm sure your perspective is going to add a lot to the viewers out there. I mean, who are all anxious, want to know more, what is going to happen. And some of them are even maybe, fired up to even acting quickly. So maybe you might want to warn them or give out some tips to relax them. So thank you so much, David, once again for joining us. And as we already have said about the topic of discussion, today's topic is U.S. study and work permits, what to expect in 2025 after the elections. So I'm sure folks out there are very, very excited. And I can already see some comments popping up. So thank you so much, Supriya, our first viewer who has commented with a question. Please stay with us. We will address your question a little later. So, David, are you ready for our questions now?
Sure, let's go.
Let's go. So how do you anticipate changes in U.S. study and work permits under the new administration, particularly for international students and foreign workers?
Well, it's an interesting question because, as many people may remember, under the last administration, they did try to enact legislation or presidential orders stopping people from coming or stopping students from coming and regarding work permits, but the courts overturned them on various occasions. So whenever they were attempted to try to sort of enact things or move forward, the courts sort of made them take a step back. So in the end, they didn't really get a lot done legislatively, meaning they didn't pass a lot of laws with regard to be restrictive. But what they did do, and what they can do again, is you can work within the system to make things more difficult if you're so inclined. I'll give you an example. If somebody makes an application for a student visa, as many people who are watching probably know, you have to satisfy the State Department or the consulate of a few things, one of which is that you have temporary intent. Now, that's a very broad concept, temporary intent, right? You have to show that you are willing to go back to your home country at the end of your studies. So to do that, you present a lot of documentation. You show you have bank accounts, or you have ties, you have family, you may own property, job offers, things of the sort. So you keep doing this and you go to the consulate and you say, okay, I've been accepted for University of Pennsylvania. And here's the proof that I've been accepted. Here's my I-20, which is the document you have to present. And here's my proof that I have ties. A consular officer can look at it, because it's very discretionary, and say, okay, I'm satisfied with those ties. Fine, we're going to give you the student visa. Or a consular officer can say, no, not satisfied, not good enough. Now, if an administration wanted to curtail the number of students that come into the country, then what they can do is simply tell the State Department, which tells its officers, perhaps look at these applications a bit more critically. There may be another set of criteria we want you to examine in that regard. So they can make things more difficult without changing any legislation for people from getting student visas. So let's say that somebody does get a student visa and they come into the country and they go to school. As many people know as well, at the end of their schooling, they can get something called an OPT, optional practical training, for a year. And then subsequently, under the Obama administration, they said they can extend that by 2 years, okay, if you're in a STEM field, okay? They could take away that. That was something that the Obama administration put into effect. That's not something you have to have. And certainly that means that in terms of being able to work at the end of your studies, they could make that 1 year, they can make it shorter, they could play with the STEM time frame, they could play with the OPT time frame. So I guess what I'm saying here is, what do we think is going to happen? I think that if they want to make it more restrictive, they can do a lot just with what the legislation and the rules that are on the books. And then subsequent to that, in terms of working afterwards, they can make it more difficult based on how they want to work the work permits after you graduate.
Okay. So we can definitely expect another layer of scrutiny or maybe tightening of.
I was going to say, and there may be a question going forward that we want to, yes, I think based on previous experience, but remember when I started, I said that politics play a huge role in immigration, meaning especially the people that advise the president with regard to this. In his last administration, there was a fellow named Stephen Miller who was advising President Trump on immigration. Now, Stephen Miller was a pretty restrictive guy with regard to immigration. He had thoughts and policies that meant you couldn't, he wanted to narrow the ability for people to come to the United States. Mm-hmm. I don't know, or I haven't heard that he's advising President Trump this administration. In fact, he's taking a lot of advice from Elon Musk. Now, I'm a guessing man. If you guess, Elon Musk would know the value of foreign workers, and especially people in STEM fields, with regard to what he does. So if he's advising President Trump and he says, okay, listen, we need people, let's say, with regard to the H1s or OPTs, because these are the individuals that we need in the tech sector or the manufacturing sector or the innovation sector. And so maybe let's not be as harsh as we were previously.
Mm-hmm. So there we go, friends. And I think along these lines, we are going to definitely dive deeper and we have more questions and more people joining us. So I'm really happy. Hello to George, if I'm pronouncing it right. Hello, George in LinkedIn. And we have Namrata Reddy, Jaya Kumar. Please stay with us. We are going to take up your questions for sure. So David, my next question is, what specific policies do you expect Trump administration to implement in 2025 that could affect students applying for F1 visa or those already in OPT?
I'm thinking, as I said before, that they are going to be more restrictive with regard. This is what I expect. Everything I'm saying here is I'm just guessing the same as you, but based on what I've seen and based on what I've heard, I do expect them to be somewhat more restrictive with regard to issuing F1 visas than they have been. I also expect them to be somewhat more watchful. I mean, I don't think they enjoyed seeing, and especially they spoke out on the campaign trail, all of the occupied at the universities in terms of the encampments. I think that was something that was not something that this Republican Party, or certainly this president, wants to see going forward. So I think there may be somewhat more restrictions and or variations that are imposed on individuals with regard to what they do when they do come to the United States, if they get their F1. And if they do act in a certain way when they're here that doesn't exactly or expressly have to do with going to school, then there may be further actions that can be taken against them with regard to leaving the United States. In terms of work permits, you know, as I said, they got slapped a lot last time they were in power with regard to changing the law. So they acted or created situations that gave them what they wanted to do. They slowed down processing. They made it, the amount of denials increased in terms of the percentage. So they can do things like that. I would guess, based on what they've done before, that that's what they'll do again.
Okay, but it's really nice to have, your point of view, your perspective on this. So thank you so much, David, for doing this with us today. And also, since we're talking about students, maybe you could tell us what challenges should students be prepared for, especially student visas on F1 and work visas H1B.
So when you're coming in, and as I said, when you're asking, I mean, if somebody's applying for an F1, you know, the easiest way to refuse a person if they have the money to pay and if they have the money to support themselves and if they have been accepted to the school, the easiest way to be refused is on temporary intent. So if you are applying for a visa, to document yourself with regard to temporary intent and your ties to your home country, I think is going to be crucial. I think you have to have as much documentation as you possibly can with regard to your case and with regard to your ties, so that when you go to the consulate and you apply, that you are able to convince the officer that you do have that temporary intent and you can come to the United States and you will leave. I think that's going to be paramount with regard to that. In terms of the student visa, I mean, once you get a student visa and you get your OPT at the end, the issue is that, of course, with the lottery on the H1s, and it makes it difficult to get an H1 in any event. And we are, for instance, contacted by companies all the time that have an individual who is in OPT status and has applied, and they've tried to get that person in H1, and they can't. They've not been picked. And a year goes by, and if they're on STEM, they have the extension, but they don't get picked. And so the company is looking to see if they can go work in another place for that company elsewhere in the world or something of the sort. So the advice I would have, realistically speaking, is that once you're here on the OPT, I mean, it's not, you don't really have control of this situation. And unless they expand the number of H1s that they're willing to give in a year, realistically speaking, I would probably look at, on practical advice, working for a company that maintains as a multinational corporation that can send you other places if they need to, if that's at all possible.
That's good advice. I think that we should consider for sure, folks out there. I think you should look onto that too. And, David, I think we'll quickly take Jaya Kumar's question, if that is fine.
Sure.
So let's go with it. I got 221G issued with white slip, and after a week got an email that intend to revoke from consulate in India. What are the chances of getting approved if my employer responds back?
Oh, that's a very good question. So first of all, for anyone that wants to know, 221G means they need more information. So there's various ways that a consulate can refuse you. It could be under a section called 214B, which is that temporary intent section. The one you don't want is something called 212AC, because that's misrepresentation and that's horrendous. 221G means that they need more information, or so they're refusing the case pending more information coming in. It's a refusal, but it's kind of not a refusal, because it means that they're still considering the case and are okay to get more information. Now, I don't know the background of this case, in the sense, why is there an intent to revoke? Is there an intent to revoke because they came upon other information that sort of speaks against what was previously submitted? Have they perhaps done an investigation and figured out that there isn't something here that they need that didn't occur, or something of the sort? So in answer to your question, what are the odds? It depends on why they're going to revoke. If they're going to revoke because they have definite objective information that's not good, then the odds may not be that high. But if the intent to revoke is based on a misunderstanding or information that they didn't get or thought or they misread, then it could be fine. Realistically speaking, I mean, whatever you do, when you file that information that is supposed to, that they want, please make sure it's as fulsome as possible, because you're going to get one crack at this. So if you're filing that information that's in addition to what they want to try to address the revocation, make sure it's as fulsome and as packed with whatever you need as possible. Don't play games with it. Because also, and again, I don't know the background, if you submit information that isn't helpful and they are looking at it and saying, well, we're revoking this because we think there is misrepresentation, then you could get slapped with that 212A6C, which is never a good thing. And it could be very deleterious to the case.
Right, David. Thank you so much for taking that up for Jaya. And Jaya, thank you for your question. Really great question. If you have any further questions, you can keep commenting. And we have Jorge saying hello, and he has a question. What can an experienced engineer in the IT industry that is a non-US citizen do to get a working visa, any type?
In the US or anywhere, I guess, in the US?
Yes, that is a non-US citizen, maybe in the US. Yes, in the US.
Yeah. I mean, realistically speaking, it depends on your citizenship, of course. If you're Australian, for instance, you may be able to get an E3 visa. Or if you are, let's put it this way. So there's different types of visas you can get depending on citizenship as well. So if in the normal course, everybody knows about the yes, in the US. Okay, good. Everybody knows about the H1, right? You have to have an employer. The employer has to register. You have to register that expression of interest. The rates of acceptance haven't been that high. They've had a lot of applications and a lot of people have not been chosen. But that is the normal way that most people do get visas. There's something called an L1, an intercompany transfer. So if you, for instance, are an engineer and you go work for a company overseas for a year, and that company then wants to do this L1 intercompany transfer, they can do that to send you into the United States. If you go work for a company that has your nationality, there's treaties of navigation and trade. It's commonly called the E visa. So if you have the same nationality as the company ownership, then they can try to get you a visa under the E visa category. If you're Canadian, then you have the free trade agreement that you can look at, or Mexican for that matter. So there are various possibilities. That being said, the most common way an individual gets to the United States, all things being equal, is if a US company petitions for them under the H1 category. Actually, there's one more as well. If you are a person of extraordinary ability, and in that you are one of the top individuals in your field, you've written articles, there's been news about you, all that kind of thing, then you can apply for something called an O1, which is extraordinary ability. You have to be a very high level, though. It's not, they realize with the cap on H1s, a lot of people are going to try for O's. So you can't do it if you don't have at least, unless you've written a lot of articles or some scholarly, and unless you've been featured in a lot of different ways, it probably wouldn't be relevant.
Definitely. And by, free trade agreement, you mean NAFTA, right?
Well, it used to be NAFTA. The US calls it the USMCA now. Canada calls it the CUSMA. And to be honest, they have no clue what Mexico calls it at this point.
Okay, but Jorge, you have a lot of options out there. Depends where do you actually fit. So you might as well go consult an expert. And I would always say, yes, you need an attorney. So it'll be good to be guided by an expert. Thank you so much. And now going on to our next question. And definitely, if you want to have a one-on-one consultation with David, you have his contact details on the screen. You can email David at garsonil.com. And you can go visit www.garsonil.com. Thank you so much. And let's go to our next question, David. And that is DJ4496 asking, hi, my husband is primary. We are from India on EB2. We got our green card EAD for 5 years. Our priority date is September 30, 2014. So my question is, when can we expect green card?
Yeah, it's going to be a long time. It'd probably be within that 5 years. Well, right now, I'll take that back. Right now, it could be within the 5 years, but it is taking 5 to 7 years in that regard. However, that is also something else that may change come the new administration. These things could get elongated out. As you probably know, many people find themselves in a priority date that is current, or you think it's almost current, and then it doesn't move for a long time. The issue is that come the new administration, one of the things they can do as well is slow down the priority date processing. So that takes a while. I mean, the fact that you have a green card EAD for 5 years is good news. I mean, that keeps you there for a long time, and hopefully, there is also the president-elect did go on radio and talk about the fact that people that graduate from U.S. universities should be eligible for green cards as long as they do everything right and they've done everything that is appropriate. So, you can't always think that he's going to, or they're going to do anything that's that detrimental. It could be that if he's looking at who is applying and that they need individuals in that field that are applying, and I mean, he may speed up green card processing in certain situations. He may be tougher in others, But to your point, your husband has the EB2 approval. You have a 5-year work permit. Hopefully, within the next 4 years or so, you should be able to get a green card.
I think 4 years is not so bad. I mean, for
Not
many
easy.
folks out there, it's decades.
But again, we don't know.
We don't know.
That's the problem with having this in November when a new president is taking office in January, and you have no clue what he's doing. Somebody asked a question about Tom Holman being appointed today as the new border czar. Yeah.
True.
You know, I'll answer. I was just looking at that. What are your views? Tom Holman being appointed as a border czar by Trump administration. Should people be scared given his known stance on immigration and mass
Deportation, Drive 10, yes.
Well, you know, he was the head of ICE before, and he is a tough guy on this. In terms of being scared, I think that Trump is sending a message, certainly. You know, one of the cornerstones of his campaign was talking about deportations, right? I think Vice President-elect Vance talked about deporting 1 million people a year. I don't think they're going to be able to do that. Let's be blunt. They're not. First of all, how are they going to find them? I mean, where do you, if they're out of status in the States, where do you go? I mean, you have to locate people. But I think Mr. Holman is a very tough guy. I think that it is sending a message. I think that if you're going to look to deport people and you're going to look to be restrictive, he would be the man for the job. Yeah, I think that that's what he's doing there. That all being said, the courts are there for a reason. And like I said, in the last Trump administration, a lot of what they wanted to do was thwarted by the courts. So if once somebody is taken into custody and they move towards deportation, I mean, I'm not a deportation lawyer, an enforcement lawyer in that regard, but there is access that a court can comment on with regard to any of this. But yes, I think I think having Mr. Holman as the border czar will mean that the Trump administration is going to try to do what they said they were going to do.
Right. And this could be one of the biggest mass deportation in the history of the United States, I guess. Let's see what it holds.
I think that he wants to try. I mean,
let's see.
Yeah, and then somebody said they were talking about deporting illegals. If you're there illegally, there's nothing to fear. I agree with that.
Right.
I agree with that. I think if you're in the United States legally, I don't see anybody wanting to deport you. I don't think they can. They can't if you're there legally. The question is that they could create situations where you can't extend your status, or that it would be too difficult to extend your status. And in those situations, then you have to leave. But in terms of being gathered up by ICE and deported, no.
True. Thank you so much. David, for taking that up for Drive 10, and even Jorge, thank you again. So we have our next question. This is Akshay. Akshay is on YouTube asking, would the consulate officer check my past employment history after my MS? Now, if I am applying for a PhD, what should I be careful about?
So they're going to check my employment after my master's degree. Well, yeah, if they have information. I mean, realistically, when you fill out, when you're at the consulate and they're asking you questions, after you got your master's degree, I'm assuming you did your OPT. If that's the case, then they may look at that. Certainly, yes. If you're applying for your PhD, if you're not extending status and you're going to a consulate and apply, then it pretty much is what I've just discussed, and that is the temporary intent issue and the fact that you're transparent with regard to what you're going to be doing and what you're doing and how you're going to be doing it. The fact that you're going for your PhD should, by practicality, make it easier to get a visa, because it does show you have certainly serious intent towards your education to get a PhD. And it's normally, when you get higher in the educational sphere, it normally would make it not easier per se, but the officer would understand especially if you've had visas there before, that you've adhered to U.S. immigration policy, and that you've been someone that is credible. Okay, and I think that has a lot to do with it, credibility, when you're applying for any visa. Because if you do things that they don't particularly care for, or have done things they don't care for, then you lose your credibility with immigration, and that's when things go awry. And that's
Right.
good. You did your OPT in STEM and then return back to your home country. I think that's very good. It shows that you adhere to U.S. immigration, that you follow the rules, and that they can count on you to follow rules. And I think that having a track record like that is important.
True. True. And I think that is a plus point for you, Akshay. Thank you so much for your question. And if you have any more questions, you can keep commenting. Well, he says, yes, I did my OPT in STEM and then returned back to my home country. Very nice. Following the rules. There you go. And thank you so much. Even DJ4469 says, thank you for answering the question. Great. Well, David, now I have another question, and that is, if an F1 student's OPT is set to expire in 2025, what options do they have for extending their work authorization, especially with the potential changes in US immigration policies? What do you suggest?
Yeah, this is an easy answer, not much. There isn't that much to do in the sense that if your OPT is expiring, and you don't have if your OPT is expiring and you don't have a STEM OPT extension that you can look at, or you can't get another type of work permit based on nationality or a treaty or something of the sort, then there really isn't that much for you to do. As I said, though, we have seen companies, multinational companies, where somebody has an OPT and they're with them for a year, and then the company says, you know what, we are going to put you and you're going to work for our subsidiary or our parent or our affiliate in another country. Then that being the case, if they do that and you're with that company if you're with that company in another country, then if you work there for a year, they can then look for an L1 intercompany transfer to bring you back to the United States. By the way, that is another possibility where they may be more restrictive going forward. There's such a visa called an L1, and an L1 is an intercompany transfer. And you can do an L1 for a manager or executive or a specialized knowledge person. And specialized knowledge usually means a unique knowledge. It's both proprietary to the company and a knowledge of the field. So if they wanted to slow down people who are coming to the United States in specialized knowledge L1s, they could do so, again, not by changing legislation, but simply by making the criteria more rigorous and saying it's going to be harder for you to get an L1 because we want to see a lot more within what you've done and your history and your experience and things like that. So that could be something else that they look at. But if you're in OPT and you don't really have any, you can't extend it, and you can't qualify for another type of work permit based on, as I said, other factors, and unfortunately there isn't really much that I can see that you can do.
Well, thank you so much for that, David. But I think that's all we can do for 2025 then. And I'd quickly like to say hello to Jemshid. Thank you so much for joining us on LinkedIn. And then we also have Ezzy Lydia. Lydia, thank you so much for joining us. Hello, everyone. I am Lydia. She says, hello. Now I have my next question to you, David, and that is, what impact will the expected changes to work permits and student visas have on industries that rely heavily on international talent, such as technology and healthcare?
That's a good, well, and this is what I was talking about before, that it would be I think it could be pretty detrimental in those situations, which leads me to believe that there will be individuals surrounding the president-elect that could talk to him about this, i.e. Elon Musk or someone of the sort. I mean, he doesn't want to, cut off his nose to spite his face necessarily. He understands that there are areas where people need employees, and if you don't have them, then things are going to not be as I guess you could say, they won't go as well as they should for that industry and for that company. So realistically speaking, I think it will have a deleterious effect on those companies and that industry, which leads me hopefully to believe that they will see that and make allowances in certain areas.
Okay, but definitely, I mean, people, I mean, especially where US needs a talent from, I mean, different countries where, US may not have theirs. And I think this is something that is going to be affected for sure. So, David, thank you for highlighting that. Now, I have another question, and that is, if a university student on an F1 visa receives an unexpected job offer before graduation, what immediate steps should they take to ensure compliance with the new work permit regulations under the Trump administration?
Yeah, well, they won't be able to do, again, they'll have to, I mean, realistically speaking, they can do their CPT, which is part-time work within the context of when they're studying, and that's fine. And they have to be able to do that and get approval to do that. But realistically speaking, if you, under this administration, we don't know what they're going to do with the OPT and what they're going to do with regard to the student visas, because in the normal course, you can't work if you're on a student visa. You have to go to school. In certain circumstances, a spouse may be able to, if things go very bad and in hardship circumstances, there may be ways for a person to get a EAD. But in the normal course, they can't do much in that regard. They have to be compliant. I think that is the lesson that going forward is going to be as important as anything. And that is, under this administration, you have to remain compliant to the letter of the law. Because I think that if you do anything that's not going to be completely by the book, you could find yourself in a situation where you will be removed from the United States, or put yourself in a position where you could be removed from the United States. So in any event, if you get an offer of employment, you can't necessarily you can't necessarily start working. You have to wait until you're eligible to work. You wait for that, then you can start to work. And any employer that is interested in hiring you, and frankly speaking, has worked in the system before, will understand that. Remain compliant. More than anything else, remain compliant.
Thank you, David. I think that is a great advice. And folks out there, you definitely need to stay vigilant, compliant, go by the rules, be on the right track, and stay hopeful. I think that is what I can say for now. And yes, absolutely. Go contact Attorney David Garson, and he's definitely going to direct you at least how to go about it if you have any confusions, or especially that every case is different and you might need special attention. So why not email David? His email address is david@garsonil.com. And you can also go visit his website, www.garsonil.com. Thank you, David. And okay, Akshay is back saying, I'm sorry I missed the first 15 minutes of this session, but I wanted to ask about the implications on OPT and STEM OPT going in the future. Do you want to say that?
Sure. As I was saying, we don't know. There's been a lot of discussion regarding it, to be honest with you. In fact, this is probably the area that has been focused on the most by pundits and newspaper reporters and things to sort of, what is this administration going to do with the OPT and STEM OPT? The STEM OPT was established by the Obama administration. I think that the Trump administration, in this first go around, tried to get rid of it, as I recall, or tried to limit it, and they weren't able to do so. That doesn't mean they aren't going to try again. The OPT, I don't see them stopping the OPT. I really don't. I don't know why they would. I think that it's helpful to employers, it's helpful to the individuals, but I don't know that it would be expanded in any way, shape, or form. Unless, and I mentioned this at the beginning, as I said, under the last administration, the person who was responsible for advising the president was a fellow named Stephen Miller, who is pretty restricted. I don't know that this person is advising the president under this administration. I think Elon Musk is having a lot of say in this. And that being the case, if he listens to that kind of individual, then he may understand the importance of people who are in STEM or technology or even trades, to be honest with you. I mean, let's be honest, a lot of people, they say there's 11 million people who are out of status in the United States. I don't know. I haven't looked at the statistics, but I'm kind of thinking that a lot of them are in construction and in trades in places that need them. So for instance, there was just a hurricane in North Carolina. There's always hurricanes in Florida, things like that. They have to rebuild their infrastructure. And I'm not sure there's enough people who are US citizens or green card holders who can do that. So I think practically, and I think I don't want to say it's a secret, but I think most people believe or think that a lot of the people that are working in trades and construction and I was going to say technology, not so much, but trades and construction are probably people who are out of status. And so if the president or this administration wanted to look at something like that, there may be a possibility of I don't want to say an amnesty because people freak out when I say the word amnesty, but of a possibility of creating a pathway for individuals who work in certain sectors and have worked in those sectors for a while to get permanent residence, especially if they're needed.
There you go, Akshay. Thank you. Yes.
Somebody just made a comment that Elon will be the savior of the STEM people.
He's the same guy. Akshay is the guy only. So he was also saying, also it is true that you can use STEM OPT only once. For example, if I used STEM during my master's, then I cannot use it after my PhD. Please clarify.
Correct. Yes.
That's true. That's true, Akshay. So there you have it. Thank you. Thank you so much, David, for taking that up. Jorge says, just want to thank David for this session. He's very well spoken and knowledgeable. Definitely. Thank you so much, David, for joining us and making time for this.
That's very
now
nice.
My next question, yes, thank you. Next question for you, David, is how will the proposed restrictions on OPT affect international students pursuing STEM degrees, and what steps can students take to mitigate these changes? We've been discussing this over and over, and maybe if you have any more points to...
Yeah, no, I think I pretty much said everything I can say. We don't know what they're going to do. Everything may change or nothing may change. You know, I know I sound, that's an easy thing to say. It gets me out of a lot of questions, but
no, but
I do think based on previous experience, meaning the government's previous governing, or this government's previous governing, that things will get more restrictive. It will be tougher to get cases through. They don't need to change the law to do that. The L1s, the H1s, they could take away spousal. I'm going away from OPTs, I apologize, but they could take away spousal work permits from the H2s or the L2s. I'm sorry, the H4s and the L2s. They could take away, meaning if right now, if I'm on an H or an L, my spouse can get a work permit. They could take that away. And by taking that away, it lessens the, I guess, desirability of people coming to the United States. Because if their spouse can't work, then what are you doing? That's not very fair. It's fair, but it's their country. But what I'm saying is it's not as attractive to somebody who's coming. So they could do all sorts of things. So in terms of the OPT, I don't know that they'll do anything significant. I think the STEM OPT, that in itself is up for grabs. And to that person's point of view, Elon may be the savior. Who knows?
For sure. Okay, well, what do you want to say about the H1B lottery? Maybe of course, we are going to expect changes, everything immigration related. But do you have anything to say on that H1B lottery system?
Yeah, I mean, the 65,000. It's always it's a mad rush when cap season comes and employers file the expressions of interest and wherever it's usually 15, 20, 25% that get picked. I can't see them going a lot higher than that. If they wanted to do things that were, I guess you could say, innovative, and then they could change that cap for the various industries that people go into. So for instance, there's a lot of people in STEM, a lot of US citizens and a lot of green card holders in that sense. So if you have if you have a degree in a STEM field and they need STEM people, then they can absolutely say, you know what, we can raise a cap in this area. We can get more people in this area. Why we need them? Or it could be another field or something of the sort. In the sense of that. So they could be innovative. You never know. Things could go better than it has been before. In that way, they could be somewhat creative and think outside of the box when they're doing these kinds of things, or they may just be completely restrictive. In other words, it may be a very good hedge, and it would be a good legacy for this administration if they changed the immigration policy and made it something that was more utilitarian for everybody, so that it's functional and practical, not necessarily a one-size-fits-all.
True, true. And maybe everything you say cannot happen. I mean, even Trump cannot say that whatever he has said can happen, right?
Right. No, that's exactly the case. I mean, in the end, it will depend upon who the president surrounds themselves with, right? It goes to the fact that if you are in a field or in an area that the president believes is important to the country, then he could basically do it he could do things that would be a great help to the U.S. And then, as I said, he's very concerned about his legacy. It could really help his legacy.
Right. Right. Thank you so much, David, for that. And, I had some more questions from people who keep commenting on our groups and YouTube channel. So I think I would like to share that. But hold on, not this one. Okay. So this was on nationwide protest on Canada 2 months back when they were talking about deportation. But if you find it relevant and if you want to take them up, you may want to give out some views or perspective on this. So when you apply as an international student in Canada, you are required to write a letter stating you will return to your country once you complete your studies. That was the agreement they signed.
Yep. Sorry, is there a question or?
It's just a comment. I mean.
Oh, yeah.
Then we have. Let me take this up for now. This is from Dixit, asking urgent. I went for my first H1B visa stamping yesterday and learned that my F1 visa was revoked. I was sent for second interview on same day, but my visa is cancelled. The interviewer told me that I was involved in a fraud with my first OPT employer. My other friends have worked with this employer, but they had no visa issues. Did anyone else? Do you want to say anything on this?
Yeah, I've seen this before. It's a scam.
Okay.
So what it is that I've had people consult me on this, and that is they get an OPT for an employer that they're not really working for. And so, but the employer says that they're working for them. And so, and they go ahead and they have their OPT, and then they can get the extension on the stamp and things of the sort. But realistically speaking, they're not working for the employer, and either I think in the worst case scenarios, they pay the employer to basically say that. So, that unfortunately is a fraud scheme that I've seen before and keeps turning up. It leads me to believe that the authorities or the State Department or USCIS or CBP have been alerted to it and are now looking for it. So when somebody gets an F1 and they get an OPT and then they say, okay, I'm working for Mary's company, being a systems analyst or a software developer, and they're not really working for a Mary's company, they may be working at the Walmart or something of the sort, but they get that letter, and then when they go to get the H1, if they're picked, or they go to get a STEM extension, and it comes out, then that's pretty bad, because then you do get charged with misrepresentation, and you lose your ability to stay in the States and or go to the States.
Okay. Thank you so much, David, for taking that up. And now I have my next question, and that is also from, this is with regard to the I-20. Got admission offer for spring, haven't filed I-20 yet. Now wanted to change my term to fall. At what point should I request for change of term before getting F1 visa, or after I get F1 visa? Or should I select defer in I-20 form to next term and submit? get confirmation from university for fall, file the new I-120 then, or submit I-120 for spring now, get visa, and then ask university to change term to fall? Which one of the options will be better?
So I need to see it. Can you make it bigger so I can read it? I can't.
Sure. This is, I think, how it goes.
Okay. So I'm going to do it myself here for a second. Sorry. Got an offer for spring, haven't filed it. Now I want to change my term to fall. It won't function to change. No, don't go to the consulate if you're not going. Should I select defer an I-20 to next term and submit? If conference or submit I-20 for spring. Well, I would advise, I mean, this is my opinion. And again, it's not, I can't give you legal advice, but if you got admission to the offer for spring, and when you say file your I-20, or you mean going to the consulate, I'm assuming. Now, if you're changing fall, don't go to the consulate with an I-20 saying you're going to spring term, because that's misrepresentation. You're telling them you're going to it and you're not. So in the I-20, when you go to submit, get confirmation for fall, fill in, yeah. I would get a proper I-20 for the session you're going to before you go to the consulate, and then apply to go for that session. I wouldn't go at all. I wouldn't play with going to, especially now. I wouldn't go to the consulate with an I-20 that has a different session than you're actually going to attend.
Okay. Thank you so much, David. I think that will be very much helpful. Thank you for that advice. And now I'll quickly take up my next question. And that is, my wife got admission in MBA in US. Should we apply F2 visa for spouse and kids along with her F1 visa application in one go? Or after she gets F1 and lands in United States, then we apply for F2 visa?
It's a very good question. I get this a bit in the sense, what strategically is probably the better way to go? I mean, either way, they're going to be looking at it in the sense of temporariness of intent, right? So if you're going to your MBA, and it depends, realistically, this is going to sound, not fair, but it isn't. It depends where you're applying from, and it depends on your monetary situation, and it depends on the circumstances surrounding yourself. Meaning, let's say you you apply from a country that the US has, their statistics show that people don't come back or they stay, and meaning you are not from a family that is wealthy or you have wealth. And in that regard, it's again, it doesn't sound good, and it kind of makes people say, well, why can't I go if somebody else goes? But the truth is, if you're applying for a visa and the consulate is convinced you will return to your home country, or you have the resources to support yourself and go to your home country, they're going to be a lot less restrictive. So to your question, if somebody's applying for an F1 and the F2 and for your spouse and children, you can all go at the same time if you are confident that you are from a certain situation that make this, again, less restrictive. If you go separately, it's no guarantee that your spouse is going to get it if you didn't all go together. I guess my point is that I don't know if it makes too much difference. I think what matters most in that circumstance is whether or not you are of a certain individual or person that the consulate is confident that everybody will come back. So in the end, if you are from a certain strata that unfairly is treated a bit differently, then you can all go together. If not, then you can go separately, but it doesn't mean that your spouse and kids are going to get the visa if you go separately. You're still going to be subject to those issues and that kind of scrutiny.
Thank you so much, David, for such a truthful opinion and help. Thank you so much. I wish I knew this participant's name, but it's anonymous post, so thank you so much for taking that up. Now, moving on, this is my next. This is, hi guys, I need your suggestions. I am admitted to UT Dallas for master's with a scholarship. However, I realized that I could have applied to UT Austin, Rice, UIUC. However, my visa is scheduled later this month. Do you guys recommend me to defer it and apply to these universities? Is it worth it? Or should I just go to UT Dallas? What do you
Yeah, I don't
suggest?
think it. I don't think it much matters, to be honest. I don't know that it matters. Somebody asked a question about, do you expect positively, negatively affecting any
Yes,
policy?
Hari Guru, let's take that up. Yes.
Okay.
Thank you.
Yeah. I don't know, to be honest with you. I don't see anything. If you are in valid status and you have the 485 is a change of status, by the way. And then you've made application to change status and you're in valid status and you're doing everything right. I don't know that it'll affect it negatively or positively. I don't think it'll affect it at all. I think it's being slow as it is, to your point. You've been there for 3 or 4 years waiting for your priority date. So I guess only negatively if they decide to slow down processing instead, which they have the ability to do. So if that's the case, then sure, that's negative. But in either event, if all things being equal and they're not looking to cause trouble to people in that situation, then I don't think I think it's a neutral answer. The only way it will affect negatively, as I said, if they decide to slow down processing as a means to limit immigration, meaning they don't have to change legislation to change processing and the law and how many people come, because they can make it more difficult within the parameters and the tools that they have already.
Okay. Thank you so much for taking that up, David. And now I have another question. This was on our YouTube channel. This was asked by Vijay Kumar. I am on my F1 visa OPT and recently got approved for H1B I-797B consular services. Since I am in US and working for employer on OPT, can my employer refile for new I-129 as change of status so that I can continue working on H1B and no need to travel for stamping? Thanks.
Yeah, they could, but I'm curious as why they didn't. To be honest, I mean, I don't know why they wouldn't. To begin with, there must have been a reason necessarily. The second is that even if you do get you change your status, you can't travel at all unless you get that visa. So once you get a 797 and you don't have a change of status, then you have to travel to the consulate that you need to go to even to travel. So it probably wouldn't be a bad idea to do it, to be honest with you. I would go and do it, especially if you get the approval and you were in the States and you went to school in the States. There's no temporary intent for an H1. So that's a good thing. So you don't have to satisfy that. So the only thing they could really refuse you under is if they think that it wasn't a real job offer, or you don't have the qualifications or things like that. But given that you went to school in the States, given that you work for the employer in the States, if it's real, then I wouldn't be afraid of the consul.
Okay. Thank you so much for taking that up for Vijay Kumar, David. And I think we'll just go on with one last question. And I think that should be, let me just see if this is the one. Or I think we've taken up all of them for now. Yes, but if you want to give a view on this. Hello, in my case, I have an F1 status to H4 status. I am in USA, but I just have the status, not a visa stamp. Would this process be the same for me? And once I upload my documents, do I need to keep studying during the processing time?
So if they've already changed their status to H4, they don't study at all because they can't. They're on H4 unless they get approval to do it. But that's what I was just talking about, in the sense that they have a visa, they have status, so they can't go anywhere. And until, I mean, you're changing status from F1 to H4, and they're asking, okay, well, can I keep studying? Do you have to keep studying? No. Are they studying? I mean, did they finish? You know what I mean? Every situation is as it is. If they are still in F1 status and they file the change of status to H4, realistically speaking, they should stay in F1 status until they get an approval to H4, right? They shouldn't. So should they? If they're supposed to keep studying, yes, keep studying. If you are done, then you've nothing to study. So you are in that status until you change your status, until you get an approval to change your status. By just filing the application to change status does not give you the new status. So you have to wait until the new status is approved before you can do whatever you want to do or not do whatever you want to do. In this case, not study. And in terms of travel, correct. They can't go anywhere. And if they do, they need a new visa.
Thank you so much, David. I mean, that was really wonderful, taking up all these questions so patiently and giving us all your point of views and expert advice, I would say. So thank you so much. And maybe we could wrap up if you want to say anything about maybe AI or these latest things that are trending right now, technology-wise or student-wise. And maybe even Akshay's last question. DHS says you can use STEM OPT twice. Please confirm.
Yeah, actually, do you want to contact me on that? Because I want to look at something. So if you want to contact me, I'm happy to answer it. Okay?
Absolutely. And so, yes, David, maybe you would want to say anything with regard to AI.
Well, it's funny. As I said, I'm dual licensed in Canada and the US, and Canada uses AI a lot in adjudication. And frankly speaking, I hate it. It's just because what happens is that if anything is out of the ordinary, it picks it up. Meaning, if you have a difficult case, and then it makes it more difficult, it goes to the officer becomes increasingly suspicious. And when the officer becomes increasingly suspicious, they're harder on the case. And AI as well is refusing a lot. Refusals have gone up, I think, by 12% using AI. So the US isn't quite there yet. It isn't really using AI per se, but it will. And I can only say that when they start using AI, refusals will rise. Because just psychologically speaking, right? If you get a case as an officer and you adjudicate it, fine, that's great. It can be a yes or no. And then when you have AI, if AI says, yeah, you should approve this case, you should approve this case, you should approve this case, you start to rely on it. But then when AI takes a case and says, well, there's something different here, you should look at it, the officer's perspective right away becomes negative, thinking, well, why didn't AI approve it immediately? And so that creates a harsher result, in my opinion, with regard to adjudication.
Thank you so much, David. Really such a great session. I wish we didn't have to wrap it up as quick, but thank you so much. And folks out there, do contact Attorney David Garson, and maybe when you do, let him know that you found him here on Immigration and Jobs Talk Show and tell him about your case, and maybe for sure he's going to be happy to help you. So his email address is david@garsonil.com, and his website is www.garsonil.com. So definitely go visit and contact David. Thank you so much, David, for doing this today.
Pleasure. Have a good day.
You too, have a good day, and I hope to see you again very soon.
Thank you. Myself as well.
Thank you. Thank you, David. And folks out there, thank you so much for joining us once again. It's really lovely that you did. And please do not forget to like, share, and definitely subscribe to our channel. It's Immigration and Jobs Talk Show. You can hit that bell icon so that, whenever we have sessions like these, you are notified. And definitely, if you resonated and if you think that your friends and folks out there can also resonate with this kind of content, don't forget to share, please. And also, my number is where you can also contact me on WhatsApp. This is my number, 408-335-6444. You can also email me. My email address is nipa@staffingly.com, and go visit www.staffingly.com to get to know more about us. Thank you so much for joining us. Y'all out there have a great day and a splendid week ahead. See you again. Stay tuned to Immigration and Jobs Talk Show. A big hello and a warm welcome to all of you to Immigration and Jobs Talk Show. I'm really happy and thrilled to have each one of you join us. I'm Nipasa Pradhan and I'm going to be your host for today's session. And we are streaming live right now on YouTube, LinkedIn, and Facebook. And before we start with our webinar today with our guest, I have this very important disclaimer, and that is by watching our videos, you agree and understand that the information provided by our experts, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, very, very thrilled today to be here with all of you to explore this topic that impacts countless lives out there and the future of our workforce. Definitely, today is election day, and we are looking ahead to ask what will US immigration look like in the next 5 years? I'm sure this is very, very exciting, overwhelming for all of us today. And with so many recent changes today, we are going to discuss and basically talk about what does America's future look like. And joining us today in an expert with decades of experience in immigration law is, for the first time, joining us here on Immigration and Jobs Talk Show, none other than Mr. Charles Cook, who is the founder and managing partner of Cook Baxter LLC, where he leads the firm's global immigration practice. So it's really very, very exciting and such an honor to have you with us here, Charles, today. Thank you for joining us.
It is a joy to be with you today. Thank you so much. What an exciting day in the United States.
It is. And I'm sure, I mean, you are a new face in our channel, but folks out there know you and they would love to know you better. So could you please tell us more about yourself?
Well, thank you. I'm actually the former national president of the American Immigration Lawyers Association, otherwise known as AILA. I'm also a founder and former president of the Alliance of Business Immigration Lawyers. I've been doing immigration law for 36 years. You can tell by how old I am and all this gray hair. I've represented more than 75,000 people in their immigration journey through all types of immigration, not just H1Bs and labor certs and Ls, but literally everything from asylum to adoptions to naturalization. I've done it all. Including lots and lots of federal court litigation. I am one of America's leading immigration lawyers in the area of litigation and bringing justice to people whose cases have been pending for a really long time. I've also done a lot of lobbying in Congress. I've testified in Congress a couple of times. And I do a lot of commentary on the Twitter machine as well as it relates to immigration. But most of all, I am the grandson of immigrants. I grew up in an immigrant household, obviously not from India. Obviously, look at me. My grandparents are from Germany. My dad's first language was German. He was born in Brooklyn. I was born just over the river in New Jersey and spent my growing up years there living in my grandparents' house. And today, as quintessential American story, I don't speak German. You're Spanish. I speak Spanish fluently. So quintessentially, I am the American experience. I mean, you look at me, I know I look like, well, he looks like an American. And in reality, I'm the grandson of immigrants, like everybody here in America is. So for me, America is a very special place. It is a place where you can truly make your dreams happen, regardless of who the president is. Just sometimes it's easier than other times.
It's really, truly an honor and a pleasure to have you here with us today, Charles. You look vibrant and radiant and so full of knowledge already. I'm super excited to have you burst out whatever you've got to say today.
I should be nervous because of the election, but oddly enough, I'm not nervous about the election. I have a feeling of confidence in a good outcome. So it's where we stand.
Definitely. So what can folks out there who have joined us expect from us today?
Well, let's talk about what immigration is going to look like. Obviously, where immigration is going depends on who the president is. Now, keep in mind, only Congress can change the law. And the law is 40,000 green cards in EB3, 40,000 EB2. That's the law. No president can change that. Presidents can change interpretations of the law, however. So, for example, a long-time interpretation of the EB1, EB2, EB3 numbers is that it includes family. So it's not 40,000 EB3s a year for 40,000 workers. It's only 18,000. because the average family size is 1.1. So the numbers are drastically reduced by counting family. That is an interpretation of the law. It can equally be interpreted to say, no, it's just people. Congress clearly didn't think that only 18,000 foreign nationals should get a job and a green card in America each year. It's a silly interpretation. But that takes a president who believes in it to get that interpretation changed. So a lot of what's going to happen in the next 5 years really depends on who's at the helm of the USS United States. And so today is the election. And although I think something like 73 million Americans have already voted early, America's very weird on elections. There's not just an election day. It's an entire season that starts 3 weeks before the election. And Trump's been campaigning since he lost the last election. So a lot will depend on what happens today. We don't know the vote total. So 73 million people have voted, but we don't have any idea how they voted. They don't release those numbers until after 7 p.m. Eastern time, which is tonight. I'm on Eastern time in the United States. They begin releasing the vote tallies from those that close. And each state controls when their polls close. Sometimes it's 7, sometimes it's 9. Sometimes judges order they stay open because there's long lines. American elections are a mess. But here's what happens. If you're elected, let's say Trump wins, he doesn't become president right away. He doesn't become president until January 20th. That's when our presidents are sworn in. So Biden would remain president really for the next almost 3 months, and then Trump would take over. Same thing with Harris. And we're not going to know tonight it's possible we know tonight, depending on where Georgia goes, where Florida goes. But unlikely we won't know until 2 o'clock in the morning, 4 o'clock in the morning, when we get poll results out of Wisconsin, Pennsylvania, and really further west out in Arizona and Nevada. So we don't know. I mean, it's just literally a toss-up. Every pollster says 50-50. One thing I will tell you this. Our law firm, we have 45 folks that work here. 40 of them can vote. 40 of them are citizens. And every one of them already voted. Every single one. That's highly unusual in the United States. And they all voted for Kamala Harris. And that should tell you something about where we think and who will be a friend to immigrants and who will not be. I see far too much on the Twitter machine from folks from India who think that somehow Donald Trump is going to be really good on immigration. And Nabasa, that's just not going to happen. The very first plank in his platform on immigration is, day one, issue an executive order that children born in the United States to parents who are not citizens themselves are not citizens, which of course is illegal because we have a constitutional amendment that says they are, but that lets you understand who he is as a person and what he believes about immigrants. Now, while Donald Trump hates immigrants so much, I don't know. He married 2 of them. Once again, immigrants doing jobs Americans won't do. Pretty funny. No. And of course, Kamala her mom's from India, right? So she is half Indian. She is the quintessential American. Dad from Jamaica, mom from India. How does that even happen? How do they even meet? So, and the thing about Kamala Harris is that she actually understands immigration law, which is crazy. Very few presidents do. But she has delved into the area. She was involved in it as a lawyer. She was involved in it as a prosecutor. And she was one of the best friends that immigrants had when she was a U.S. Senator. So she gets it. Now, unlike Biden, honestly, he's a nice guy, he's a nice old man, and he saved us from Trump. But he doesn't get immigration. He was never, ever, even when he was in the Senate, he was never good on immigration. He just wasn't. And same thing with Obama. He was never good on immigration. So we have a lot of hope for Harris. But let's talk about these policies, all right? So in the United States, there are 4 ways that you can come here legally and immigrate. You can get asylum. It's not happening right now from India, right? You can win the green card lottery, which of course India can't participate in. And you have employment/investor immigration and family immigration. Now, family immigration itself is pretty fixed, delineated by Congress. Congress has written the laws. There's not much you can do as a policy perspective on family-based immigration, except you can do what Trump did the first time, which was stop adjudicating cases. I know that because I sued him hundreds of times for not adjudicating cases. They just don't do them. They just put them in a box and don't do them. So you have to get courts to intervene. That's all they can really do. On employment-based immigration, however, there's a lot of bad things that can happen in a Trump administration and some good things that can happen in a Harris administration. So, for example, if Trump is elected president, one of the things that could easily happen on this employment-based immigration stuff is he can get rid of STEM OPT. So you're in the country, you're in a STEM field, STEM OPT gone. They are definitely going to do that. They're going to publish a regulation, STEM OPT is gone. One proposal written by Vice President Vance when he was in the Senate actually bars anyone from immigrating under EB1, extraordinary ability, or EB2, national waiver, until they have lived outside the United States for 10 years after they graduate from a U.S. college. That would be crazy. That would eliminate a lot of people, including many Nobel Prize winners, from getting green cards in the United States. They can change how the H1B lottery works. Right now, this next year is the first year of the higher fee, $215, I think. And you're gonna pick by the foreign national. So you, not your employer, but you are gonna put in for the H1B. Whereas what Trump will do will say, no. H1Bs are by bidding. It'll be like the eBay of H1B. Who will get paid? We will give H1Bs to the highest paid people. That was his proposal last time. They just didn't get it published in time. That's going to be published in February of 2025. We're going to see drastic changes to the L visa program, where they're going to make it very hard, not that Biden hasn't done a terrible job with the program anyway, but make it much harder to prove who's a manager or executive. H1B is already now more limited under the new Biden administration. They're going to crack down on what jobs require degrees. One of the things that's been happening in the United States over the last 10 years is there's been a movement away from requiring degrees for jobs that have historically required degrees. A great example is a software programmer. Why do you need a bachelor's degree to be a software programmer? You don't. Heck, look at all the people losing their jobs because AI is doing it, right? So a lot of negative things can happen in a Trump administration on employment and family-based immigration. Now, Harris, on the other hand, obviously will keep in place the program for STEM, obviously, probably expand it to a certain extent. But what she will also do is look at the H-1B program a little more critically so that it works more effectively for the United States. Because she's a prosecutor, I think they're going to go after job shops, companies that just throw in thousands of applications for visas that don't really have work for them. Or where they abuse the employee and say, we're not going to pay you. I think there's going to be a massive crackdown under the Harris administration for H-1Bs in that regard. I think we're also going to see some attempts to change some of the interpretations of how regulations work. We're also on family-based immigration. With her, the new Biden family parole program will keep going if we win the court case, which is today, by the way. And I don't think a lot of people in India realize this, Napasa, but there are a lot of undocumented Indians in the United States. Do you realize that? There are a lot. There are hundreds of thousands of Indian nationals in the United States who do not have immigration status, who came as students and overstayed, or came illegally. Hundreds of thousands. Many of them are helped by the Biden family parole program. And so I think that will definitely continue if we win the case today. Literally, the hearing is today. on whether that program is legal. I think it is legal, but we'll see. I'm not the judge. So a lot of these key immigration issues will be drastically impacted negatively if Trump wins, and not at all, or positively if Harris wins.
You're absolutely right. I mean, if Trump or, they have similar stances like what you have just said, and on immigration, everything is going to be heightened with a lot more scrutiny and stricter enforcement. I think it's going to be even more hard with regard to immigration, for sure. But thank you so much. I mean, those were great insights. I mean, so much in the first 15 minutes already, so much processing and so much happening, I'm sure.
There's so much going on. Now, one of the questions you gave me was on, what is going to happen today? All right. So I don't know. I mean, I'm not a prophet, but I will tell you
discuss on the questions, but I think I'll just quickly say hi to our folks who already have questions, and you might see some of the comments popping up there. Right. So big hello to Anjali and Luan Dial, Luca. I think we should pick up a few before we go
that's
on
great.
with our questions.
Vinny's got a great question here. How might the election outcome impact the likelihood of establishing a path for undocumented immigrants? Well, I think you hit the nail on the head. If Trump is president of the United States,
Anjali, we're taking your question.
There is 0% chance that there will be anything to help undocumented immigrants. 0%. In fact, there will be a crackdown, as he has promised, to deport 11 million people. Now, that is a great way to destroy an economy. That's how it works. You want to destroy an economy? I don't know if you know this or not, but we've done this before. This wouldn't be the first time. We did this in 1957 and 1958 and 1959, 1960 on something called Operation Wetback, which today is, of course, a slur. Back then, we deported over 1 million Mexicans who had come to the U.S. during World War II to work in our fields and work in our factories while we sent men abroad to fight. Eisenhower created this, and we deported over 1 million Mexican men and 500,000 U.S. citizens. So it's not like the U.S. is fully capable of doing stupid things, which then led to a recession, because that's what will happen. So, yeah, there's nothing coming from this. Now, Harris, on the other hand, has said repeatedly she voted for bills that were pro-reform when she was a senator. She will advocate for them. And think about this. This is actually really important to understand. Biden was always walking a tightrope on immigration because he wanted to run for re-election, and he knew he was running against Trump, who was anti-immigrant. If Harris wins, there's a whole new dynamic. Trump's not running again because he's probably going to be in prison. So he's not going to, maybe not. Maybe she'll pardon him, but he's not running again. So, and I believe that as Trump is defeated, so will we defeat this anti-immigration rhetoric. So it puts her in a much better position to work with Congress on not just passing this border bill on asylum that she says she'll pass. By the way, that bill would never pass again unless you add in some sort of legalization and take away the per country limit. Increase, and it's not just, hey, taking away the country. I mean, I've been an advocate for hey, the limit's the limit, and that's it. And people have really ragged on me about that. Because if you're going to take the women away for employment, you got to take it away for family. But that doesn't solve the problem. Right. Because all that does is share the pain, right? And now,
it's not proportionate.
And now that ROW is terrible too. You have to increase numbers. If I've got a lot of clients who applied for their green card in 2012, 2013, 2014 from India, and they're not getting a green card for another 10 years, 15 years. Even if we reduce the number, even if we said, okay, Indians can get them all, it's still 20 years. And then that cuts the rest of the world off, which makes no economic sense to anybody. So there's a really good thing that would come from a Trump defeat, is that would be a defeat for anti-immigration forces. That would relegate them back to the ash heap of history and would embolden the president, I would hope, to work with Congress and look, let's fix this problem once and for all. We can do that. So there you go.
Thank you so much for taking that up for Anjali. Very passionately answered, I would say. Thank you, Charles. Well, let's go on. We have a lot of comments on LinkedIn as well. So let's take this Luan Dial, if I'm pronouncing it right. Do we pay for visa or trips when we get jobs in USA?
Well,
Okay.
that's a great question. And the answer is no, you should not be paying for the visa. So let's say, I'm going to assume you're talking about the H1B visa. So the H1B visa, the employer is required to pay for that, the lawyer fees and the filing fees. You also should not be paying an employer for the job. That if immigration knew about that, they would deny the visa. I can assure you. I know people do it, but it's and I can't tell you it's illegal. I can tell you that immigration thinks it's fraudulent. But the trips, the airplane fares, that's on you unless you've got a really good employer. I mean, that's been my experience. You got to differentiate out the visa fees, the lawyer fees, and then travel expenses are different things.
Thank you. Thank you for taking that up for Luan Dial. Thank you for your question. Now let's take up Luca. This is on, today. Trump's advisors are already preparing massive cuts to legal immigration as soon as he enters office. That's what we were discussing. And everything from families and refugees to skilled workers is threatened. Economic insanity. What do you have to say about this comment?
What do I have to say about that is 100% accurate. Keep in mind, on refugees, there were essentially no refugees that came in 2019 and 2020. None. And keep in mind, that was when there was massive refugee crises abroad. Remember Syria? People forget about Syria. Germany took in 1 million Syrians. Not us. Not the Great White Hope. Not the Statue of Liberty. Not under Trump. So, yeah, it's America will revert to a 1924 close the borders, shut the system down kind of country, and we will enter a massive recession, the likes of which we probably have not seen since 1929. That's a reality. And then tariffs on top of that, which of course are taxes on U.S. citizens. So there you go.
It's crazy what can happen today. But what do you think? Let's take on when can we expect the election results to be out?
That's a great question. So in some states, so America has 4 time zones. I don't know how many time zones India has, but America has 4. How many time zones does India have, Napasa?
One.
You have one? You have one time
Yes,
zone?
just one only.
That's crazy. It's a huge country.
It is, but we are under one time zone.
We have 4. So we have East Coast, Central, Mountain, and Pacific. What that means is, and about 70% of the population lives on the time zone Eastern, on the Eastern time zone, up and down the Eastern seaboard. Those polls, no election announcements are after the first polls close. The first polls close at 7 p.m. in some states. Some close at 8, some close at 9. Some states like Florida and Georgia count during the day, and then you will get initial results, especially on early votes, right at 7 o'clock. And but you won't get final results for Florida and Georgia until 8 or 10 o'clock at night, maybe midnight. States like Pennsylvania will give you initial results for maybe 20% of the votes at 7, but you won't get final results till 2 o'clock in the morning. Some states, we already know who won, like New York. Harris is going to win New York. All right, she just is, because that's just the way it is. I mean, it's most of the states in the Northeast are going to go for the Harris. So these swing states are what matter. So I have a home in Tennessee. Tennessee is red. It's as red as red as red as red. Trump wins it. So, and then you move every hour more in the night, you get the next set of polls. So this, if you've never watched an American election result, go online to one of these news sites like CNN and watch their video, because it's just fascinating. By the time California, and I will tell you, Western time zones, the last time zone, Pacific, we call it Pacific time, California, Washington, and Oregon, Hawaii, Alaska probably go Trump, but they don't have a lot of power. Hawaii will definitely go Harris. California Harris, Washington Harris, Oregon Harris. Then there's Arizona, which is the only other state in the Pacific time zone. They're a toss-up state, but the election may well be decided by the time their polls close, which are at 11 o'clock Eastern time. I will likely be in bed because I like waking up at 2 in the morning and seeing what the results are or what they aren't. I will tell you this. In 2016, Florida reported at 9 o'clock that Hillary lost. I went to bed because I knew the election was over at that point. She was the first Democrat to lose Florida. If she lost Florida, she lost the election. Now, that's a different thing today. Now we know Florida is going to go Trump. We know that. So we don't really care about Florida's result. It's Georgia, Pennsylvania, and Michigan all in the Eastern time zone. And then Wisconsin in the Central time zone. And if or North Carolina as well. If she wins 3 of those states, she's won. It's over. It's just over. And then the rest is just gravy. So that's kind of what to look out for.
Great, but still, again, so that's what we are expecting, folks out there. And I know how exciting this is and overwhelming at the same time. But I hope you're all vigilant and doing the right thing and practicing your right. Well, we have Bikram's question now. This is also on LinkedIn. We should take this up. But Charles, who is better precedent for tax cut for green card holder and citizens?
Well, if you're a billionaire, Trump. But if you're not a billionaire, not Trump. It's Harris, because Harris is not going to tax anybody. Taxes are going to go down for anybody under $400,000. Now, I know that sounds like a lot of money, and it is a lot of money. I get it. But in the United States, there are millions and millions and millions of people making more than $400,000, and billionaires that are paying essentially no tax. So she's going to go after very, very rich people. If you're, the average, ordinary American green card holder, citizen, Harris is your best friend on tax cuts, because Trump only wants to cuts for the rich people. And that's you can Google it. It's a proven fact that the people that benefited from his tax cut were, in fact, people that were billionaires. I will tell you this, something that a lot of people don't realize, Napasa. If you're a green card holder in the United States and you die here, basically all of your assets are taxed at 50%. Whereas if you're a citizen, there's a $4 or $5 million exception. So if you're a green card holder and I don't really want to get a citizen, and you've got assets, you're a fool not to naturalize, because your relatives that you leave behind are going to be paying a lot of taxes. Just FYI.
Thank you for that very important information, Charles. I think that's a very important point you pointed out to be kept in mind. I think we should take up some of our questions now, Charles. Yeah? So let's go with mine. How might the election outcome directly impact key immigration policies such as family-based and employment-based visas?
We talked about that. I talked about that for the first 10 minutes. I mean, the reality is there's going to be impacts either way. But Trump, they're going to be mostly negative, and with Harris, they're going to be mostly positive.
Right. Well, and now let's take up another question. Let's take up Vikas's question.
I love Vikas's question. This is a great question. Great question.
Right. Indian Americans have historically favored the Democrats, but there has been an incremental shift in the community's voting behavior in favor of the Republican Party this election. Do you agree? And what, according to you, is making this change, Charles?
Well, this is 100% true. We've seen a lot of Indian Americans that favor Republicans. And that's because Indian Americans are very entrepreneurial. They are the wealthiest immigrants in the United States by far and away, wealthier on average than many native-born Americans. And that's just reality. And when you have wealth, you tend to go towards the Republican Party. Because historically Republicans have taken care of wealthy people, and Democrats have historically, and I'm talking since about the 1960s, not before. Before 1960s, it was reversed. The parties kind of switched positions, and Democrats will kind of focus on the poor, the disadvantaged, and help people, which means taxes. You got to take money to pay for that, and so we've definitely seen that, which is with Trump kind of an irony, because he clearly does not like immigrants. It's just clear he doesn't like them. And so it just, the irony doesn't escape me, but it's absolutely true, especially over the last decade or so. And I would think that if Republicans had nominated a normal Republican who actually believed in Republican policies, because in many respects, Trump's not a Republican. He was a Democrat most of his life. Did you know he gave Kamala Harris $2,500 when she was running for Attorney General like 15 years ago? Yeah, he was a Democrat for most of his life. So he's not really a Republican. But the reality is Republicans tend to be more favorable towards businesses, and that's why.
Well, thank you. Thank you so much for taking that up. And Vikas, such a lovely question. Thank you for participating. You can keep commenting if you have any further questions. Let's get back to Luan Dial. She's back with another question. I applied for a job in USA, New York, and they told me that I must pay for work permit. Is that legal?
No, that is quite illegal. And in fact, if you really want to burn it, make a complaint to Wage and Hour. Go online to the Department of Labor, Wage and Hour, H1B complaints. Just Google that and file a complaint against this employer so they stop doing this.
There you go. There is a permanent solution to that. Thank you, Charles.
I like this question. Go to this question from 1233. It's a great question.
Let's take this one.
It's a great question.
Anonymous, I wish we knew the name, but yes, we have seen a lot of reduction of tech jobs, which was caused by mass layoffs in the last 2 years. Which candidate could be the one trying to get back those jobs and stabilize the job market again?
Well, you have to ask yourself, this is a great question. Why were there layoffs? Were there layoffs because the economy reduced? No, the economy is growing like crazy. We're at 3%, worldwide envy for the growth of our economy. The problem you have with a lot of these tech jobs is they can be done by AI. This is a problem. This is a big problem for tech. I don't think either president is going to say, you can't use tech to do this work. Let's use Elon Musk as an example. Elon Musk buys Twitter and eliminates, 80% of the people working there? Now, initially, that meant the platform was garbage, but now it works again. What do you think the lesson learned from big tech was? You don't need all these people. And I'm going to tell you, tech jobs in the United States are not necessarily the future. First of all, you're not going to be able to get within about 10 years, H1Bs won't be available to many tech jobs. They just won't be, because we won't be able to prove that you need a degree to do the job. So the reality is, I don't think either president is going to do anything to stabilize the tech market, because both presidents, to me, seem all in on technological advancement. Maybe the better question is, how are they going to help people who are displaced by modernization, mechanization, and AI? That's the better question. And the only party thinking about that is Harris and the Democrats. Republicans are like, well, go shovel poop at the chicken house. That's what they think. Go find a job somewhere. Whereas the Democrats are planning for that with retraining and rehiring and things like that. So Democrats, I think, your only option in that respect. Now, keep in mind, I'm a lifelong Republican. I've got a picture of Ronald Reagan hanging on my wall over here. But the reality is, the party of Ronald Reagan is dead. It's gone. That's the reality.
But too much of everything is scary. Look at technology advancement; it's scaring us now.
Well, I could be talking. In a year, I could be talking to AI for this interview, an AI video, right?
Yeah, they would need me.
You can.
Who knows? You would have an AI version of yourself doing your job online.
Yeah, you could just put me as an avatar, and they're talking to me, and they're talking about that. There's no doubt that that's the future. If we can build enough power plants, we have to build more power plants, so that's going to happen. But the reality is, what does that mean for human beings? Does it mean that we're all going to be online playing video games all day long? Or does it move us to the next level? Hopefully it moves us to the next level. I'm a big Star Trek fan, so I believe in the future. These things make us better. So there you go.
Definitely. Thank you, thank you. And Lawan Dial is back with saying, thanks, Charles.
You're
Then
welcome.
we have another question. Do we have to pay for anything when you meet all the requirements for the job after the interview?
No, you don't pay for anything other than your plane ticket. No.
I think she's making her budget, but definitely thank you for your question.
Wanda, don't be deceived by this. The internet in the job market is full of scammers. It's full of scammers. And you know, sometimes you just hire a lawyer, have a consult with a lawyer who's got a good reputation, so you can get an answer if something's real or not. That is not real. That is a scam. Don't do it.
Now let's take up Shubham's question. There are two parts to this. Could the judiciary overturn immigration reforms passed after the 2024 election, potentially influencing policy implementation and enforcement?
Well, the courts do not overturn statutes in immigration law. There's actually, I'm actually a law professor in my free time. I've been teaching for 25 years at Emory Law School. And the courts have a doctrine called the plenary power doctrine. What that means is that when Congress legislates on immigration, that's it. That's the final word. The courts will never overturn an immigration statute. What they will overturn are executive branch or presidential policies and regulations. And we have a very conservative Supreme Court that is not necessarily friendly to immigrants, but generally speaking, they have not been super hands-on on immigration policy. For example, DACA is a great question. I mean, they could have ended DACA years ago and they didn't because, they realized this is going to hurt people. So could they overturn it? Yeah. I mean, they let a Muslim ban stand, right? The Muslim ban stood. So I would not suspect there's going to be a lot of overturning. And there's been a couple of recent cases out of our Supreme Court that limit different parties' ability to actually sue, whether they have what's called standing, whether they're actually allowed to sue, and then what jurisdiction the courts have over those cases. So there's a lot in play there, but I don't see them invalidating any congressional reforms. I do see them playing a hand in permitting some regulatory policy changes.
And he was continuing to say that the federal courts, including the Supreme Court, have the power to review and invalidate reforms deemed unconstitutional or non-compliant with existing laws.
Well, yeah, they clearly have that power in certain circumstances. There's actually an immigration statute that limits the power of the courts. Our courts, what's called jurisdiction, is defined by Congress. It's not defined by the Constitution, except as it relates to constitutional matters. And immigration issues are rarely, very rarely, constitutional, except when it comes to things like immigration detention and some deportation contexts.
Right. Thank you so much, Charles, for taking up all these questions. And thank you, folks out there, for participating. Keep commenting. We're really happy to have you participate. And maybe, Charles, you could tell us more, since we were talking about DACA. What could the election outcome mean for DACA recipients and other undocumented individuals who are in the U.S. currently?
DACA, if Trump wins, DACA's gone. It's gone. It's history. It's over. He will end it with a regulatory publication in February. It's gone. If Harris wins, it's still kind of hanging in the ether sphere. It's still kind of, and there are something like 50,000 DACA recipients who are Indians, from India. So it's not, this doesn't just affect Mexicans. There's a substantial number of Indian nationals who have DACA. Right now, DACA exists for people that received it before September 2017. Biden republished DACA and allowed new applications between January and May of 2021, but then a court stopped it. And that case has been ongoing now for 3.5 years. And there was oral argument in the Court of Appeals of the Fifth Circuit last month on DACA. That court will likely find that DACA is illegal, but will allow DACA recipients to keep renewing. And then it will go to the Supreme Court, and we will get a decision probably sometime in late 2026 or early 2027 from the Supreme Court if Harris wins. The hope, of course, if Harris wins, Congress just says, look, if you've got DACA, first of all, the youngest DACA recipient today is 22 years old. 22. The oldest DACA recipient is 42. These are not children anymore. These are adults, many with families, many with kids, and it's just time. They're not going anywhere. This is their home. Fix the problem. The refusal to fix this is not just frustrating, but it's immoral. This is a morality issue at this point. When people have spent essentially their entire lives in the United States, deportation becomes banishment. It becomes maybe an unconstitutional punishment for them. And, an argument we can go into in the future.
And I mean, there's so many families who are breaking apart just for this reason, and it's so sad to see.
So I had 2 consults this morning for 2 people who had criminal convictions, unfortunately, both long-term, one from Vietnam, one from Mexico, long-term residents of the United States. They got addicted to drugs. They made some bad choices. They're gone the rest of their lives. They're never coming back ever. Our immigration laws are mean. I don't know if you've ever seen the play Les Miserables. Les Mis. I don't know if you've ever seen that play.
Yes.
It's a great story. And
I think it's Jackman, and it was like a musical, right?
The story of Jean Valjean, who represents mercy, and Valjean, and then Javert, who represents justice. Our immigration laws were written by Javert. They're all about justice. There's no mercy in our immigration laws, and that's what makes them so terrible.
We have Shubham back again. He has another question saying, thanks for taking my question. I would also like to know, how will the outcome of the 2024 US presidential election impact the future of immigration courts and the processing of asylum claims?
Well, there's a lot of Indians that come to the United States in the last couple of years seeking asylum. Honestly, I don't know where they're seeking asylum from. I don't know. Good question. I don't want to be in a pro-growth country. I don't know. Something. But our asylum system is completely broken. We have two different asylum systems. We have a defensive asylum system in immigration court, and then we have an affirmative system with the Immigration Service. There are over 1.6 million asylum cases in the affirmative part of the process. There's only 300 officers. 10 years. If you file today, 10 years before you get an interview. If you're in immigration court, there are over 3.5 million cases in immigration court. We have 675 judges. So if Trump comes in, they're going to want to hire judges. But here's your question. Who wants to be an immigration judge? What kind of person do you have to be that would enjoy the job that requires deporting people? You have to be a lawyer for 5 years. I'm not sure there are enough lawyers willing to sell their soul to do that 24/7. That's just awful. Harris wins. The reality is they will find more positive judges who will want to grant asylum and work these cases more efficiently. But we're never going to be able to deport our way out of this problem. And of course, if Trump really does win and want to deport people, you just can't pick people up you can't pick them up on the streets and deport them. If they've never been in proceedings before, you actually have to put them in front of a judge. And now you have 3 million people in front of you. That's why I said the system is entirely, completely, and utterly broken. There you go. All right. Any more questions?
I think we'll quickly go for a short break and be right back. And by then, we'll take up a few more questions, Charles, if that's fine. Welcome back,
Hey,
everyone, to Immigration and Jobs Talk Show. I'm Napasa Pradhan, and this is the second half of this webinar we are having today on Election Day. What will U.S. immigration look like in the next 5 years? And we have with us none other than the very, very amazing guest for today. We have none other than Charles Cook. Thank you so much for this very insightful webinar so far, Charles.
my pleasure. It's great to be with you today. I love talking immigration.
Absolutely. And so are our, viewers out there. They have such amazing questions. It's really lovely having your questions and have you participate with us. Thank you. So, Charles, I think, yes, we have Luandi thanking you. Thanks for the eye opener, Charles. Thank you. Well, I think I would have this next question. If you can tell us, how might enforcement priorities at agencies like ICE and USCIS shift depending on who is elected?
Well, for USCIS, it's really important to understand that Trump has promised through the individuals in his campaign who have immigration background and will work in the agency that every application will have to go through a fraud review and supervisory review before approval. That's not currently happening. That will slow things down to a crawl and will result in a lot of false claims of fraud by the Immigration Service because they are notoriously bad at identifying fraud. So it's going to be very, very slow at USCIS if Trump wins. I don't expect any changes if Harris wins, other than hopefully getting better management. Immigration, the USCIS is so terribly managed right now. They basically promote from within, so they don't really have people that have outside business type of experience, how to run a large organization. And as a result, they're really bad at their job. ICE, on the other hand, as for the last 4 years, they've kind of just been all been twiddling their thumbs like this, waiting for the chance to deport people. So ICE, which we call ICE, will be very proactive in looking and searching out people with removal orders and working with local police as they arrest immigrants for various crimes or driving violations and put them in removal proceedings. It's going to be big changes for both agencies.
I would also like to know, what impact could this election results have on the backlogs? I think that's what most of us are concerned about. And also the visa bulletin and family-sponsored visa categories.
Well, of course, the visa bulletin is constrained by the law. Only Congress can fix the visa bulletin; it can't be fixed by anybody else. So, you could, as I mentioned earlier, the administration could reinterpret who is included in the 40,000 in each of the EB3 category, EB1 categories to only include actual workers. They could do that. I'm not sure they will, but they certainly can do that. We tried to get Biden to do it, and he wouldn't bite. But I don't think he had the right people on the bus. I think we might have better. I know the person currently advising Harris on immigration. He's fantastic, and I think we've got an in on getting that interpretation done. But as far as the other aspects of immigration, Trump's going to make it worse. The backlog you have today will be much worse under Trump. And Harris, keep in mind, Indian nationals have a friend in the White House, right? How does it get better than that to have someone with an Indian mom in the White House? It doesn't get any better than that. And she loved her mom. So I think there's going to be a movement, and I think we will see aggressive movement by the White House to kind of cut back on that backlog and increase legal numbers. But ultimately, it's Congress that controls it, not the president.
Definitely, but America being land of immigrants, I think we are so much excited to know what changes will happen in the immigration front, and I'm sure that's going to be a lot.
Rich guy. All I can tell you is what should happen, not that it will happen. I've been fighting for immigration reform since the last time Congress destroyed our immigration area in 1996. So it's almost 30 years that I've been going to Congress every year, lobbying them, talking to senators. The thing is, most of them know what they have to do. They're afraid of losing an election if they help immigrants. And that's why defeating Trump is so important, because it will allow us to throw that anti-immigration rhetoric out the door, out the trash can, and embolden some Republicans to say, I love immigrants, like George Bush always did. I want to fix this. So that's what will happen.
Thank you. We really need some solutions for so many of these loopholes to be covered and be fixed as soon as possible. But definitely talking about those, I mean, the visa bulletin, the dates changing, I don't know when will that happen. But yes, we have some comments. Let's take up Dheeraj from LinkedIn. He's asking, will there be any effect on H1B holders after the elections?
Not after the election, but if Trump wins after he takes office in January, you will see rapid changes to how immigration works. I would suspect they will immediately republish their rules, which I was one of the lawyers that beat back the rule on prevailing wages. And they will publish right away, probably with immediate effect for the March lottery, the H1Bs based on job income, so that people with the highest salaries will get H1Bs. I think that will be an immediate thing in February and March of 2025 if Trump wins. If Harris wins, you won't see any changes. None at all.
Thank you, Dheeraj, for your question, and thank you, Charles. It's been lovely having you. I wish we didn't have to wrap up so early, but I think this is it. And thank you so much for joining us today. But before we leave today's discussion, if you could leave all of us, especially our viewers, with an end note, it would be great.
All I can tell you is this: America is a great country. It's a great place to live. It is an land of opportunity for immigrants. One of the things I've dedicated my career to doing is helping immigrants achieve that American dream. You know, not everybody can come legally. Not everybody has that opportunity. Not everybody's got a degree. Not everybody's got a relative here. Some people come seeking refuge, and that's okay too. America's got room. We have room to grow. We have room to be. The only thing we have to worry about in America is if people stop coming here. People stop coming here, we do have massive problems. But until then, until we talk again, good luck. Pray for America tonight. Pray for a Harris win, and we'll move forward.
Thank you. Thank you so much, Charles. It was really lovely having you. I'm really looking forward to having you back as soon as possible for such passionate discussions on immigration. Lovely having you. Have a great day ahead and enjoy your day ahead.
Thank you. Bye-bye.
Bye-bye. Thank you, folks. Thank you so much for joining us here on Immigration and Jobs Talk Show on today's discussion on Election Day. So who is going to win and what is the next 5 years going to look like on the immigration front for the US? Well, I think we'll just have to stay tuned, and you have to stay tuned on Immigration and Jobs Talk Show because we are coming up with a lot more updates on today, Election Day. Thank you so much for joining us. This is Nipasa Pradhan saying bye for now.
Hi everyone, welcome to Migration and Jobs Talk Show. I'm Rajni Bharara, your host, and before I move ahead, let me very quickly read out this very important disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. All right, after this very important disclaimer, welcome back everyone to Immigration and Jobs Talk Show. I'm your host Rajni Bharara, and today we are diving into a timely and relevant topic, especially as we are on the cusp of a pivotal US presidential election. The upcoming election could dramatically reshape US immigration policies, making it more crucial than ever for startup founders, entrepreneurs, and tech innovators to understand their visa options. For many, the H1B has been the traditional route, but as we know, that path can be limited. So today we are exploring alternatives and uncovering solutions that might be better suited for startup founders looking to build their vision here in the United States. I'm thrilled to introduce our guest, Alyssa Hussain, who brings a wealth of expertise and insight to our discussion. Alyssa is a business and employment-based immigration attorney who represents companies and individuals seeking temporary or permanent legal status in the US through employment, trade, or investment. Her background is impressive. She has experience working with multinational technology companies, growing firms, and innovative startups. Alyssa's approach is all about strategizing with clients, guiding them through each stage. See, I'm so excited to introduce you that I've started fumbling. So I'm really sorry about that. So Alyssa's approach is all about strategizing with clients, guiding them through each stage of their immigration journey with dedication and passion. She earned her honors Bachelor's of Arts from the University of Toronto, majoring in gender studies, political science, and history, and holds Juris Doctor degrees from both the University of Windsor's Faculty of Law and Detroit Mercy School of Law. Licensed in Michigan and Ontario, Alyssa has handled complex immigration cases across Canada, the US, the Middle East, and Asia. Her work has spanned roles on the US immigration team at Deloitte with boutique firms specializing in startups, and now she's leading her own practice focusing on TNs, H1Bs, O1s, EB1s, and NIWs, which is national interest waivers. So without any further ado, let me not fumble anymore and welcome Alyssa Hussain on Immigration and Jobs Talk Show. So Alyssa, very warm welcome to Immigration and Jobs Talk Show. This is your first time. How are you feeling?
I'm feeling good. Thank you for the very warm welcome. I'm excited to be here and excited to kind of share as much knowledge as I can.
Right. And, Alyssa, this topic is pretty unique and a little different than what we usually do. So what do you think? What would you like to say? What can people expect from today's episode?
Yeah, I think there's, a common perception that in order to work in the U.S., to gain permanent residence in the U.S., that you need to have an employer who's willing to hire you and sponsor you. And the purpose of today's presentation is to focus on kind of taking control of your own immigration journey, and especially for those who want to be entrepreneurs and run their own companies, and also take control of their immigration journey into their own hands instead of being tied to employers, which for many immigrants, especially born in certain countries, including India, those wait times, those dependence on your employer can be very challenging in terms of making life decisions. And so, yeah, I hope that this information is helpful in the sense of being able to recognize that there are other alternatives available, and kind of taking control of your own immigration journey.
Right. So, being an entrepreneur in your own country is so difficult, because being an entrepreneur and starting your own startup, it's a difficult path than usually opting for a job, because that's the most conventional way, right? And this is a little different than what usually people do. But if then trying to make it in a different country, in a foreign land, it must be so much more difficult than the normal path, right? So, what kind of cases have you handled? Let me just start with that. And how difficult is it for people to actually make it into a foreign land and build a successful business or a startup?
Yeah. I actually think that, I'm obviously biased, but I think that my foreign founder clients are, because they have so much more to navigate in terms of not only are they starting a company in the US, which is already challenging to begin with, they are, the odds are set against them in having to additionally handle US immigration, which has a further impact, right? When you're dealing with, fundraising and talking to potential investors, you also need to be able to explain to them that you're not an additional risk, when they're doing their due diligence. So if anything, I think that foreign founders are the most equipped to handle, growing successful businesses in the US, because they're just already faced with so much adversity in additionally having to navigate the U.S. immigration side of things. In terms of the types of clientele I work with, it really ranges. I have people in tech. I have clients who have started retail companies. It really is so industry wide. It ultimately, which I think really allows for a lot of opportunity, and really is focused on people's plans and career goals and what their long-term plans are. So I think that in some way it is, U.S. immigration is very limiting, but on the other side of things, I actually think that it is also, there's like, the world is your oyster in terms of what you want to pursue and how you want to pursue it. I think top advice I give to all my clients is, as soon as you want to start your own company, I would say try and understand the U.S. immigration side of things simultaneously while you're kind of thinking of your long-term strategies for your company, for yourself, and your long-term plans, because there is a way to align those. You just need to think strategically about it sooner than later.
Right, right. I mean, that's a great advice. But also, is it easy for a particular startups or a particular type of companies to make it, and in comparison to other kind of businesses, like maybe like you mentioned, tech companies? Is it easy for them in comparison to the ones who are maybe getting into a restaurant business, or
Yeah.
different businesses basically?
Yeah, I would say, there's no one route that's easier than the other. It, again, is very case specific. But in terms of for professionals, those who are kind of pursuing a tech company for the most part, there is an easier sell in the sense of it's less of an investment, right? You don't need to make as much purchases in physical premises, in inventory. So in terms of like the cost perspective that you would need to demonstrate to the US government that this is a real and operating company and that it will be, you need to show that you have put enough into it to demonstrate that it'll get there. And that's harder on the more brick and mortar side of things. But that doesn't mean it's not impossible. There's other routes. E2 visas are generally more recommended for restaurants and for more of the brick and mortar companies versus like an O1, but that doesn't mean it's not doable. It's just more challenging, but yeah, I think that answers your question.
Right. It does. Thank you so much for getting into it and answering the question. Now let me quickly, get into my questions that I've prepared for you. So my very first question to you is, so what key trends do you see in US startup visa programs compared to those offered by other countries?
Yeah. So I obviously focus on U.S. immigration, and most of my clientele are startups. I'm also licensed in Canada and am involved in some Canadian cases as well. I think the current climate of immigration, at least for the past 6 months, probably because of upcoming elections, because of economic, in terms of economies kind of struggling right now, there seems to be a tightening of immigration, at least, when it comes to the US, when it comes to Canada. But that doesn't mean that, you can time the system and necessarily wait it out, because I think there's no way to really kind of figure out when is the best time to pursue US immigration, and even international immigration for that matter, when it comes to investments, because, when you start your own company, everything's not going to align at once. I think it's really about paying attention to your company, what your goals are, and then using that to inform your decision about strategizing on the immigration front of things. So in terms of key trends, within the US, there's been, I think people are fearful of what's going to happen with the new administration and how matters are going to be adjudicated. And so there's been an influx in filing of cases. And so with that means that there have been more requests for more evidence. In terms of denial rates, I think I haven't in my own practice seen an increase. It still seems very, standard, based off of what I've seen. But again, that's my sample size. But I do see immigration on the Canadian side of things where there are changes constantly happening, and it does seem like they are limiting immigration because there was in the past few years there's been an influx, and so they're trying to limit that. They also have an upcoming election as well, so these are considerations in terms of kind of how these programs are adjudicated or available. But on the US side of things, these programs don't really close down, right? Like the legal framework of temporary work visas and the green card routes are like have been available since the 90s. What changes is USCIS's guidance on how they're adjudicated, the reality of how they're adjudicated, and the types of evidence that can be used. So, particularly, I mean, we'll dive into this later in the section too, but in terms of for startups, USCIS has kind of broadened what, H1B founders and O1 founders can do to demonstrate that they meet the requirements so that they can sponsor themselves as a beneficiary through a company that they own. And their framework has allowed for this. However, that can change because of the political landscape or because of a change in administration. So these trends are, I think, always moving, but for the most part on the US immigration side of things have stayed fairly consistent. It's just how we need to document the eligibility that kind of has changed.
Right. So, but do you think, have you noticed that maybe the recent US policy changes has influenced, the attractiveness of the startup visa for international founders?
I don't know if it's just an increase also of people starting their own companies. I think there was some statistic, and I don't quote me on who published it or where it was from, but I think it was post-pandemic where people really did start to take control of their own, just like their own employment overall, and did start to pursue, entrepreneurship. And I think that with that also means that immigrants are part of that conversation. And as there is, an increase in investment, the US obviously wants that investment to be inside the US. And so as they kind of open up these programs, and guidance on how they define the eligibility criteria, I think that has allowed for more startups to kind of pursue these routes with a little less challenge than they were met with before, because there was less clarity in the law. But that doesn't mean it wasn't happening. I think that USCIS has kind of moved with how the adjudications were going and provided clarity on this is permissible, to kind of make it more clear to founders that it is doable and that they likely will, so long as they meet the requirements and can demonstrate such that they will approve those applications.
Right. But then, also I would like to know, Alyssa, that do you think that there are specific sectors? I asked this question, but still I would like to know that. Do you think there are specific sectors like maybe tech, biotech, where other countries are outspacing the US and attracting founders through their visa program? Because we recently had an attorney from Portugal, and we spoke with her regarding golden visa, and then we also have golden visa in I guess Dubey, right?
Dubey,
so yeah. So do you think that is also happening?
I think that the US market is very unique. There's always, everyone's going to always want to enter the US market, even if these other countries are available. I think that for periods of time, the availability in these other countries may be, based off of people's life situations and their choices, that those may be options that they choose over going to the US. But I think that, it's one of America's, everyone just, not everyone, but there is always going to be this market of wanting to grow your company in the United States, to be able to kind of grow to that next level. So I say that to say that even while international countries are kind of opening up in their investment visas and even in their nomadic visas for freelancers, as we've seen an increase in, especially since the pandemic, as people are moving abroad and wanting to live internationally and work remotely. I think that there is and will continue to be a US market for startups. And I don't know if the opening of those programs has necessarily impacted the U.S. immigration side of things. But that's, again, just my opinion, right? Like that, yeah.
No, of course. I mean, people can choose whatever countries, but they're always attracted to US. That's absolutely true. And
Yeah.
but then, could you provide like an example of a particular country that you feel that you must have noticed, notable success with startup visa program that you would want US to learn from?
That's a good question. I actually think that I'm not too well versed in the other programs, but it seems like for the most part, if you have sufficient funds, you can, they're kind of framed in that way that if you have sufficient funds, you're going to put that money at risk and purchase either a property or a business in these respective countries that is leading to a side of permanent residence or just residents in general. In those countries. And I think that there's also been some pushback from what I understand, again, not licensed abroad. But I think that the EU overall has been kind of looking into these programs specifically because there's some countries like Portugal that have opened up investment because of the nature of their economy and wanting to increase more international movement into their country. But then the rest of the EU isn't so open to those, everyone having access to those open borders. So I think that in some ways it's been working, but I feel like they're also kind of narrowing it down now in a way that is a little limiting. Whereas the US has just been fairly consistent. And if anything has made it a little bit more difficult, right? I don't handle too many EB5s, but obviously like that pathway to an investment green card essentially is a very high threshold. It requires a large investment financially. But for the most part, most of the clientele that I'm dealing with are eligible for other work visas and even green card routes that don't require a huge financial investment. Those who can do it and generally and are eligible and have the funds available to do a 1.5 million plus investment, they will, right? That's the route that they're going to take. But I think that there are opportunities in the US based off of the current current work visas and green card routes that allow for little to no investment, but still a clear trajectory and plan of what that company and investment will be in the US, which is in some way an opportunity, but it is also very limiting because you need to meet certain eligibility criteria, right? Like for an O1 visa, it's great, but only if you can show that you're of what the USCIS defines as extraordinary ability. And sometimes that doesn't make sense in certain industries, right? Someone who is maybe pursuing retail or is pursuing a restaurant business may not have these particular awards and have earned this, a certain salary or have scholarly articles. Like it's very academic focused in terms of how it's been framed. So I think for those in tech or who come from a professional background, it does seem easier and that there are more routes available. Purely investment routes do require a little bit more of a financial commitment to have that opportunity in the US as well. But I do think, right, that if the US kind of lowers that requirement of what kind of investment is needed, it will open opportunity for more investment into the US. I just don't know if they're going to be open to that.
Okay. I would also like to tell you, thank you so much for answering the question. A lot of people have also joined us and they are constantly posting their questions. If you can see, let me quickly say hi to them. Dharmesh is here, Ishani is here, and I'm also getting questions on WhatsApp. So hi guys, a big hi and a hello to you. And thank you so much for your question. We'll be taking them in a bit. But before I take your questions, I would again like to tell you that we are live, not just on YouTube, but also on LinkedIn, Facebook, Twitter. So make sure you subscribe to us. The handle is Immigration Talk Show. And yes, you can also, post your questions on these platforms too with, of course, YouTube. So we'll be taking your questions in a bit, but before that, let me again discuss a few questions with Alyssa. So Alyssa, you mentioned different visas. So now let's discuss those visas which are for startup founders. So what are the key differences between O1A visa, EB2 NIW, and EB1A visa for startup founders, and which one would you recommend for someone just starting their business in the US?
Yeah, I really like this question because I think it allows me to also clarify something where I think sometimes people have a common misconception is that green card routes are very different from temporary work visa opportunities. And so from the three that you listed, right, there's O1, which is a temporary work visa, and then EB2 NIW, which is the national interest waiver, and EB1A, for those of extraordinary ability, is an eligibility criteria for a green card. So when assessing which one to pursue, I think it depends again on the circumstances of the founder's situation, but ultimately the EB2 NIW and EB1A are more long-term plans. They don't provide any work authorization in the US. So if you are abroad and you're not inside the US and you've already started your own company, but you know you eventually want to grow into the US and you don't have so much of a quick timeline on your hand, like an immediate rush to go to the US, then pursuing an EB2 NIW or an EB1A, depending on your eligibility and demonstrating that, which we can kind of dive into, is a good idea, especially for people who are born in India, because wait times are very long for green cards for Indian-born nationals, and it's based off of country of birth, unfortunately, not on citizenship. So even if you did become a Canadian citizen, that won't really open any opportunity for a shorter queue for the green card. So what you do by kind of getting to this sooner than later is you are locking in what's referred to as a priority date. And your priority date is what determines when you can eventually apply for your green card. So locking this in sooner than later shortens your wait time for eventually securing a green card. I say that to say that if you are, if you have if you need to be in the US immediately and you want to start working on your US based company, then you need to secure underlying work authorization, which includes an O1 visa. There are other work visas that are options as well, which can be H1Bs, L1s, E2s. I think these are the four main ones that my startup clients will pursue in terms of underlying work authorization, while simultaneously either building up their profile to be eligible for an EB2 NIW or an EB1A, or pursuing that and submitting that application while they're growing their company inside the US. So in terms of which one is the best, it'll be very, case specific. I would say that, for people who aren't too familiar with the eligibility criteria, an O1A visa, you need to have a petitioner, which can either be your direct employer. It can be an O1 agent, which is a US citizen who kind of oversees your work and will be authorized by a lot of gig workers will use that. So they have like existing contracts and they freelance. And so the clients that they freelance with are willing to authorize this O1 agent to petition the O1 visa application for the individual. And then the third option is to have a US entity that you own petition you for your work, which is the startup founder route. You can, have a co-founder depending on your circumstances, or you can have a majority stake in the company as well. And there's certain requirements you need to meet to demonstrate an employer-employee relationship, which we can also dive into on this session as well, because I think that's the biggest crux of eligibility for these work visas that is specific to founders. But not only that, you then need to demonstrate that you are of extraordinary ability, which high level is, layman's terms may mean something different to everyone. But USCIS clearly identifies what those 8 criteria are. You need to meet a minimum of 3. And for different founders, for different industries, the types of evidence that we can kind of submit to demonstrate that you meet this criteria varies. Like I said, the regulations and the law is written in a very academic nature. So it's pointed towards, there's a criteria for scholarly articles, but someone who is in an entire, I'm trying to think, who's in retail, right? And in design, I mean, they may have written scholarly articles related to design and while they were in university or pursued academia, but for the most part, that's not the case. So really, it's about delving into what your industry is, the nature of your startup and your specific work, and then how you can use your experiences to date to demonstrate that you kind of have this corroborating evidence in those criteria. And so that's the O1A. In terms of the green card routes, then the O1A criteria is very similar to the EB1A criteria. Instead of 8 criteria, there's 10, 2 more that are related to arts. And it is a way higher threshold. For an EB1A, you don't need an employer to sponsor you, so you can self-petition. It is a first preference employment-based green card route, which also means that priority dates for green cards are a lot. It's a much shorter wait time, which is why they are very heavily sought after. But meeting the threshold for an EB1A is a very high standard. And so generally, based off of my client situation, we'll get them going on the O1 and we'll come up with a game plan of how to enhance their profile so that they're EB1A ready in the next year or two, depending on, you know, where they're at with their application at that point. We kind of do an assessment. We work together and identify what is feasible with their career. You know, sometimes getting publications going takes a long time versus one of the criteria is peer review. So that requires less work in terms of having to sit and publish content, but it does require more networking and engagement in the industry. So we kind of strategize on what makes most sense because you're also creating and growing your startup at the same time. And so there's only so much you can do while also pursuing your goals, right? You get so focused on the US immigration side of things, and then your company fails because you're just so focused on that. So it's really an alignment of understanding this is a long-term journey, but it's doable, and it's really about being as targeted as possible in your approach. And then the EB2 NIW has been a great route, I think, again, for the last 6 months in adjudication for both EB2 NIWs and EB1As. There's been an influx of people just applying to get their foot in the door. And not all these cases are viable cases, unfortunately. And so it's kind of backlogging the system and making it difficult for people who actually have viable cases to get approved, and it is increasing RFEs. And so, but like I said, you can never really game the system and figure out a best time to apply. If you are in a position where you are eligible, I would say still go for it. Work with an attorney who knows what they're doing and will work with you on kind of presenting the best case, but be prepared to be met with potentially an RFE, to be met with a bad adjudicator who may deny, and you may need to refile or you may need to litigate. The system, unfortunately, is not the best system, but there are mechanisms to kind of eventually get there. It's just, you got to be committed. But the EB2 NIW, just like high level, is demonstrating that you're going to be pursuing a proposed endeavor. Technically, this endeavor doesn't need to be clearly defined, but it won't be approved if there isn't clarity on what it is. So you need to identify what your proposed endeavor is, and then on top of that, demonstrate that it is in the national interest of the US so that they can waive the labor certification process, which is the more classic employer sponsorship route for green cards. The EB2 NIW also allows for self-petition, so you are not tied to your employer, which allows for greater flexibility too. But there are like additional eligibility criteria, but just high level in terms of whether you're selecting to pursue the EB2 NIW versus the EB1A. EB1A has a higher threshold. Most people who will pursue EB1As are primarily Indian borns, because for an EB2 NIW, if you are eligible, wait times for a green card aren't ridiculous, and you will, be likely eligible in the next few years to be able to either adjust your status or get a green card. So, and if you did pursue the O1 or any other of the startup visas, be it through an L1 or an H1B, you likely have at least 2 to 3 years of work authorization while you're waiting out for your priority date from your green card to be current.
Right, right. And also in cases like these, the role of the right kind of attorney for you also comes into play, right? You should have the right attorney to help you with your case, right? So guys, if you're looking for an attorney, and if you have a startup and if you want to get a visa and if you're looking for an attorney, so you can get in touch with Alyssa. Here are her details. You can email her on info at crossingfrontiers.ca, info at crossingfrontiers.ca. I want to spell it right so that people can note it down. And also, you can also please visit our website, which is www.crossingfrontiers.ca. Yes, do visit our website, and also you can write to her. You can email her. And now, Alyssa, so thank you so much for that detailed answer. So I would also like to know for you, for founders who are early in their careers, so which visa option would you recommend for them, so that they can that would offer them the most flexibility to pivot or expand their ventures?
Yeah, I think it is, like I said, of the main four, the go-tos, it really is dependent on, the nature of how they're kind of developing this startup in the US. And then there's also some like case specific based off of nationality for the E2, for example, versus if this is an intra-company transfer where someone has their startup that they started abroad and are now bringing to the US. So those are all considerations, but I'd say high level, like the pros and cons of the four, I can kind of go through those. Like for the O1, a huge benefit is that, there's no limit on how many times you can extend. You first can get up to 3 years, and then technically every time you request an an extension, you can only get one additional year each time. But if something major has changed in the trajectory of the company, we can kind of file this as a new employment. And so we can request 3 years on an ongoing basis with that. So the benefit of an O1 is that you're not limited in number of years like you are with many of the other visas, including H1Bs and L1s, which are limited to 6 years for an H1B and then 7 years for an L1A or 5 years for an L1B, which can be quite limiting. That time goes by so fast. So that's a benefit of the O1. A downside is that your spouse doesn't get work authorization from you having an O1 visa. They would have an O3, which has no employment associated with that. They would need their own employment visa in order for them to be eligible to work. And that is quite limiting for some families who both spouses do work. In terms, again, another limitation of the O1 is demonstrating that you're an extraordinary ability and that you meet that criteria. But I do find that many founders actually do not realizing that initially. So I would say, do your research, look online at the criteria, at the 8 criteria. You probably will check off at least 2 based off of, like, think deep about it, about your portfolio, about things that you've done to date. And most clients, when they come to me, at a minimum, have at least 2. And then we kind of work on pulling their profile together, seeing if we can kind of reach a 3rd or a 4th, or, I give them like a 3 to 4 month time frame. And I'm like, okay, focus on these ones and then come back and we'll reassess. So that can be limiting because you need time to do that and you need authorization to grow your profile if you're in the US. So you need a backup visa or something else that's keeping you inside the US if that's your plan and you need to start working immediately. So that is a limitation. In terms of H1Bs, they are beneficial in that you don't need to demonstrate this extraordinary ability. As long as your role is in a specialty occupation and that you will be paid the prevailing wage and you can demonstrate that need, then it's sometimes easier to meet that criteria as a founder where you are quite early stage and haven't built up your portfolio so much. However, there's limitations to this. You need to be able to have enough funds to pay yourself the prevailing wage. For the O1 visa, there's no minimum amount that you need to pay yourself. Generally, we recommend, obviously, making sure you're compliant with local employment laws and all of that. But, you can pay yourself a larger portion through equity. And that can kind of, offset paying yourself a little less and demonstrating to USCIS the nature of your work, which is very common for founders. So the limitation of the H1B is that you are, the Department of Labor has to, approve, and you need to demonstrate that you're going to be paid at least the prevailing wage of your occupation based off of your geographic area, which can be quite limiting. But there are strategies around this. Instead of submitting a full-time H1B petition, you could submit a part-time one where you'll pay yourself hourly and within a range of hours that you disclose in your application. So some clients will do that. They'll start off only working 5 to 10 hours a week as they're growing their business, and then they will add on longer periods of time or switch to a full-time H1B once they have sufficient funds for that. Like I said, a downside of the H1B is you're limited to 6 years. Time spent outside the US can be recaptured into that 6 years, with one exception. Under AC 21, if you meet any of those requirements, you can extend beyond the 6 years, but that is if you are pursuing a green card route. The other thing is that spouses cannot work, H4 spouses cannot work unless you have an approved I-140, which is the green card pathway. And then that will allow for work authorization for H4 spouses, which again, pro or con, right? Another pro of the H1B is that it's a dual intent visa. So for most US temporary work visas, they are non-immigrant intent, except for O1s. They're kind of quasi non-immigrant, quasi dual intent, but the rest of them, like TNs, H3s, these are all non-immigrant intent, which means that you cannot have the intent to permanently immigrate to the US. However, H1Bs and L1s are dual intent. So if you have a pending adjustment of status for your green card, that won't implicate your intent issues with your underlying work authorization. So there's some benefit to that as well. And then in terms of L1s, so that's like, again, very case specific. You need to, high level, there's more eligibility criteria to it, but you need to have worked for your foreign startup, or it doesn't have to be a startup, your foreign company that you own abroad for one full continuous year in a managerial or executive capacity for an L1A. And then you open up your US operations and you keep your foreign operations going. And so you have hired a team out there who's running the foreign operations, and then you start up the US operations, work for it for one continuous year in a managerial capacity or executive capacity as well. That not only gets you a work authorization, which is the L1 visa, you also may be eligible for the EB1C, which is a green card route, which is like the EB1A is a first priority. So it's a good strategy for some Indian-born nationals to kind of take this route towards a green card that may be more plausible with their long-term plans. So sometimes that's a strategy too for founders. If you are willing and open to starting your operations abroad first and then coming to the US, then that's a route as well. I would say L1s are very USCIS kind of digs deep into them. You need to demonstrate the eligibility criteria. Our fees are very common. It's better if the individual moving is a professional in some capacity. The nature of their work will be professional. Doesn't mean it's not doable for others in terms of like a restaurant. It just is a little bit more challenging. You need to demonstrate more. USCIS asks for more supporting evidence for that. And then for the most part, you need to be able to demonstrate ability to pay, unlike for the O1. So you need to show that there's funds in the company that can pay you. And then for the EB1C, especially, that you will be able to pay yourself up until you get your green card. So you do need enough funds, which can be limiting. But an L1, like I said, is a dual intent visa. So that's good. Spouses get an open work permit based off of the primary applicant having an L1. So that's a benefit as well, because if your spouse will be working, then they're not tied to an employer except for to your startup, and probably just dependent on their spouse, but that's another story. And then the next one is the E2 visa, which is a very common investment visa. The limitation of it, well, there are a few, but the main limitation is that you need to be a citizen of a treaty national country. So you can look up the treaty countries. Canada is on that list, but India is not. But so a lot of people will who have immigrated to Canada and have now attained their Canadian citizenship, which is a way faster process than it is in the US, can then do an investment into the US through an E2 visa. There's no minimum investment. Generally online, you'll read that people recommend $100,000 minimum. This is not a threshold that the US government has set. It's not a real threshold. I would say $100,000 plus is definitely a case that may be an easier sell to the government, but I've had successful cases where they've spent $15,000 to $20,000. Ultimately, you need to put the money at risk. You need to demonstrate that the company you're investing in, either through a purchase or through starting on your own, is going to be, you show your 5-year plan, your business plan, that you're going to, make some US hires, that you're going to be creating enough income that's more than just to support your family. And that's kind of the threshold you need to demonstrate. And in terms of the amount of investment, it needs to be substantial compared to the nature of your business. So if someone is going to be starting a trucking company and only investing $15,000, that doesn't make sense, right? You need a fleet. You need to demonstrate that you have purchased some of these, that you have a place that you're keeping them. And 15,000 isn't going to cover that. So that's not realistic. Versus someone who has a tech company that's just starting with one computer and this software that they're developing, 15,000 may be doable. So it's really about spelling out the nature of the company, what the long-term plans are. And then there's a component of sourcing the funds, which is a part of the E2 visa, which is important. So depending on, you can get funds from, I was going to say anywhere, not anywhere, but it could be gifted to you from a family member. It could be VC funding. Ultimately, you just need to demonstrate that the funds were given to the applicant or the treaty national company, and that those funds are now at risk and being spent on the business. So that's kind of how we focus on the sourcing of it. And then for E2s, another benefit is that your spouse can also work. So of the 4, spouses can work on L1s and E2s in terms of the dependent visas, and sometimes on H1Bs, depending on people's green cards. But for O1s, they definitely can't. So these are all considerations based off of, everyone's, unique circumstances. So, yeah.
Right. Thank you so much for such detailed answer. Thank you so much for, explaining everything in detail. And that was really, really insightful, Alyssa. Thank you so much for that. So with that, I know a lot of people are waiting, and we also have to take the Facebook questions as well. But still, I would like to know one more question. So are there instances where a founder, might have initially opted for one visa, a type of visa, and then, after their business became successful, then they transitioned into and they opted for, a different visa?
Yeah. I've done a few of those. It's just all dependent on people's, situations. But like top of mind, would like a certain case stands out to me as someone who was on H1B. They were a founder. They started on a part-time H1B, and then they switched to an O1. And they did that because they were hitting their 6 years and they didn't have an approved I-140 at that point. So they were running out of time on their H1B, and they wanted to, and then they were eligible for an O1. So during that time when they were building up their startup, on a part-time basis through their authorized work on their H1B, they were profile building so that they could meet the O1 eligibility, so that they didn't have to leave the US for that 1 year and then come back and be reselected in the H1B lottery. So it's very common. I think if anything, for the most part, I would say once someone is a founder and on an O1, they generally won't switch to a different one, because at that point, you have a little bit more flexibility, unless, of course, someone is looking for work authorization for their spouse or certain circumstances based off of, if they have travel and they want to be on a dual intent visa while their green card's pending, then they'll kind of consider something else. But I'd say most founders, once they're on that O1 route, they're now focused on their green card application and know that they'll continue extending their O1.
Right. Okay. Thank you so much again for answering the question. Now, let me quickly move to our audience's question. So, Kalpesh is here from LinkedIn, and he says, interesting. Thank you so much, Kalpesh, for your comment. Let us know if you have a question, if you would like to know anything. Please post your question in the comments below, and we'll be more than happy to take it. So let me start with Dharmesh's question. Dharmesh says, for founders seeking an E2 or L1 visa, how do you assess if the business and investment actually meet the minimum substantial or qualifying thresholds required?
Yeah. So,
we also have a
sorry.
part two. I'm so sorry. We also have a part two. And he says, are there common misconceptions about what substantial investment means? Okay, let's start with the first question.
Yeah. So, in terms of substantial investment, that's required for the E2, not for the L1. But for the E2, like I said, I think we kind of did touch on this later on after Dharmesh posted his question. But basically, the investment needs to be the argument needs, we need to be able to demonstrate that the amount you're investing is reasonable and substantial for the nature of your business. So we would really, demonstrate that through pulling your business plan, looking at what you have already spent on, and then the nature of your business. So if all you really need to spend in the next year is on marketing, and that's reasonably a few thousand, then we would demonstrate that that would still be that's all that is really needed for your company, because the product is already developed. It's already been, it's really, there's not much more financial investment that needs to go in order to sell to clients. But again, like I said, if you have more inventory and you need it for the nature of your business, then we need to show that that money is substantial for what it is. So there isn't a clear definition. It's about arguing to the officer why this investment amount is substantial compared to the nature of what you are going to be doing in the US. And then for the L1, there isn't a requirement of how much you need to pay yourself. Usually if it's on the lower end, officers will question, how true and operating your company is if you're not paying yourself a reasonable amount. But for the L1, the focus is more on demonstrating your qualifying relationship between the foreign office, the US office, and then specifically with your managerial or executive role abroad and in the US, or specialized knowledge. So the focus then is on including evidence that shows that you have proprietary knowledge, or that you were leading a team, or you led a function of the organization. So that is kind of how that will be documented.
Okay. So Dharmesh, I hope you have got your answer. In case you have a follow-up or anything else that you would like to know about, please continue posting your questions. We'll be more than happy to take it. Okay, so Lasha is also here from Facebook, and he says, I'm already in the USA. I have a work in social. Can I still participate into green card lottery? And if I win, do I have to leave the country?
I actually don't deal with too many of the diversity lottery. I think he's talking about the diversity lottery green card, which I think just opened up last month. Don't quote me on that. I don't handle too many of those. So I won't be able to answer this specifically, but I would say kind of reach out to an attorney who does handle. I know that there's quite a few attorneys who specifically also only handle the diversity visa green card. So, like Rajni said, I think the focus on finding a U.S. immigration attorney is really, dependent on their area of expertise, which is unfortunate, because you want someone to kind of assess all of your options. But some of us are very, I am very experienced in working with startups specifically and within these various routes. And so I don't do so much of the diversity visa green cards, unfortunately.
But Lasha, we do have a lot of shows with a lot of attorneys on our channel. So you can, definitely subscribe to our channel, and we'll be bringing a lot of shows, and you can, ask your question, and we'll definitely ask one of our experts and we'll reply to your question. But thank you so much for, posting your question. We'll be replying to your question after asking it from an expert. Now, let me quickly take Ishani's question. So Ishani is also here from YouTube, and Ishani says, a startup client is considering acquiring a US-based company with existing employees on various work visas. What are the key immigration-related due diligence considerations and potential risks we should assess to ensure a smooth transition?
Yeah, that's a really good question. You should definitely engage with a U.S. immigration attorney to make sure that prior to purchase, because you want to make sure that you've kind of done all your due diligence, which obviously you're trying to do as well. I would say focus on making sure that you have access to all the petitions that the US based company submitted on behalf of the employees. So you understand the commitment based off of financial commitment in terms of length of period of stay, if there's pending green cards. And then you also want to make sure that you do your I-9 and E-Verify compliance as well. If they have been compliant, for them to provide that documentation to you. And if they haven't, that you make sure you engage with an attorney so you can set up a system internally so that you can make sure you're compliant moving forward, and you can demonstrate that and paper trail that. Also, when you do the purchase, depending on the nature of it, whether it's a merger or acquisition, the nature of the employees' work visas, you may need to disclose this to USCIS just to let them know that there's been a change in ownership, but that's very case specific. So again, I'd recommend kind of engaging with an attorney to go through that with you, because you want an attorney's eyes on those, an immigration attorney's eyes on those petitions prior, ideally, to you purchasing over a commitment for foreign employees.
Okay. So Ishani, I hope you have got your answer. In case you have a follow-up, please also post it. And thank you so much for your question. And okay, so Lasha is also back and he says, thank you so much. Of course, we are here to provide you information and provide you help. So thank you so much for being here. And let me quickly take Yuri's question now. And Yuri says, how do you evaluate the potential of visa options like the O1 or E2 compared to the H1B in terms of aligning with the startup's long-term goals? And then there's one more question. Then after you answer this, we'll be taking that.
Okay. Yeah, no, this is literally where I start off with my clients, right? If high level, they've consulted with me and we kind of know that they're potentially eligible for an O1 or an E2 and an H1B, then we unpack what makes the most sense based off of their plans. So if they already meet a lot of the O1 criteria, and then sometimes my recommendation would be to pursue that over an E2, because you don't have to put the money at risk yet. But if the nature of them, the startup, is that they're purchasing a company and the money's at risk anyway, then that may be the better route, because eligibility is for a longer period of time. If they do get married, or if they already are, then their spouse has that option. H1Bs are usually only applicable to people who have previously been selected in the H1B lottery, or are like simultaneously working with a cap exempt organization. So sometimes that's a limitation. And then at that time, I also want to know what long-term plans are. Do you want to pursue a green card? What are your plans? Do you want to change up your company? Are you going to start up a few companies? That's very common in the industry. And so how do we kind of want to frame your narrative for your green card application while you're pursuing your work option? So we kind of talk through that, and I try to understand your long-term goals and align that with what makes the most sense with the various temporary work options based off of that. And then also based off of adjudication at the time, right? E2 visas are not adjudicated for the most part by USCIS. They're adjudicated by the consulate office. So you're going in for an interview and someone's deciding on the spot whether you're eligible or not, versus an officer in USCIS who sits and goes through your documentation for days, right, or hours, and is really looking at everything very in depth. And so sometimes a strategy would be going to a consular office versus submitting it at USCIS, and there's strategies around that too. So it is all basically, I say, short answer is it depends on your long-term goals and the nature of your investment and what you're trying to do in the US.
But and so what if they don't have long-term goals? They're looking for like quick advice or instant advice for just that moment. So how do you manage that?
Yeah, I mean, I go into my consultations being like, do you eventually want a green card? Because if we need to assess that. But in terms of if that,
everyone does, right?
Sometimes a lot of Canadian citizens don't, because there's then tax implications of having a green card. So, and the proximity and all of that too. Sometimes it's not the long-term plan. Sometimes people just want to work in the US for 4 or 5 years and then go back home to their home country. When people tell me that, I say, if you are eligible for a green card, you should maybe still apply and decide at that time if you want to proceed with actually getting the green card versus not. Because, being eligible is, not too many people are. So if you want, that's a good opportunity to have. But again, very, very specific to the situation. But I would say in terms of evaluating, I do on consultations, I will do like high level of collecting as much information through our conversation as possible and giving you my high level advice on what makes the most sense. I would say in terms of the O1, E2, H1B, like I said, there's all the pros and cons I listed previously, and it'll depend on, do you want to have to pay yourself a certain amount, right? With the H1B, do you want to put those funds at risk for the E2? Do you meet the eligibility criteria of the extraordinary ability for the O1? So if you meet all three of those, then it's a strategy of, okay, which one has better adjudication? Which one are you currently most prepared for? And likely, I'd say if you meet all three of those, the E2 is probably the better option, assuming you meet all three of those criteria. And of course, this is just, with as little information as possible on the circumstances.
Okay, and her next question is actually on the tax implications. So she says, please do discuss potential tax implications for investor visas. Also outline the application timeline and required documentation.
Okay, so in terms of tax implications, I am not a tax attorney or a tax professional, so I would recommend, because it's very specific based off of your home country and any tax treaties. So I would very much recommend that you speak to a tax professional on that. Like I said, there are tax implications for becoming a green card holder in the US, in that giving up your green card in the future or your US citizenship in the future for tax purposes. So because the difference with the United States, this is, again, I'm an immigration attorney, not a tax lawyer, but just in terms of informationally, the difference with the United States versus other countries is if you move abroad, you still have to pay taxes to the US government. So sometimes people will have, made a change in plans and they want to retire in a different country and they're still paying taxes to the United States. And so they may want to abandon their green card or their citizenship for tax purposes. And when you do that, you are, when you abandon your citizenship, the US government will ask you if you're doing it for tax purposes. And then in the future, if you ever wanted to come back, that will implicate your US immigration journey and options available to you. So that's a consideration in terms of once you are a green card holder and or a citizen. In terms of for the visas, the work visas, that is different. You obviously, when you're working in the US, you have to pay US taxes. How that works with your home country and treaties will depend on where your residence is and based off of the nature of the country. So for that, I would say talk to a tax professional. In terms of I think this is about the E2, right? Outline the application timeline and required documentation. So documentation, for the most part, will vary based off of the nature of your business. I'd say high level, you need to be able to demonstrate that you have the formation documents, that you have the business plan, you have all of the source of funding documents, and then you need to demonstrate your eligibility, why you're best to kind of run this business, which could be your resume, supporting documents of previous work in the industry as well. And then for E2 timelines, they are specific to the consulate. So you submit E2 applications to the relevant consulate in Canada. That's in Toronto. They're the only ones that adjudicate the initial E2s. And the timelines vary, but generally what I've seen is that when you submit the application, you'll usually get an interview within about a month or two max. That can vary depending on how busy they are. And then once you go to your interview, if they approve your E2, they'll send you your passport within a week or two. So E2s, in terms of, I'd say the application preparation time is a lot longer, but once you submit it, it gets rolling a lot faster versus an L1 or an H1B that get adjudicated with USCIS. And then if you need a visa, you need to go to the consulate or embassy and apply for that visa before you can enter the US. So timing kind of varies based off of your circumstances.
Okay. Thank you so much for that detailed answer. Alyssa, Yuri, I hope by now you must have got your answer. Thank you so much for your question. Okay, so Alyssa, it's already one. We have crossed 1 hour mark. But if you have a little more time, we can discuss a few more questions because,
Okay, I can do a few more minutes, yeah.
Okay, great. Thank you so much for that. Let me quickly take Arjun Mehta's question. Arjun is also here and he says, what are the unspoken challenges of switching between visa types? For example, moving from F1 OPT visa to an O1 or an H1B. Are there risk founders might not be aware of when they ladder through visa categories like this?
Mm-hmm. It'll depend on, again, it's very important that you work with a qualified immigration attorney who's experienced in these, because what we'll do is we'll review to make sure that you were maintaining status in your previous visa status when we change status to one of the other ones. If there's a potential gap, while you were in F1, you were unemployed for a bit, but you went beyond the permissible time, and that may raise a potential issue, then we may advise to do a consular process for your application versus a change of status from within the US. So it's very important to make sure that your immigration attorney that you're working with is reviewing your previous applications, your previous status, asking you those questions. And another thing to consider for F1 to one of the other visas is that F1 is a non-immigrant intent visa. You need to be able to demonstrate that you maintained your ties abroad. It won't usually come up at the change of status to another work visa, but it may come up at the green card stage. So you want to make sure that you are keeping documentation of your compliance of all your visas in the US. Documentation of that is keeping records of when you attended school, that you attended classes, while you were working, your pay statements, when you switch jobs, make sure you just download them and save them somewhere so that when you're applying for your green card in the future, if any of those things are questioned, you don't need to then go back to your old employer. You already have it all saved. And if there were any gaps in employment, that you demonstrate the exact dates and documentation that demonstrates that, so that you can demonstrate that you were within appropriate grace periods and that you timely filed your next application. So that's high level, but again, it's very case specific. Biggest recommendation I give to everyone is keep documentation of your whole US immigration journey, no matter what. It may never come up. You may never need to give it to you at CAS, but it's just the best way to be prepared for any potential questions.
Right, absolutely. And guys, if you want to get in touch with a good attorney for your case, so we have it right here. So you can get in touch with Alyssa. Her details are scrolling below and also right there on screen. You can note it down. info@crossingfrontiers.ca. You can write to her on her email, and you can also visit our website, which is www.crossingfrontiers.ca. Let me quickly take Rohit's question also. Rohit says, I've heard that national interest waivers and NIW can be used for founders, but what does a startup need to demonstrate in order to genuinely show national benefit or interest? Is there any practical guidance you can give on the merit of a tech startup here?
Yeah, so it'll really be about documenting the genuineness of your proposed endeavor. So letters of intent of potential clients you're going to work with, or if you already have clients for your startup because you have work authorization to work for your startup, including those. Including, for companies that are quite early stage, haven't really taken off the ground yet, I would definitely recommend including a business plan that clearly demonstrates what you're going to be doing in terms of staffing projections, financial projections. That's not on the national interest component, that's on the proposed endeavor component to show the genuineness of your company. But in terms of the national merit, the national interest component, you will really need to identify the market that you're going to be in, the types of clientele. So I'd say if you're in the semiconductor industry, that's an industry that USCIS has clearly, loves for national interest. There's a lot of supporting evidence in that. So you won't need to, the argument will be a little bit easier in terms of demonstrating the national interest versus someone who, is in real estate and in one geographic area, and you could be probably in affordable housing, and that is a national interest argument, but is it siloed to one geographic area? Is it national? So it's really, really for national interest waivers. The good and bad thing about it is that it's not definable. It's really about how you demonstrate to USCIS the impact of the work you're going to be doing and demonstrating that it is in the national interest of the US. And so that can vary based off of the nature of your work and the nature of your startup.
Okay. Thank you so much again for that answer, Alyssa. And thank you so much, Rohit, for your question. I hope you have got your answer. In case you have a follow-up, continue posting it in the comments section. And whenever we get Alyssa back for an episode 2, we will be taking that question maybe on in that episode. For now, Alyssa, I'll take a few more minutes, maybe 5 more minutes or 2-3 more minutes, if that's okay for you. I would like to share my screen and show those Facebook questions. I would also like to get an answer to those Facebook questions. So I think I'm already sharing my screen. I don't know why am I not able to show it. I would like the control to help okay, it's here. Okay, so let me take it from the top. It's just posted 1 hour back, and let me zoom my screen a bit. So this anonymous participant says, trying to figure out where to schedule an H4 visa appointment for my spouse. Is Islamabad Consulate Embassy still conducting these interviews for first time? Okay, I think this is for Pakistan. But then here is one question from Hari Krishnan, and he says, if I book Dropbox appointment in Chennai, can I submit documents at Bangalore drop-off location? So is it possible?
I would say for all the consular related questions, because they're so specific to each consulate, each consulate does things differently based off of location. So at a minimum, what I'd recommend is they have their email addresses posted and their phone numbers for the most part. So reach out to them, and you can also specifically ask. And otherwise, your attorney should be able to answer this question, because if they are providing consular processing support as well. But each consulate is different. Things change on an ongoing basis. So I would recommend reaching out to the consulate.
Okay. I think that's a great answer. Thank you so much for that. And then there is this one more participant who says, hi guys, the salary mentioned in LCA is different from what is mentioned in the offer letter. So which one to tell when the visa officer asks for the interview about salary?
Yeah, I mean, this is very case specific. I'd want to look at the whole petition to make sure that what was disclosed is the offer letter's salary higher than what's been disclosed in the LCA. At a minimum, you need to, if it's drastically different, you need to be able to, you likely haven't disclosed to USCIS the actuality of your petition. So you may want to file an amendment of the LCA. Sometimes what I recommend for clients, especially for startup founders who don't know how much they'll be paying themselves, is to put a range so that way, if you end up paying on the lower end of the range, or if you eventually want to pay more, you can you have that wiggle room. At a minimum, you need to be paying above the prevailing wage. So I would, if you are going to the interview and you are going anyway, I would make sure that the offer letter salary is higher than the prevailing wage for the specific role and the location, which likely is the one in the LCA.
Okay. Thank you so much for that answer. And then there is one more participant who says, hello, everyone. I took 10 months of break due to health issues and did not travel to USA on H1. I have H1B valid till October 2025. Will it be any issue at immigration? And from past 3 months, my pay stub did not generate.
If you're outside the US, you don't have any obligation to be paid. USCIS only has jurisdiction on your work authorization while you are on US soil. Did not travel to the US on H1, so any of that time you were not using your H1 time. You don't need to demonstrate that you were being paid during that time.
Okay. So after this, let me take maybe one more question for today's show, and then maybe we can wrap it up. So this participant says, I just appeared today, 4th of November, for consular interview at Chennai, and my visa H1B was approved, but I have not received any blue slip from the lady who took my interview. Is it normal? And any idea by when can I expect my passport? I selected VFS S Delhi for delivery. Please, if anyone can provide clarification, it'll be grateful.
Yeah, I mean, again, dependent on consulates. Yeah, but for the most part, I'd say unless you're put into administrative processing, which they may do afterwards too, even though they said it's approved, it could still happen. That may delay the process, but for the most part, once it's approved, you'll generally get your passport within a few weeks. And then if you don't within a few weeks and you haven't heard anything about administrative processing, then I'd recommend reaching out to the consulate to touch base on when you should expect it.
Okay. Thank you so much for those answers, Alyssa. I would really like to take more questions, but unfortunately, that's all the time we have. Thank you so much for extending the time too. And thank you so much for being here. And, it was a great episode. And thank you so much for that great debut that, on Immigration and Jobs Talk Show. And for our audiences, I would like to say to get in touch with Alyssa, you can email her. Her email ID is info@crossingfrontiers.ca. I would like to read it. info@crossingfrontiers.ca. Yes, that's our email. And you can also visit our website, which is www.crossingfrontiers.ca. Thank you so much again for being here, Alyssa. There were so many questions still pending and we were not able to cover all of them. So if you're okay, we would love to have a second part to this episode.
Yeah, I would love to do that. I like this. And I think that the more, targeted questions we get as people are more informed too, then we can kind of unpack them more in detail as well. So I'd be happy to do another session. But I had a lot of fun doing this. I, love talking about U.S. immigration for startups. So this was a lot of fun.
Thank you so much. Thank you so much for that, for those kind words. And we are going to see you very soon. And we are going to, schedule the show. We'll check your availability for a second episode. And thank you so much again for being here. And your answers were insightful, detailed. So thank you so much for being so elaborate and so detailed with your answers. Thank you so much again for being here.
Thank you.
Guys, that's it from our side for today's webinar. We are going to see you very soon. With an episode 2 of this webinar, and we are going to have Alyssa back soon. But until then, you guys keep on watching and keep on subscribing to Immigration and Jobs Talk Show. I'm Rajni Parara signing off for now. Take care and keep subscribing and keep watching Immigration and Jobs Talk Show. Bye for now.
Hello, everyone, and welcome back to Immigration and Jobs Talk Show. I'm really happy to be back again. And I'm Nipasa Pradhan. I'm going to be your host for this session today, and it's going to go on for an hour or so. So, before we go off with the discussion, I got this very important disclaimer, and that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, friends, thank you so much for joining us. We are live right now on YouTube, LinkedIn, Facebook, and I'm very happy to tell you that you can also participate in this discussion and you may have some questions. And as you can already see, the topic of discussion for today is H1B compliance in the Trump era. So, are you prepared for increased scrutiny? And we are definitely going to discuss about H1B site visits, especially on this episode. So please feel free to comment whatever questions you have and to help us navigate through this very important discussion. It's none other than Attorney Justin Rivera joining us from Wasden Immigration Litigation. Thank you so much, Justin, to join us. How are you doing today?
Hi, I'm good. I hope everybody else is doing well. Friday, mid to late afternoon, close to the end of the day, so can't
Yes.
complain too much.
For sure, for sure. I was thinking we will not be able to make it today, but I'm so glad you are here. And
Yeah, my son may guest star at some point as a result of having to pick him up early from school. But other than that, we should be good to go.
we would love to have our guest star for today, but for sure, I'm really just glad that he's all right, you know. And
Thank you.
folks out there, thank you so much for joining. We are going to discuss today about H1B compliance in Trump era. So maybe you can just give us a few pointers what folks out there can expect today in this discussion, Justin.
Yeah, so I think this has got to be a pretty unprecedented event where, you have an administration, a new administration coming in that is not the incumbent administration, but has previously served a term. So I think what we're really going to highlight today on the discussion is what were some of the things that were done previously by the Trump administration the last time that they were in control of the White House. What is it that we likely anticipate to be done moving forward, and how to, prepare as an employer or even an H1B beneficiary to deal with what is very likely going to be a more complicated next 4 years for U.S. immigration.
That's what, friends, we are going to be talking about today. A lot to discuss about, and 4 years is a long time. Right now, also, we are going through a lot of changes, and we are worried just about year 2025. So let's dig in and let's see what have we got for our future. And so, Justin, to help us, step into this topic, I got this first question. So, given the Trump's administration's history of increasing wage requirements for H1B visa holders, what can we expect in terms of wage obligations in the future, and how will this impact employers and H1B workers?
So I think inevitably you're going to see attempts that are made to alter, how the H1B process functions, just based on how, Trump made some those sorts of changes in the previous administration. Obviously, not Trump in particular, but Stephen Miller and those under his umbrella. I think in the past you saw things like the level one wage issue, which was something that came about during the very initial part of Trump administration, where basically they began just attacking any type of level one wage. Basically saying, level one is reserved for the absolute bare minimum entry level position into the field, and anything that seemed like it was above that in terms of job duties, or job requirements, they would use to knock out those cases. So that right there is already something that I think it wouldn't be shocking to see, be rehashed or altered in a way where they continue to assault the lower wage levels as a way to make all wages go up overall. The other thing is, hey, bud, you got to stop. You got to stop. I told you can't do that. Sorry. The other way that you're probably going to see changes is I'm sure they will try to introduce some level of new regulation altering how the wage system works for the H1B. They may either try to do that through the lottery, the H1B lottery, by making the H1B lottery weighted in a way by wages, where basically there's somehow a higher level of probability added to a higher waged position. Or they may try to redefine the scopes of the wages, basically saying, each leveled wage is actually a higher spectrum than it has been previously. So those are just a couple of ideas of what they could do. Overall, the big thing to say about how immigration law works, stop. The way that it works is this: if you want to create new law, obviously it takes steps. You have to take measures to either pass something, issue an executive order. A lot of times that's hard because it's subject to scrutiny at the court level, right? Eventually it can be challenged and overturned. What it's easier to do, and what I expect you're going to see a lot of done immediately, because it was done during the previous administration when they were in power, is just a tightening of existing rules and regulations. I think right out of the gate, that's probably what you're really going to be looking at, is really curtailing and trying to use what's in place to limit the scope of what does and doesn't qualify. And so I think that's really where you're going to see them coming after pretty much everything that they're able to come after from an H1B standpoint. But yeah, in terms of wages, it would not shock me if they attempted to make some sort of significant change over the course of the next 4 years to impact the program. And obviously, we have to realize if you're increasing wages, for the entry point into an H1B, the people who are probably going to be hurt the most by it are going to be people who are trying to go into the lottery, people who are trying to get those first H's that are most of the time coming directly out of college. Because the problem, obviously, that begins to become for the employer, how much is too much, where it's just the floor to pay an employee is so high that it's just not worth it to actually employ that person, and instead we'll just find an alternative.
All right. So we can definitely expect a lot of changes and a lot of tightening. And since rules and laws cannot be changed overnight, but we are definitely going to see wherever they can make changes faster, I think we can expect some definite changes for sure. So let's look out for that. And thank you, Justin, for giving us a heads up on that, at least so that we can prepare ourselves. So now moving on, I have this next question for us, Justin, and this is how will the Departments of Labor's rules on wage levels for H1B and other foreign labor programs affect the hiring and retention of H1B workers?
Yeah, so I think that's a great question. And I think that obviously it's impacted by what types of changes are going to be made to either the wage scale or, the actual full-on change in the implementation of utilizing H1B wages in a lottery type system, in a quota lottery type system. Like I was saying before, obviously, if the point of increasing wages drastically in the H1B program is to make it restrictive. And that's the underlying goal, would be to have less people that are actually, going out and employing individuals on H1B, because it just becomes cost prohibitive. So obviously, I think it will have a negative impact. But at the same time, it's the way in which these policies are implemented that open the door for the possibility of litigation. I know people will hate hearing this, and I think you're going to hear it a lot over the next 4 years. It's a bit of a wait and see. It's a bit of how do we look at what it is? Because not to be, I'm saying this because it's just the truth. There's not really a lot of definitive information that's really come out there about Trump's immigration policies as it applies to legal immigrants, right? A lot of the things that have been capturing the attention of the media are in relation typically to people that are undocumented in the U.S. So that's going to be, things like the mass deportation idea, and then the idea of I believe birthright citizenship has seen a lot of attention recently. Now, the caveat to that is, what is the implication of those issues, as they will subsequently inevitably relate to people that have legally immigrated? So what I mean by that is things like, we had seen in the previous Trump administration an attempt by them to basically say, if we deny you, let's say you're on an H1B and you apply for an extension and you get a denial, we're going to issue an NTA, a notice to appear, because you're unlawfully present. Well, an NTA can be a leader to being placed into deportation proceedings. Coming on the back of this idea of mass deportations, do they then utilize that kind of program or that ideology to subsequently move against people that are on, legal status, who have their extensions denied and are then unlawfully present in the United States? So I think that there's going to be stuff that, in the moment when he says it's impacting, illegal immigration, it's still probably going to have an impact on legal immigration as well. I think the other thing to highlight too would be like the note, like birthright citizenship notion. Whether or not that's an actual thing that can be done is left up to interpretation. But hypothetically, if it were done in the way that he alleges it would be done, the idea would be that in order to qualify for birthright citizenship, you would either need to be one of your parents would need to be a U.S. citizen or a legal permanent resident. So that would subsequently mean that anyone that was in the United States on a non-immigrant visa who has not had the opportunity to adjust status to a green card that has a child in the United States, that child would not be a U.S. citizen by virtue of just being in the United States. Would be born and would not be, which is it's a crazy thing to even think about, because I don't even know how the long range implications of that work. Do you get a grace period to file for a visa? How exactly does that even make sense? But anyway, all of that is to say that it will have all of these changes that are being implemented are going to impact in a certain way people that have entered the country legally. And I know I kind of got off topic on that question, so I apologize. But I did want to make sure it was brought up in the discussion.
No, that was great, actually. Thank you so much for your insights and for your perspective, for sharing that with us. Thank you, Justin. Well, to move on, I wanted to quickly say hello to our viewers who are already participating. So, Christopher, we have Supriya with their questions. So, I think we will take up your questions, but just stay with us for now. I have a few more questions on my end, Justin. So, this next question is with regard to third-party placements. So, what changes can we anticipate in the eligibility criteria for H1B visas, particularly regarding the definition of specialty occupation and the requirements for third-party placements?
Right. So during the Trump administration, they already attempted to make alterations for third-party placements, right? There was the entire issues with the, memorandum regarding third-party placement requiring, specific work examples. You would need to show work orders. You would need to show the full 3 years that there was specialty occupation work available. A litany of issues that were highlighted and eventually struck down by litigation. So that obviously fantastic that the end result was the removal of those things. However, knowing that third-party placement existed as an issue during the last period in which this administration was in a position of power, it stands to reason that it will be something that they again look at to try to place some sort of barrier that makes the process more difficult. Currently, they are still bound by the requirements that came out of the IT-Serve versus CISNA litigation, which is, their prism is supposed to be specialty occupation. They're only supposed to be looking at, does the position qualify and does the person qualify for the position? So unless they're able to introduce new policies that allow them to specifically attack third-party placement, they shouldn't really be capable of doing anything other than what they're doing presently until those new policies are released. Are those new policies possibly rehashing, under a different argument, the need to provide documents for third-party placement or the need to show work available for a full period of time? Maybe. Or they may try to attack it in a different manner. That all being said, with what they can look at with specialty occupation and beneficiary qualifications, I think it's worth thinking about what I said earlier, the idea that they are going to tighten the existence of existing regulations. They are going to make it harder to qualify for specialty occupation. They're going to make it harder to qualify for beneficiary qualifications. How do they do that? So for specialty occupation, there's a couple of different ways in which you can qualify. There's 4 different ways to be specific. And in order to do that, you provide, evidence at that's supposed to meet a standard that subsequently allows the service center to approve the case. What we saw kind of during the Trump administration previously was basically invalidating the legitimacy of evidence by pushing a hurdle, by pushing something to an impossible standard. So what do I mean by that? One of the ways you could show specialty occupation is to say, hey, look, I have 15 software developers in my company, and all of my software developers need a bachelor's degree in order to do the position, okay? So I'm going to produce evidence to show you that. Well, back during the previous Trump administration, when you present that kind of argument, they would basically attack anything they could to invalidate it. Things like, well, that specialty occupation software developer actually does X, and this one does Y. So those aren't similar positions. or this guy is actually paid at a level 4 wage and the guy you're talking about is paid at a level 2. That's not really the same position, or things like that, to basically push it to where it was very difficult, if not impossible, to meet the standard unless you really were able to stick to some really solid evidence. I wouldn't be shocked if there was a real uptick in the need for expert opinion letters pushing back against RFEs for specialty occupation, just because they're one of the strongest items of evidence that you can provide. So I wouldn't be shocked to see that. I think what you're going to also see is the kind of evidence that that you get away with now. Things like maybe articles, insight, professional insight, that kind of stuff is going to be lessened. They're just going to find ways to say that that's not legitimate and that's not something that actually shows the position qualifies. So I think that'll be a problem. From the beneficiary qualifications standpoint, it's going to be much harder to really say what qualifies someone for a specific specialty. And what I mean by that is this. I can remember before, during the Trump administration, that there was a litany of denials for people who had previously been having no problems getting approved with like an electrical engineering degree. Just something that was, somewhat related to the position, but the Trump administration was coming back and saying, absolutely not. If you're doing computer systems analyst work, you need a degree in computer science or IT. And that's basically it. So just the idea that you're really going to see that tightened, probably even further than it has been now, is something to be aware of. And so that does kind of get back to the idea of, do you just start getting those combo evals at the outset, those education plus experience evaluations, to then fit the person into the bucket that you want to put them in terms of, this is the specific type of education and experience they have that gives them this degree type. So it's a lot of times, I think now we'll wait for the RFE. We'll see what the RFE is. I don't know if you want to wait for the RFE now, because if they catch you on one issue, they're probably going to do what the third thing is I was going to talk about with the Trump administration was the boilerplate litany RFEs, where they're just going to start hitting people with specialty occupation and beneficiary qualifications on every RFE. And it's just, the whole purpose of it is to delay the process, open the door for there to be more problems that could arise with the case based on what kind of evidence is provided. So I think people are going to have to adapt as a result. And we'll see, do they try and come out with a new definition of specialty occupation? We'll see. I think that would be difficult to do. I think they've had success in curtailing the definition as it is under the current rules. And I think what they're going to do is just continue to do that. I mean, if I remember right, I saw recently in an article, I believe the RFE rate generally for H1Bs under the Trump administration rose something close to 20-something percent. I think it was 24, 25%. So if that's what we saw in the last administration, it makes sense that that's probably what we're going to return to, if not see higher levels.
Absolutely. And I think we also saw a lot of problems with extensions when they wanted to extend their visas. They were also facing a lot of problems. So we might as well expect that to happen even in Trump 2.0.
Yeah.
Right. Thank you so much, Justin, for explaining that in detail. Now, I think
Sorry for the noise if he's walking around in the background.
No, please do not bother. It's all right. In fact, if you want to take a break, we can have a quick break.
Yeah, if you wouldn't mind giving me like 2 minutes, that'd be awesome.
All right. So folks out there, just hang around. We are going to discuss further on H1B compliance in the Trump era. So don't go anywhere. Stay tuned to Immigration and Jobs Talk Show. We'll just be back after a short break. Welcome back after the short break on Immigration and Jobs Talk Show. This is Nipasa Pradhan, and we have with us our guest for today, Attorney Justin Rivera from Wasden Immigration Litigation, and we are discussing on H1B compliance in the Trump era. Are you prepared for increased scrutiny? And if you're not, if you have any questions, please feel free to comment them because we are definitely going to keep some time to take them up for you. Justin, thank you so much for being a part of this. It's been a great conversation so far. And we are talking about, we want to also know more about the scrutiny if we can expect on H1B site visits. Do you want to talk about that too?
Yeah, absolutely. I think it's something that's going to be it's going to be problematic moving forward. I think that really right now there's probably going to be a familiar issue for people who are particularly handling third-party placement. I believe they're typically called, IT consulting companies, things like that. Right now, I think if you're an IT consulting company, you're probably seeing some level of site visits. Maybe it's not that bad. Maybe you're getting a couple a year, something along that line. I think that it's reasonable to anticipate that during the Trump administration, there's going to be a significant ramp up. Probably going to be done under the allegations of fraud, that there'll probably be some sort of idea put forward that, oh, there's fraud taking place in the visa system and we need to catch the fraud. They'll probably throw money into it to hire more officers, more FDNS site visit officers in order to carry out these site visits. And as a result, I just think you're going to see a significant uptick. The thing about site visits, which we've talked about before, is a lot of times a site visit is used as a fishing expedition. It's an opportunity to come in and gain as much information about H1B employees within a company as possible. So it's always common to see these broad ranging questions asked, things like, how many H1B employees do you have? Can you give me a list of all of their names, all of their work locations, all of their wages? What that really does for them is it just gives them an opportunity to then start looking through more and more information with the hopes, and I really want to reiterate, the hopes are that they find information to get cases revoked. That's what the FDNS officers are doing. They're not there to be your friend, and they're not there because they're just verifying information. Their intent and purpose is to catch fraud. And the more fraud they can allege, the better it looks for them as an agency. So if we were looking at a level of scrutiny that, let's say, was mild to medium during the Biden administration, I would expect a significant uptick. The reason for that is, it's pretty simple and straightforward. This administration wanted to restrict legal immigration during their last tenure. I see no reason to think that they're not going to be trying to do the exact same thing. One of the best ways that they can do that is by going to people's places of employment, doing site visits, and then trying to revoke H1Bs with a finding of fraud. If you revoke an H1B with a finding of fraud, that employee is inadmissible from the U.S. and set up with a permanent ban. It's a great way, if you're trying to restrict immigration, while still remaining within the confines of the law. So I think that what we're going to have to do and what we're going to have to look at moving forward is an understanding that you need to have your employer and the H1B employees set up in a way where they're able to succeed in the event of a site visit. Because you're not going to know typically when the site visit is occurring, and you're not going to, most of the time, be prepared. And I think that era needs to go by the wayside, because in addition to issues with DOL violations for improper wages or placement or things like that, as the employee, the beneficiary, the holder of the H-1B, you're at risk if something happens. If something goes wrong where your case gets denied with a finding of fraud, you're in a bad situation. And the fact of the matter is the employer can typically walk away from it with not much of a penalty to them. Maybe they lose the employee, which sucks, but that's really all that's happening for them. So unless there's really a repeated pattern of them doing these things, it's really not as big a deal for them as it is for the employee. That being said, for the employer, as I told someone who I had a conversation with earlier today, when you get popped with an issue of fraud on an H-1B, you're basically opening the door for them to basically try and utilize that information across the board for any other H-1B employees. You know, what does this do to your other employees' extensions isn't as big a deal as what does this do when you go to the consulate? Because the problem you're going to also face as a result of this is at the consulate, I cannot see why they wouldn't start to issue even more 221Gs than they're issuing presently. And so, yeah, really when it comes to site visits, you're going to have to be absolutely on top of your game with the information. I think it would be ludicrous at this point to not have legal representation when you're dealing with FD&S, because I just think it's too difficult to combat what the officers are trying to do unless you have someone there telling you what you actually do and don't need to require to answer. Because they're not playing that game. They're going to, like I said, they're going to try and get as much out of you as you are willing to give them, and they will use every piece of information that they have against you when they can. And so, yeah, I mean, it's really incumbent on the employers and as well as the employees to really process what is happening, what is going to happen, and get ahead of that process by making sure you're prepared. And the last little thing I do want to say about this, because I've unfortunately worked on cases as a result of this very thing happening, you can have a site visit to your home. If your home address is a work location, like it is for a lot of us nowadays,
Right.
you can expect an officer to show up to your house.
Mhm.
That's something that people need to be prepared for, because I have seen horror stories where people have been working from home and, like myself, have their kid in the background and they're trying
Yes.
to answer an officer's question and they misspeak and say something wrong. And that officer, most of the time, isn't going to say, "Oh, hey, sorry, I think you said something wrong. What's going on?" They're going to say,
It's going to
"Okay,
use it against you.
report the information," and
Right.
then they're going to forward their report with a finding of fraud and a request that your H-1B be revoked.
I can only imagine. And it's happened. You said horror
Yeah.
stories, and it's not just one story. There's so many stories. So many people have been revoked because of this situation. And I think confidence also plays a very important role in this, the way you answer to these officers, or how timid you get, or how unable or nervous you become when these officers suddenly surprise you with their visits. Unexpected, right? And
Right.
it's so scary that they note down all these and they take your weakness and they just play it against you for their benefit.
Yeah.
Crazy. But thank you so much. Yeah.
Thank you. No, I just, yeah, it's a tough situation to deal with when you're in it, especially if you haven't been, properly trained on what you're supposed to do and what you do have to say and what you don't have to say. And, the big thing too about legal representation is you can really just close the door on any line of inquiry right at the outset and explain that any level of correspondence has to go through your representative, and
Right.
that's when it comes into play that
Okay.
having that attorney representation removes you from having to make any of these difficult decisions in a moment where you're going to be stressed out. What it also does is it
Mm.
places you in a situation where you're eventually dealing with correspondence through email, which is great because then there's a record to show exactly what you've said, or you're doing it on the phone with your attorney present. And so in that circumstance, you're in a much better situation than you are if you're just handling the process by yourself.
There you go, friends. And it's always best to have your attorney with yourself who would answer most of your questions for you. Thank you so much, Justin. Much needed. I think folks out there they have questions regarding this because, like you said, it's happening nowadays.
Mhm.
So let's move on now. I have this next question. How will My next question for you is what are the implications of the Trump administration's rules limiting H1B approvals to 1 year for work at customer locations? And how will this affect IT services companies and other affected industries?
So for now, they're not really able to get away with doing that. What they had been doing in the past under the Trump administration is using those third-party placement memos. What they had done is they had basically curtailed approval notices to the duration of a work order. So a lot of work orders They're typically going to be going till maybe the end of the year or maybe even the end of the fiscal year because they renew. And because they renew, even when we were responding to requests for evidence, we would be highlighting, just because this is the end date listed on the work order doesn't mean the project ends. It's subject to renewal. USCIS was ignoring that essentially and just saying, nope, you've only got that end date on there. So that's the validity period that you get for an approval. That has been invalidated by litigation. So it's not something that they're currently capable of doing. In fact, they actually cannot shorten a validity period anymore without giving an answer or a justification. Basically, because it's a partial denial, it has to be explained. So can they bring that back, I suppose, is kind of the issue to think about. And I don't know how they would do it, because I think they would have to get around the litigation that's already there saying that you can't. Because really how that issue came about was, like I said earlier, there's 4 ways that you can show a position's a specialty occupation. What they were doing was focusing on the 4th way, which is like the duties and the nature of the work is so specialized or complex that it requires a bachelor's in specific specialty. What they were doing was basically saying, oh, we have to know what these duties are. Otherwise, we can't tell if the position qualifies for specialty occupation. So we have to look at the work being done. And somehow they used that to justify that they needed the work orders. They did it with the employer-employee relationship in there as well. But it's all under this guise of specialty occupation because that's all they're really allowed to look at. So because that's been invalidated, I think that for now, I don't know how they would reasonably be able to do that, how they would be able to come back and shorten that. Again, I know, like I said earlier, you're going to hate hearing this, but it is a bit of a wait and see. We have to kind of see how they plan to implement that, if it's something that they want to implement, instead of being proactive in that regard. Like I kind of was saying earlier, though, just because they're not going to be able to attack the H1B that way doesn't mean that they're not going to try to come up with new creative ways that exist within the confines of the current construction of the law to make the process more difficult. Maybe trying to attack wage levels again, maybe trying to find ways to increase the wages in the H1B. Again, really trying to tighten down on what a specialty occupation is. So I would say expect to see, all of that. But this may be something that they're not able to touch unless they're able to figure out a different way to do it.
Okay. Thank you so much, Justin, for the detailed explanation. And at this moment, Justin will take up this question from our viewer. This is on YouTube from Sandeep. Sandeep, Sandeep is asking, is there any chance of green card backlog reducing by passing some law? I have a priority date of 2016. Any chance of getting current in the next 4 years?
I don't want to hurt anybody's feelings, but I've definitely seen this idea floating around on social media that the Biden administration's inactivity, and their lack of desire to make substantial, meaningful changes to legal immigration merited them, going a different way in administration. What I mean is, the immigrants thinking, well, they're not doing anything, so maybe if we get Trump in there, he'll do something. I would be shocked and awed if the Trump administration took any act or did anything whatsoever with the end goal being of benefiting legal immigration in this country. I would love to be wrong. It would be amazing to me. But the fact of the matter is, the people who are in charge of the immigration policies that he's going to be, he's going to be putting forth, the people who are in charge of those policies, they want immigration restriction. They do not want immigration restriction purely within the ideology of illegal immigration. It is a totalitarian belief that immigration should be curtailed as much as possible. So why, if that is their goal, would they pass any meaningful legislation to benefit people that are waiting for a green card? I just don't know why they would do that. Again, I would love to be wrong. It would be awesome if I was wrong. It would be really great if Trump, for whatever reason, woke up and said, this is messed up. I have control of pretty much the entire government, the entire federal government, because my party is in charge of basically everything, and I'm going to help these people out. That would be
It'd be
fantastic.
great. I know.
Could he do it? Yeah, I think he probably could. Is the other side of the coin. And that's where you start getting into what is the political benefit to him of taking that kind of action? And what is the rhetoric, the MAGA rhetoric he wraps that in to sell that to his own supporters? Because I'll already tell you just off the top of my head the way something like that would work. He would maybe introduce something that would work to curtail the backlog under the guise that the people who immigrated legally into the United States don't deserve to wait forever for a green card because it's not fair. Okay, that's a nice sentiment, in terms of this is unfair and we want to make it fair. His base will in turn very likely come back and say, why are you helping them? Why aren't you helping us? You're supposed to help us. Why are you helping them? What about my problems? Why does my groceries cost so much? Why is gas so high? Why is it so hard for me to get a job? So you do have to think about, you really have to think about why would he want to do this? What would he do? Why would this really help him in any capacity? And then looking backwards from that, look at the people around him, the Stephen Millers of the world, the Heritage Foundation, the people who really do immigration policies, and think about what they want and how he would be able to somehow spin this idea to them. So that being said, I would love to be wrong. And please, if I'm wrong, you can rub it in my face. Find me on LinkedIn and tell me I was wrong. I will tell everybody, each one of you, I will say, you are so right. I was wrong. I apologize. Congratulations on getting your green card. I would love for that to happen for you guys. I think it's an
Sure, Justin. For sure. But thank you so much. I think never better the way you explained it. And Sandeep, there you go. You have the harsh truth, but that is what it is. Thank you for your question. Thank you for participating, Sandeep. And now we have Jagadish on LinkedIn. I think we should take that up. Yes. Asking, is there a possibility to start the domestic visa renewal again?
So this again goes back to what do you think the Trump administration is going to do? And I think their underlying goal is going to be make immigration as difficult as possible while operating within the legal parameters of the law. That being said, I believe that the domestic visa renewal program was a pilot program that was being tested out where people were able to renew their visas here in the United States rather than having to travel abroad to do that. So obviously renewing your visa in the US was easier than traveling abroad. So no, I don't think it's going to come back. I can't say it any more plainly than that. I think that you're going to have to go out of the country to renew your visa. You're going to see more scrutiny at the consulate, and you're going to see more scrutiny at CBP because it's good. You're going to have multiple opportunities where they can check when you're entering and applying for a visa to see if there's a reason to deny you.
Mm-hmm. Thank you, Justin. Thank you for taking that up for Jagadish. And I think we can take up Christopher's question now. This is with regard to RFPs. Yes. The Trump administration's stricter H1B policies, what specific documentation and evidence should employers gather to demonstrate the specialty occupation's complexity and the beneficiaries' qualifications?
Yeah, so this is kind of where it gets back to what I was talking about earlier with, I think that evals, position evaluations that are from, accredited professors at accredited universities or whatever. I think those are going to become big again, because those were really one of the strongest levels of evidence you could have. I think you're going to have to really, you're going to have to get real specific into the weeds about the job duties being performed for the offered position. They're probably going to want to see things like percentages, which is a ridiculous notion. I've always found it hilarious that, we're supposed to provide specific percentages for job duties as if I know how much of my day is spent checking an email or drafting a motion or reviewing a petition. But that's another thing that it wouldn't shock me if it comes back, because, you know, what they were doing before was if you weren't providing percentages or, you know, 15 to 20 job duties, the argument became, oh, we're not able to tell if this position qualifies because we just can't really tell what this person's doing. And I had even seen that moved into the vein of, you know, a professor does a position evaluation and they say, yeah, but the professor relied on these job duties and I don't know what he's doing in these job duties. So how did the professor? So, I mean, you're going to have to get really, really specific about what exactly the person's doing and how they're doing it. Again, you're probably going to need evals. The ONET and the OOH are basically gospel for USCIS. If you don't know what the ONET and OOH are, those are databases online that has employer information. The percentages related to the degrees, you know, people that have degrees for that position, that's going to come back probably in a big way for them to say, oh, you know, you're a market analyst. The ONET says only 30% of market analysts have a degree. So how do you qualify? So I think you're going to have to really start looking at what specialty occupation category are you in and how do you fit into that category? Because the other thing that they're going to push on now is pushing people out of the categories that have those higher rates. You know, so let's say maybe a software developer is an 87% bachelor's degree on the ONET or OOH information. The other thing they're going to attack is this isn't a software developer. They're going to make this broad claim that this is actually position Y instead of position X. And so not only is this not a specialty occupation, but your LCA is deficient. So really, it's going to be, you know, really having to hone in on the job, making sure it's in the right occupational category, and making sure that the duties, are detailed and strict in how they relate to the position itself. For the beneficiary qualifications, I mean, you're going to be looking at them restricting it as much as possible. It would really shock me if unrelated degrees get through without getting an RFE moving forward. And by unrelated, they're really going to press it. You know, they're really going to make sure it's very specific fields in relation to what's being done. That's where you come back with those combo evals, those education plus experience evaluations. You have to be really careful with those because just like they try to attack the job duties for the professor eval, they're going to try to go after those qualification letters as well. So when you're saying I have 5 years of experience at company X, expect them to start trying to come back with things like, oh yeah, we see that you said that, but we don't know what your duties were. So how do we know that this is a legit position, you know? Or, you know, that document wasn't on company letterhead. So how do we know that this is legitimate? I think I've even remember seeing in the past, and I'm not even joking when I say this during the prior administration, I think I remember seeing a case where it was signed and had all the information, but USCIS questioned the credibility because it did not have the signature information under the signature. So it was basically signed, you know, thank you, John Smith. But they were like, where's John Smith's phone number? Where's his email address? And why doesn't it say his job title? So yeah, that's what I would say you could expect. And also, I'm sorry for the vibe being so, you know, down during this. I feel like I'm answering all of these questions really negatively. I'll try to find some.
Let's take a U-turn. Maybe you could tell us what are the positive things we can expect then on this note, Justin.
Wow.
I know that's hard, right?
Yeah, that's a tough question to answer. You've put me in a tough spot. I mean, look, is there a world in which, you know, really because the focus of what Trump had been running on is purely in relation to, purported illegal immigration and border issues? Is there a world where that kind of gets the forefront of his attention and the brunt of his attention in the beginning of the administration? I think maybe. I mean, it's maybe possible that happens, but I don't know. I don't know how to find a real big positive spin on it, just because I was practicing. I started practicing the first year Trump was in office. So all of this stuff was normal to me. And it wasn't until I got out of the administration into the Biden administration that I saw things and realized, oh, wow, actually it was a little bit crazier under the Trump administration, just because the difficulty level was ramped up so high. So I would say, you know, I guess the benefit of it would be this. Now that I think about it, thank you for giving me a moment. The benefit is we've seen the administration before. There is some understanding of what had been done in the past, and I think that it will make it a little bit harder for them to make these changes in the future. A lot of attorneys practicing in immigration already have the experience under Trump's previous administration that we did not have before. We were having to create arguments whole cloth to combat these things that came up because they hadn't existed before. And we were able to find success once we were able to, get to that point where we found those arguments that worked. So I think that's a benefit, is that we are more equipped and prepared, I think, this time than we were before. Of that, you're not going to see as many denials as there was the first time the administration, the Trump thing is, litigation is a tool, and it is an opportunity to, go after the administration when they act in ways that just straight up. So, yeah, I think they've been sued before, and they've lost. And moving forward, we know that. So it is tough when you take on Goliath. It is difficult when you face the government, but you can be successful. And I think that's important to know. It's not a hopeless situation just because it's made more difficult. I think more than ever, the employers that are willing and able to adapt and that are able to understand that standards may be enhanced, understand that difficulty may be higher, and they get ahead of it before it becomes a continuous issue for them, they're going to be in a position to succeed. I think it's the nature of the profession to be reactory and wait until something bad happens to then seek help. I think we have to be proactive, and I think we have to go ahead and start making sure that what we're presenting is stronger than what we're used to, with the understanding that it will inevitably begin facing a higher level of scrutiny.
Thank you so much, Justin. I mean, that was a real good perspective, and thank you for sharing that with us. I think we really needed to hear that.
Yeah.
Yeah. Thank you. So we have Sahil also, Pavan. Thank you for your questions. Stay with us, and I hope we can take them up shortly. But Justin, at this moment, I have another question, and that is, how can employers ensure compliance when H1B workers are placed at customer sites, and what additional legal obligations might they face?
So when you have an employee placed at a third-party location, that location is designated in your labor condition application, which means it is absolutely opened up to the scrutiny of an FD of a site visit. Site visits at third-party locations, you lose power there, obviously, because as the employer, you're not physically present on site. So a lot of times in that situation, it's going to be kind of incumbent on the employee. The employee might have to be the one in that situation that's more properly trained and ready to respond to the inquiries that occur at that third-party work location. Just generally speaking about some things that really need to be clear-cut when you're placing someone at a third-party work site in relation to the petition is their name. And what I mean by that is this. I know you're like, name, what does it matter? It's a silly thing. In your I-129 petition, there is one place for your name, and then there's a place below for any other names that you have or you may have been known by. If you are somebody who comes to the United States from another country, and because you're, maybe trying to assimilate, or because you've noticed that people have difficulty with your name, you say, just call me Jim. They all know you as Jim. Which means if an FD&S site visit officer shows up and says, hi, I'm looking for Sahil, they may say, I don't know who Sahil is because I don't know a Sahil. I know a Jim, but I don't know a Sahil. Understand that that's literally all they need. They will say, okay, cool, turn around and walk out. Guess what? You're getting a notice of intent to revoke because they're claiming that you weren't working at the work site when they showed up. And when you say, well, I was working at the work site, they're going to come back probably and say, you may have been, but you didn't say in the petition that you were known by any other names. So how were we to know? all we have is the petition and the information in the petition to verify. So when it is a third-party worksite, I definitely think it's at least worth, as the employee, maybe just letting them know in some capacity, hey, if somebody shows up and they ask to speak with me, please let me know. Please come get me. If I'm not there, please tell them, hey, I'm out, and give them my email address or something like that. So that way I'm able to, communicate with them. The other thing about it is, when they talk to these third parties, it can create issues with miscommunication. Perhaps the third party who has you assigned there as a contractor doesn't necessarily know how many hours you're working. Maybe it's unclear what your actual job title is to them because they just know you as a consultant. So those are things where, you really want to try to make sure that the information that's presented with you at the third party location, as much as possible, matches up with the information that's in your petition. Sometimes that's genuinely outside of your control. There's some things that you can't control, but it's always important to know that within the bounds of what you can control, you should do everything possible. And so that should be, letting them know about the potential for a site visit, letting them know how to get in touch with you, and letting them know that you want to be notified if and when a site visit occurs.
For sure, for sure. Thank you so much, Justin. And I think it's very important to be on the same page, especially when you have to deal with other parties and, the risk is you and your job. So you might as well try to communicate better, have your friends. I know not everyone is a friend in a world like this, but I think you will still have to try to be together in the same page so that you are safe, and make sure that you're playing safe. Basically, just that, doing the right thing, and being able to communicate properly is also much needed. That's from what Justin just explained. Thank you so much, Justin.
Hmm?
I think we can. How much? I just want to know how much time do you have? Can you stick around a little longer, or do you want to wrap up as quick?
I could maybe try to give you about 5 more minutes, but my son is being as quiet as he
I
possibly can be, and at some point it's just not going to be tenable anymore. So
understand. All right. So since we have a lot of questions, and this is a very, very vast topic, and I'm sure folks out there also have so many questions, we can continue this for another episode. But before we go, Justin, if we can wrap this up in a good note, and also give us pointers to keep in mind so that we are able to prepare ourselves for these coming days.
yeah, so just generally speaking, not to incite fear, because I'm not trying to, but I think if you have an extension that's pipelined, let's go ahead and get that filed now. Get it done now, sooner rather than later. If you need to go, for visa stamping, and you have the opportunity, do it now. Any sort of thing that you have the potential to get done presently before late January to early February, I would get those things done, as expeditiously as possible, because it's always better to deal with what you know versus what you don't. And so
Yes.
I would just say if you have that potential to do those things, do those things. That all being said, I think that, like I kind of was saying earlier, I think that the immigration community is in a much better spot in terms of preparation than we were back in 2016. And so I do think that in order for them to really go after the H1B program and H1B holders, I think they're going to have to be more inventive and creative than they were before. So we are already on notice, basically, of the kinds of things that we were used to seeing, and we're ready. I think we're more ready and more equipped to deal with them than we were before. I mean, really, honestly, like just the notion of even suing on denials, I remember back, before, it almost seemed ludicrous, this idea like, oh, wow, really, we're going to go sue the federal government just on an H1B denial. Like, that was something. I don't know if those will become more commonplace as the denials get more outrageous, or if there'll be different avenues that'll be pursued. But that all being said, I just feel like we're in a better spot than we were before. And as a result of that, I am hopeful. And then obviously, with Wasden immigration litigation, you have John ready, to do what he does best. And I am ready to, handle those petitions moving forward and ensure that we have the highest probability of approval possible.
Absolutely. That is what is required, I think. And folks out there, you can always contact Attorney Justin Rivera, have a one on one consultation, maybe consult with him regarding your case. And you can call him on his number. His number is 844-592-7336. You can note it down. And you can email him to get in touch with him also. And the email address is support@wasden.law. And go visit www.wasden.law to get to know more about Wasden immigration litigation. But thank you so much, Justin, for joining us today. It was really insightful. I wish we didn't have to wrap up as quick, but see, we've completed an hour and there's so much more to talk about. So I'm hoping to see you again soon, next week, maybe.
Absolutely. I'll do my best to be available.
Thank you so much. You have a great weekend, and I hope your son is going to be superb very, very soon. I think he already is feeling fidgety.
Fine with me.
All right. Happy
Thanks.
weekend to you and your family.
Say bye.
Bye. So sweet, but thank you so much. I hope you're doing good.
Appreciate it.
There he is.
Bye.
Thank you. Thank you. Bye bye. Well, we've got someone saying you look like Junior Trump, Justin. Banda was saying that. That's just a view. But thank you so much, all you folks out there, for joining us. It was really great having you. And if you still have more questions, I'm really appealing to you to keep commenting because, as you just heard, Justin is going to join us very soon again in the coming week. And we are hoping to cover all your questions and discuss further on H1B site visits. Thank you so much for joining us today. Y'all out there have a great day ahead. And please do not forget to subscribe to Immigration and Jobs Talk Show and hit that bell icon so that whenever we have discussions like these, you are notified. Thank you for joining us. Have a great week.
Happy to be back here. And thank you so much for joining us. We are streaming live right now on YouTube, LinkedIn, Facebook, and also Twitter. And I'm happy to tell you that you can also participate in this webinar with us. But before we move ahead, I have this very important disclaimer, and that is, by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, once again, thank you so much for joining us today. And we've got a great session lined up for you. And today we are diving into a topic that's vital for many businesses and workers across the United States, the H2 visa program. And so, whether you are a business owner seeking to sponsor seasonal or temporary workers, or a worker instead in learning more about your options, this webinar will be invaluable. And I'm really thrilled to be welcoming our guest for the first time on Immigration and Jobs Talk Show, none other than Meagan Kirchner, who is the founder of Kirchner Law PLLC. With nearly a decade of experience in immigration law, Meagan has become an expert in H2A and H2B immigration matters, and she'll be walking us through everything today you need to know about legally sponsoring workers and also exploring the processes of working as a seasonal temporary worker in the United States. So yes, I think you can go grab a pen or paper if you're still the old school, or maybe even note down some pointers in your tab or your phone or your iPad. Thank you so much for joining us, and let's get ready to really learn some key highlights today and these insights that Meagan is going to, share with us. So, Meagan, thank you so much for joining us today. Really happy to have you here.
Hi, great to be here. Thanks for having me.
Yes, Meagan. I don't know if the introduction was enough, but we would love to know you much better. Please tell us about yourself and how busy you are these days.
Sure, like many immigration practitioners, it's a hot time. There's with unemployment where it is, everybody is just looking for people to fill empty slots. The H2B and H2A realm is just extremely busy. I service employers all around the U.S. In both H2A, which is agricultural, and H2B, which is non-agricultural workers in the seasonal temporary visa process. Been doing immigration for over 10 years now, and it is a hot segment right now, and we're all on pins and needles with the U.S. political climate, and just hoping we stay busy.
We are. I already feel it is, and especially with the elections just over just some time back, and everything changing right now. And in the next coming months, we're going to see a lot more changes. I think there's a lot on our plates, on everyone's plate. So
very much so. A whole another segment for that.
For sure, Meagan, for sure. And today's topic. So, what can folks out there expect from today's webinar from us?
Sure. So today's focus is really going to be on the H2B side of the seasonal worker program. The agricultural H2A side, it would have to be a whole nother show. But what you should learn how an employer would get involved in the program, whether or not they would qualify, how the process looks, what the risks are, what compliance components they need to be aware of, what workers should know and what they should know their rights are in the process so that they are not taken advantage of. So really just trying to focus on giving a little background knowledge from start to end, on the employer side and touch on the, employer rights side as much as we can.
We will. And I'm sure folks out there are very excited as well. So happy to tell you that you can participate wherever you're watching us. And if you have any questions, especially regarding the topic, please feel free to drop them in the comments. And Meagan is definitely going to be very happy to take them up later in the show. So I'm excited too, Meagan. Thank you so much for doing this today. And without further ado, I have a few questions lined up. So let's go ahead with the first one.
Sure.
So what are the key steps an employer must take to obtain a temporary labor certification from the Department of Labor for H2B workers, and what documentation is required?
So, just as a little bit more background, the H2B is a full-time temporary non-immigrant visa. It is seasonal. So unlike many other visa types, it's something you have to apply for every year. Unless you're doing a one-time need, that's a separate category for like a nanny or a caregiver. That would be for up to 3 years. The rest of the visas, the bulk of the H2B process, for your hospitality, landscaping, seafood industries, construction industries, those are seasonal or peak load, meaning it's an annual application. It involves 3 separate government agencies. That's Department of Labor first. We'll get into what that entails in a minute. The USCIS, U.S. Immigration Services, is the second agency, and the third would be Department of State. That's the consular processing. So that's where the worker would come in, and that's at the point that they would go get their visa. The first step in the process is critical. One of the key compliance components of this program is that all workers are paid at least a prevailing wage, which is mandated by the government. It's to ensure that they're receiving a fair wage based on the type of position they're working in, and the location and experience required for that position. So, it just really ensures that the program maintains its integrity and no one's being paid something that's too low for what they're working on. That's the first step in the process. All of these steps in this process can be time intensive. So it is very much sensitive to what part of the year you're applying for, what your dates of need are. So this prevailing wage step takes up to 60 days sometimes. So you really have, for all parts of this process, you need to allocate at least 6 months. You need to know at least 6 months ahead of time in order to ensure you have enough time to file with each agency. The way the program is set up is that there's 2 halves of the fiscal year. So that if you're based on your start date of need. So if your start date of need is in October, you'd really start prevailing wages more than likely in April, so that you can file in July. You file your H2B application, which is an ETA 9142B. That's the second step in the process. Once you have prevailing wage, you can start that process. And again, if you're at April 1st start date or later in the second half of the year, it goes by the government fiscal year, which starts in October. My apologies. You will need to start that process probably in August of the preceding year. If you're looking for instance, starting an H2B worker April 1st, 2025, you're going to need to have already started that process. It may be too late at this point to get a prevailing wage back in time to start the process for next spring. That being said, once you've gotten that prevailing wage and you file the second step in the process also with Department of Labor, that actual H2B temporary labor certification, that would require you to set forth with the government whether you're filing for one-time needs, seasonal, or peak load. So that would entail documentation if you're a new filer, a new employer, establishing your seasonality, establishing your season and your need for the number of workers you're requesting. Typical documentation would be a statement of need, which again explains your business, your season, your industry. Taxes for the company, could be revenue charts, payroll showing when you have workers. Those are very common documents, as well as contracts. Really what you're showing at this stage is that your business operates either seasonally, meaning you only operate during the season, the times that you're telling the government you operate, or that you're peak load, meaning you operate year round, but there's a peak, there's an objective increase in your business or revenue during particular months of the year. That would be your season. So all of those kinds of business documents can prove that seasonality, prove that temporary need. Now, that application gets lodged with the government on one of 2 time periods, depending again on your start date of need. It's either July 3rd for October 1st filings or January 1st for April 1st filings. There's technically a 3-day filing window that you have at the beginning, but it starts on January 1st and July 3rd, unless it's a leap year. So that's when you file that application. The next step after you actually lodge the application with your supporting documentation is your company will be, this is what they talk about when they talk about the H2B lottery. All of the employers are put into a pot in a computer and randomized. Your company will be assigned a group letter, A, B, C, D, and so on and so forth. And while that letter or that group doesn't truly dictate whether or not you get workers, it's more nuanced than that. It does impact the timelines, and more so for the spring visa half than the winter. That letter will determine whether you beat the cap from in all cases, for the most part, for the spring. It's there's enough employers or applications for the number of workers in Group A, for instance, in the spring to encompass the entire cap. So if you don't get it, that's not to say that if you don't get Group A, you're not going to get workers. We'll get into it later in the program over what the cap is, if there's other ways to get in under the cap or other mechanisms to file with supplemental visas. We'll talk about that in a little bit. But assuming you get in and there are still visas available to file the next step is filing with Immigration Services. You take your certification from Department of Labor and you file it with the USCIS. If you're approved, then you can move on to Department of State and file for the actual visas. There are more steps, such as recruitment, involved in the Department of Labor step before you get your certification, but we'll kind of delve into that a little bit later when we talk about recruitment and things like that. So there are a few more steps involved with Department of Labor before you get to USCIS, But that's kind of in a nutshell the general steps.
Thank you so much, Meagan. Those are really good points to keep in mind, and thank you so much for highlighting, especially the documents required. So thank you so much, folks out there. I know you are excited as well. Thank you so much for joining us. I'll quickly say hello to Tanya and Nishtha, who have commented with their questions. Please stay with us. We are going to take them up a little later. So right now, another question I have for you, Meagan, and that is, how does an employer demonstrate that there are not enough U.S. workers who are able or willing or qualified and available to perform the temporary work as required by the H-2B program?
Sure. So that is what I alluded to a little bit ago with the
Yes.
additional steps that are really happen between filing your temporary labor certification application with Department of Labor before you get certified. There's something called recruitment. At this point, the recruitment, every employer, once they get a notice of acceptance, they will, meaning that the government hasn't asked for any additional documentation, the government could issue what's called a notice of deficiency asking for more information. But if they don't do that, you get a notice of acceptance and then starts recruitment. The recruitment process is how the government essentially asks each employer to test the U.S. labor market to ensure there are no qualified U.S. applicants who can fill these roles. The recruitment period lasts 15 business days for most of these steps. However, every employer still beyond this recruitment period, at the close of which, at the end of the 15 calendar days, the employer will file a recruitment report which details every U.S. applicant, how they applied, whether or not they were hired, the outcome of that interview, if there was one, if they're able to reach them. Based on that recruitment report, the government will then certify the employer for either the full complement of H-2B workers requested, or they will reduce that number based on how many U.S. hires they make. So if you're asking for 10 H-2B workers and you are able to hire 2 U.S. workers, then you've proven to the government that there are 2 qualified U.S. workers. So your true need is only 8 workers. But in order to get to that process, there are a number of recruitment steps that every employer must take. The first of which is an internal posting notice in their job at the job site. So whether that is a break room or an HR office or a primary office, at least 2 spots at the place of employment must post this H-2B job order. So that would have the terms and conditions of the H-2B position, any job description, title, location, deductions, benefits, all of that information is required in this job order that gets posted at the work site. Now, in addition, that same posting, the same content at least, is posted on the state workforce agency. Every state has a different process for posting jobs that are available to local candidates. Think of it as like Indeed, but it's run by a state. So these postings get put online with the state workforce agency, and every employer must field applicants that are interested in the position. Another required recruitment step is, which again protects U.S. workers, is every prior U.S. worker that employer has had in the past year must get a copy of that job order so that they know they're hiring for that position again. The only exclusion would be workers that were terminated for cause or workers that quit or abandoned the job. So those workers would not get a letter, but other U.S. workers that may have worked seasonally in the past year would be entitled to know that this job is open again. Another item that could be by phone or certified mail is the best way, so the employer is protected and you can prove you've sent it to them, the last known address. Another less common recruitment step is if the employer participates in a collective bargaining agreement, they must publish that job with the CBA representative so that it's advertised across the organization. If the employer has a website or somewhere else internally, an intranet, they normally post jobs, that would also be somewhere that would need to have the job posted. If they have one. If they don't have one, it's not something that they need to create for the purposes of H-2B. It's only if it's normal course of business for them to post jobs in that manner. The last part of recruitment is performed by Department of Labor. Department of Labor will post the job order on seasonaljobs.gov and make it available nationally so that anybody who's looking for H-2B jobs or anybody that's looking for a job it'll come up on a search. So if someone searched landscaping in Richmond, Virginia, it may come up. It would be available on that website. So the last component that is important for U.S. workers is to know is that this job rec, even once that 15 calendar or business days have passed, while it won't impact the number of workers the employer is able to get with H-2B, they do need to continue to accept U.S.-based applicants up until 21 days before the start date. So it's not going to impact their H-2B worker count, but they do still need to field U.S. applicants. They are obligated to do so. Again, the purpose of that is just to ensure that there's no additional opportunity afforded to foreign workers over U.S. workers.
All right. Thank you so much, Meagan, for for the detailed explanation and helping us with the answer for that. Thank you so much. I have this next question for you.
Mhm.
So, what is the current cap on H-2B visas for fiscal year 2025, and how can an employer access the additional supplemental visas announced by DHS?
Sure. The annual quota for H-2B has been 66,000 since the 90s. And it's divided into two halves. The first half of the government fiscal year on October 1st, is allotted 33,000. The second half of the government fiscal year, which opens on April 1st, is also allotted 33,000. The demand far outpaces supply for those initial visas year over year and has for a decade. So in 2017, they started issuing what are called supplemental visas. They are not in the regulations. They're not guaranteed, but the government does have the ability to issue additional visas if they elect to do so, if they can agree to do so. This year, they did announce that they will issue almost 65,000 additional visas for this fiscal year. However, the text is not yet available for the 2025 fiscal year, but if we assume it's the same as the past two fiscal years, which it has been largely the same as far as eligibility and compliance, then we can expect it to be broken down such that a portion of those additional visas will be allocated to the first half of the fiscal year and what they call returning workers. So if you've never had an H-2B, you're not going to qualify for the supplemental visas under returning worker exemption. Those are workers that have had an H-2B at least one time with any employer in the past 3 government fiscal years. So if you have worked for anybody, you would be eligible if your employer wants to file for supplemental visas. So again, that is just a little bit of a security net for employers that miss the initial cap, that they have a second opportunity to try and take advantage of the H-2B visas for this year. There's also an allotment similar to that for the spring. In other words, if you miss the cap for April 1st in the spring, again, if you have workers or know of workers that have had an H-2B at least once in the past 3 years, they would qualify as returning workers. And there will be visas in the spring as well in that same category. Additionally, the spring has another category of returning workers. Typically, that is reserved for late season H-2B employers. So if your start date of need is not April 1st, if it's May 15th or later in the year, there's a separate carve out for supplemental visas in that for returning workers for those dates for those employers. The last option for supplemental visas is what used to be called Northern Triangle. Now it's called country-specific allocation. It is open to workers from a specific set of countries that have never held an H-2B visa, but employers, there's a brand new cap from these supplementals. So if the employer will take recruits from this subset of countries, then there's a whole extra 20,000 visas available to employers who will recruit from these separate countries. Those are Haiti, Honduras, El Salvador, Guatemala. They just added Costa Rica, Ecuador, and Colombia last year. And so I think I might have missed one. Honduras, I think I'm not sure I've said that already, but those countries are a great option for employers who don't have returning workers and have missed the cap. Because the nice thing about that part of the supplemental visas is in the years that they've been offering those, that cap has not been hit to date. As, you know, there's a first year for everything, but those are a more reliable and a little less risky pool of visas to pull from because they have been more open.
All right. So, yes, thank you so much, Megan, for saying that for us also and for the detailed explanation. Well, maybe you could highlight also, how the H2B is different from the other employment visas, for folks out there who want to know where can they categorize themselves.
Right. So, as we know, there's an alphabet soup of non-immigrant visas available. All of them have their own eligibility requirements and stipulations. H2A, those who are going to qualify for H2B probably will qualify for H2A from the worker standpoint. Employer standpoint, that's reserved for agricultural companies, employers that work in the agriculture section. It may be farms that do produce. It just depends. There's a lot of agricultural employers that take advantage of H2A. There are other visas, that so H2A and H2B generally don't require degrees. It's not necessarily true across the board, but it is the only category that's going to have people, without any required specific training. There may be experience or training requirements employer to employer, but overall, if you're from a country that's on the eligible country list, which you can find online, there will be ways for you to get seasonal employment if you don't have a degree. Those are what H2A and H2B are really good for, as far from a worker standpoint or from a prospective visa holder standpoint. There's TN visas if you have a degree that, if you're from Canada or Mexico, there's a whole list of occupations and there's no cap for TN. So if you have a degree and you're from one of those countries, or if you're, an employer looking for a particular occupation that falls on the TN list, that's a great way to, have workers come in that way. TN, there can be some crossover for some of the occupations that are very similar to the kinds of roles that you may want for H2B. For instance, a landscape architect would fall under a TN, or veterinarian or an animal breeder or something like that that's related to farms, but maybe you need someone with more skills, more training.
Right.
So something like that. And there's a whole host of other visas I could go over. I don't know how many of them you'd like me to talk about.
But yes, thank you so much. Thank you so much for highlighting those differences of the H2B and other employment visas. Thank you, Megan.
Sure.
And, Megan, we have a viewer who has joined us. So nice of him. This is George from Nigeria. Really happy that you have joined us. So we would love to take a couple of questions from George if he has any. So Control, if you could just let him in. Yeah, please ask your question. George, are you there?
Yeah, can you hear me?
Yes.
Yes, we can hear you now. Great.
Okay. The question I was gonna ask had to do with you loosening up a little bit regarding your policies. Like I said yesterday, everyone does not have to come to America. Okay. If you if the government actually loosen up a little bit, let's say, just like what you're talking about, they have quarters they're giving for H2B visas. So if you have search for remote, you tell the companies, look, you can get anyone outside of this country. They don't have to come to America, but they're going to be working on the remote basis, right? And before you have to pay their salaries, then do what they call tax deduction from the salaries before you pay out, right? So I think if that would be looked at, it will be a very good idea, because one of the reasons why you have the Americans coming up with several immigration policies is because you have a lot of people.
Can you hear it? I can't hear.
I think, yeah.
Papers or documents are being expired, and then they also want to continue the work. Can you still hear me?
I
Yes.
missed that middle part. I heard that if their documents are expired, but I missed a part.
Hi, can you hear me?
Yes, we can hear you. Could you just repeat the part where just some time back you were saying? George, are you there?
Yeah, I'm
I
here.
think
So,
okay.
did you get what I said?
No, we didn't hear the question part. I'm sorry.
Could you just repeat your question, please? The question you just asked some time back. George, if you're still there.
Yeah, I'm here.
So sorry, we couldn't get your question. Could you just tell us what your question was?
Okay, the question is, can American government look at, loosening up a little bit and allowing companies, independent companies, actually employ people from other countries without they coming to America, and the American government providing some sort of tax identification number for remote workers. I think if you encourage that, that would actually strengthen the job quality you have over there, and also
The government here in the U.S. has been very apprehensive about changing policy. I mean, like I said, just in my experience with H2B, the quotas have not changed since the 90s. So while there may be many ideas that would be beneficial to both the U.S. economy and workers abroad, I would not expect there to be any meaningful change or positive additions to immigration, particularly with the upcoming administration change. I would not expect that to happen right now. That's not to say it would never happen, but I wouldn't expect a tremendous amount of change, at this point. There are many other countries that allow, such as things like digital nomad visas, where they can come work remotely from their home country in the U.S. and do things like that. We don't have anything like that here. Our immigration categories have been fairly static for quite a long time. We have not had comprehensive immigration reform since the 90s. And with the polarization of this topic overall, from an employment and family-based side, I just would not expect there to be any change. There may be many great ideas that people could bring to the table, but adoption or passage of that would be very difficult in this climate.
Thank you so much for taking that up. And George, do you have any other questions? George, are you still there? All right. Thank you so much, Megan, for taking that up for George. I think there might be some network issue, but I hope George got the answer he was looking for.
Sure.
And if he has any further questions, I'm sure George will drop them in the comments or maybe rejoin us soon. Meanwhile, I think let's take up Tanya's question. I run a small landscaping business and want to hire workers for our busiest season. How do I start the process of sponsoring workers under the H2B visa? And are there specific forms or steps I need to prioritize? I think we touched on this earlier already, but if you could just highlight, anything.
Yes. If it's landscaping, I would assume your busiest season would fall in the spring. So at this point, the first step is starting to file a prevailing wage application with Department of Labor. That's the very first step required, no matter where you're filing, what position you're filing. So you just need to know what position you're filing for and get that application lodged with the government. You can't move on to any other step if you don't do that first. So you should find someone that can file that for you. I have a great number of landscaping clients. So I'm very familiar with that process from start to finish. At this point being mid to late November, it would be very tight to try and get that filed for next spring. Unfortunately, it's not impossible, but timing would really have to work out in your favor. That's the first thing you need to prioritize. And if the only other thing I can say that is if you have workers you want from a particular country, make sure they're on the country list. I get a lot of questions that say they know somebody from X country and that country is not eligible for H2B at all. So if you're wedded to one particular person, make sure that they qualify before you bother starting the process.
Great. Thank you so much for taking that up for Tanya, Meagan. Thank you so much, Tanya, for participating with your question. And I have more questions lined up, but let's take up Nishta's question first. I've worked under an H2A visa before. Can I apply for H2B visa next, or do I need to wait for a certain period of time before reapplying? Uh, And how soon can I reapply for an H2 visa after my current one expires? Is there a limit or on how many times I can apply?
Mm-hmm. Okay. So the answer is it depends. For part of that. So if you have been on an H2A visa, whether or not you can apply for the H2B visa, it just depends on how long you were here on the H2A visa. So one of the eligibility requirements for H2 workers, whether that's H2B or A, you have up to 3 years of H eligibility, at which point if you enter, say, January 1st, 2020, then your H authorization would have expired in January 2023. So you have 3 full years of eligibility. You can reset that by, if you've been outside the US for 3 consecutive months, then you reset your H time and you get another 3 years. So there's no limit to the number of times you can be on an H2 visa, A or B, but there are time limits for each stay. So if you were to come in, like I said, say April 1st, and you change employers, so you're never out of the country for more than 3 months, then you're going to be limited to 3 years. And at some point during that 3 years, you need to reset. You need to be outside of the US for 3 months to get more H time. And that, you can certainly have an H2A visa, go home, get an H2B visa, and come back. That's fine. You can do both. There's nothing to preclude you from participating in both programs. You just need to make sure you're aware of what your limit is and make sure that you've been out to reset that clock at least for 3 months if you're here for that long.
Okay. Thank you so much for taking that up for Nishta and for the detailed explanation, Meagan. And now we have Samuel. Samuel is on YouTube. He also has a question asking administrative processing in H1B visa for 9 months. What can be the cause?
There is not very much transparency for administrative processing. For instance, if I, as the attorney, email the consulate and ask, why is this an administrative processing? What do you need from me? What do you need for the worker? They will give me a canned response that just says it's an administrative processing and we'll contact you if we need anything. There could be a whole host of reasons why you might be administrative processing. Your name, it could be something as simple as your name is similar to someone who has some overstay issues or a travel issue or is on a list somewhere, flagged in the system. It could be that you've overstayed. It could be that they're unsure of your intent to return home. That's called, immigrant intent. They could be questioning whether or not you will stay permanently if you're issued the visa. There's a whole number of reasons that we'll probably never know the answer to, unfortunately. For instance, I just had someone try to process in South Korea, and she has no red flags. She's no criminal history, no one prior U.S. visit. There's nothing on paper that should have precluded her from being issued a visa, but she was put in administrative processing briefly, and then, certainly not 9 months. But the reason they gave ultimately for being refused was that they questioned whether or not she would return to her home country at the end of the visa. There's the consular officers are given a great bit of discretion to review the applications, and they don't give us a lot of transparency. I said South Korea for that process. So, there can be and this would come up from any country, anybody from any country on the eligible list. And sometimes there's a surprise like that. For instance, that client, it was a surprise to have that happen. There were no indications prior to going to that interview that there would be any issues. So I wish there was some way to find out why you're in administrative processing.
Right.
But there's not very many good ways to do it.
All right. Thank you so much. Thank you so much for taking that up for Samuel. Samuel, if you have any further questions, you can keep commenting and we'll be addressing them very, very soon. Thank you. And now let's take up Mukesh's question. This is also on YouTube. He asks, if our company hires an H2 worker who doesn't show up, what are our obligations and potential liabilities? And what happens if an H2 worker gets injured on the job? Are we liable?
So I'll take up the first part of the question first. So if you have H2 workers and someone disappears, they abscond. If they have, that's typically if they haven't reported to work for 5 days, they have been non-responsive, they're AWOL, they've been absent without leave for at least 5 days. You can report them as an abscondment. So, and you are required to report them if you know they're not coming back. For instance, if they've quit or left in some way, and they're not coming back, and you haven't given them permission to leave. People leave all the time, but your obligation as an employer is within 2 days of knowing that they're not coming back. So they told you they weren't coming back, or it's been 5 or more days, and they haven't reported to work. No one knows where they are. You can assume that they've absconded. You have to report the departure to the government. You have to report it to Department of Labor, and you have to report it to Immigration Services. That will insulate the company from being on the hook for the 3-quarter guarantee when the worker's not there. So that's one of the compliance requirements. We didn't get a chance to get into those today. But on the employer side, one of the requirements is the 3-quarter guarantee, meaning that it's a full-time position, 35 hours or more. Mm-hmm. You have to, as an employer, offer them at least 3/4 of those hours offered, whether you say it's 35 hours or 40 hours. If you have to report them as missing or absconded, or if you fire them, you still have to report them as an early departure. It's one of the compliance requirements is to report a missing worker. As far as workplace injury, that falls outside of the scope of immigration, and it's going to be based on your state law, whatever your state workman's comp is. You would be liable in the same fashion as you would a U.S. worker. So if would be liable for workman's comp for a U.S. worker, it's going to apply for an H2 worker. Now, on the worker side of that, if they're injured on the job and need surgery and can't travel and the end of their visa is coming, they need to look at changing it from an H2 visa to a B visa, a visitor visa, and do a change of status so that they're not here unlawfully on the H2 because they're no longer working. So it comes up in rare cases, but yes, if someone's injured, they need to make sure, and they can't travel home for treatment, we have to be able to make sure they stay in status.
Right. Thank you so much, Meagan, for highlighting and for giving us such important points today. And thank you for also taking up Mukesh's questions at the same time. Thank you, Mukesh, and you can keep commenting if you have more questions. Now, coming back to our questions, Meagan, I have another question, and that is, what are the robust protections in place for both American and foreign workers, under the H2B program, and how must employers ensure that these protections are met?
Right. So there's many protections for both U.S. and foreign workers. On the U.S. side, there's basically it boils down to making sure that a possible U.S. worker is not treated in any less fairly or afforded any fewer opportunities or no more requirements than would be required of a U.S. worker. For instance, if you're filing a landscaping position, a corresponding worker couldn't be required in the U.S. to have 5 years experience when you require 0 experience for a foreign worker. So, each business, when they file the application with the Department of Labor, has to sign an attestation with all these compliance requirements listed, noting that they understand what those requirements are and that they will abide by them while they're participating in the program. Now, workers, to start out with, for corresponding workers or foreign workers, they should get before they start, or if they're a corresponding worker and they already be working, because that could be a worker that's worked for a year or less with the same employer. So again, corresponding worker means it's a U.S. worker either present, already working, or one that you hire during the recruitment process that performs substantially similar duties, same job. That would not be your secretary or your landscape manager if you're coming in as a groundskeeper. If you're just doing a landscape laborer job, corresponding workers on the U.S. side would be the same position, not something that's unrelated. So again, the employer can't impose any requirements or obligations they wouldn't impose on the H-2B worker, and they also, have to pay them at least the same as they're paying the H-2 worker. Now, anyone in the H-2B process, which is going to apply to corresponding workers as well as H-2B, because if you have H-2B, then you have corresponding workers more than likely. A big component is prevailing wage. That prevailing wage is the first step. I talked about the employer process, but it's important for the workers because when you get the terms and conditions of employment before you start, which tells you what kind of job you're applying for, where it is, who you're working for, what the wages are, whether or not there's overtime, what benefits are included, all of that is given to you. So you can track it. You can make sure you're being paid what you should be. And that includes the prevailing wage. Every position is set by the government, and you have to at least make the H-2B prevailing wage. So you get that protection. Also, in H-2B, you're going to need to be paid at least every 2 weeks. They can't pay you once a month. There has to be regular paychecks. It's another requirement. On that same note, every employer is required to provide you with a pay stub, which provides you with the hours offered and the hours worked, the pay rate, overtime rate for every pay period. So that should be something that you get. Also, deductions. Unlike H-2A, which does not have to have with tax withholdings on it, H-2B does have tax withholding. So your federal taxes and Social Security withholdings are withheld from your paycheck as required by law. But any other deduction aside from those lawful, required deductions, the employer has to have your approval to deduct it. So if you, one difference between H-2A and H-2B is that H-2A housing is provided, H-2B, the worker is responsible for their own housing. That being said, some employers will give workers the option to stay in employer housing, which means you pay fair market rent and utilities. If you are opting into that as a worker, you have to either pay the employer directly, or you can have it withheld from your paycheck. So things like that, health insurance, rent, utilities. Let's see, what's another common one? Loans, things like that could be a deduction on your paycheck need to be approved by you. And they need to be on your pay stub so that you can see what the deduction is. So, you just need to know what's coming out of your check, and you're entitled to know that. I talked a little bit earlier about the 3-quarter guarantee on the employer side. It's another thing for employees is that H-2B is a full-time role. If you are offered 35 hours on your contract, you are entitled to at least 3/4 of those. If you're offered 40 hours, you need to be offered at least 32 hours, so you've got some minimum protections to make sure you're not doing nothing. You're getting paid for the work that you expected to be here to perform. And if they don't have enough work, there's still required to pay you for it if it's rained, and it goes for every 12-week period. So there's a calculation for that you can look up. The employer should be aware of. That's an important guarantee to make sure you're paid as the contract says. Another important item that comes up is tools and equipment. There's no reason you should be charged for tools and equipment. That the employer provides all tools and equipment to perform the job. So that should not be something that happens. Another important note for protection for workers is visa fees. There's under no circumstance should the worker be paying for visa fees. You may pay them at the consulate. Some employers will do that, but you have to be reimbursed the first work week when you get here. Inbound travel, also something that is covered by the employer as part of the H2B program. That one is most employers will prepay it for you. Some may pay it when you get here. The regulatory requirement is that as long as you stay, you have to stay for half the employment contract to get the inbound transportation. But with federal wage requirements, a lot of times they just pay that with your visa fees up front because they can't take you below the federally mandated minimum wage by virtue of withholding that, by not having you reimbursing that travel. So the bulk of you will have your travel reimbursed when you get here, if not prepaid. Same thing, if you complete your contract, you do not leave early, you're not terminated, you're entitled to have the employer cover your return transportation. So you finish the work contract at the end of the season, your employer is responsible for sending you back to your point of origin. So that wherever country you came from, you get travel reimbursement back to your home. Very important. Same thing if you're terminated, you still get return transportation. The only time you don't get return transportation is if you quit early, or if you transfer to another H2 employer, then that new employer is responsible for paying your travel to the new employment site. So those are very important. Another very important thing that workers should know, and this comes up not in the employer context, it is an employer compliance requirement. Employers should sign something if they're using a recruiter, the employer should have something signed that the recruiter says that they're not going to charge workers a fee. No H2B worker should pay an employer or a recruiter a fee to be referred to H2B. Very important. It's not something that you should be responsible for. And violations for this, there are audits from Department of Labor, there are site visits, inspections. Employers are required to maintain an audit file with all of this documentation, copies of your pay stubs, copies of reimbursements. The employer should have copies of all of this. And workers also, there should be an H2B rights poster that the employer posts in the work site. That also will have details on how you can whistleblow, how you can report it. There's anti-retaliation components as well, so that the employer can't retaliate if you report wrongdoing or mistreatment.
Wow. Those are, a great number of protection rights and laws and rules and regulations you highlighted. And thank you so much, Meagan. I think once you have the passion to work and you have the right documents and you're on the right path, I think nothing can stop you.
Right.
So thank you, Meagan. And we have Samuel who's back with another question. I think we should take that up. He's asking, can my spouse, who is my dependent on an H1B visa that is in administrative processing, apply for a visiting visa?
There's nothing to preclude her from doing so. But again, there's very little transparency into that application process. So, it's possible for a spouse to also be put in administrative processing for anybody can be put in administrative processing for any visa, for them to review it. But there's nothing, just because you have a visa pending, that also doesn't mean she couldn't apply for her own H1B, her own visitor visa. There's nothing to preclude, again, assuming she's eligible or can qualify. Your being in administrative processing isn't going to prevent her from doing something else. Even if she's on an H4, she could still theoretically apply for a visitor visa. Whether or not it's approved, is anybody's guess.
That's cool. Thank you so much for taking that up. And Samuel, I hope you've got your answer. Thank you for participating. I have another question, Megan, and that is, how does the H2B program ensure that foreign workers are not exploited by the employers?
Right. So that a lot of the same things will apply from the compliance requirements. All of those compliance requirements are in place so that workers are not exploited. You have a prevailing wage to ensure the worker is not paid too little. There's, again, reporting opportunities with Department of Labor to report employers that are, misusing the program, so that your protections remain in place. There's also, depending on your state, there may be nonprofit or volunteer groups that can also provide services to help if you are, being subject to mistreatment. So, all of these protections and compliance requirements that you should be entitled to, they can be enforced in the same way. Though you can report them and they can be subject to penalties for that. And I don't know if we'll get to the penalty question or whether I should cover that here, but there are penalties that the employer can suffer based on that, depending on what the violation is. Again, the anti-retaliation requirements are important for that. Workers can file a complaint with the Wage and Hour Division with Department of Labor for any of those violations, for being charged a fee, not making your hours, not being paid the correct wage, being denied. Again, another thing that doesn't come up often, but when there's severe negligence or mistreatment of workers, another thing you should report absolutely is if your employer is holding your passport. Your employer should not have your passport or your visa. You should have free autonomy to leave at any time. Be aware of as a worker, the terms and conditions of your visa, and make sure you're not, by leaving, having an issue with your status because you're no longer at the employer. So, there are things to consider for that, but it shouldn't deter you from reporting mistreatment.
Right.
I don't know if you want to jump ahead to the repercussions for employers. I know that's another question, or if I should just get to that later.
Yes, we could get to that a little later, or maybe in our next episode as well, because there's so much to talk about H2B. But I would also like to tell our folks out there, that it's always best to consult an attorney and be guided with your case, because every case is different and needs proper attention. And I would say, why not contact attorney Meagan Kirchner in her number, and her number is 434-226-0586. You can note it down. You can also email Meagan. Her email address is meagan@kircherimmigration.com. You can check out the spelling on the screen and go visit www.kircherimmigration.com to get to know more about Meagan. Thank you so much, Meagan. It was really great. But of course, so much to talk about this. I think we should definitely do another episode on H2A and H2B visas again.
Sure. Be happy to.
Yeah. But before we go, what do you have to say about Trump and, starting 2025? What can we expect maybe, or what do you think the immigration scene is going to look like?
I was just at a conference in DC with other immigration attorneys on Friday, and we're all just ready to buckle up for the ride. H2 in particular was a little more insulated from some of the trials and tribulations that came from the administration last time. A lot of the other employment visas, family-based visas, are going to have much tighter scrutiny. Requirements may change. It's going to be more difficult. Again, I know you mentioned a lot of people file on their own, but particularly with this administration change, having an attorney navigate the process will be more important than ever, because it's going to change, and it will change quickly, and more than likely not in any way that makes it easier.
I know everybody is so anxious, and I really hope that, things fall in place as soon as possible, or at least folks out there get to know what can happen or what may happen with their case. So thank you so much, Meagan, once again. It was great having you, and I really hope to see you in the coming week.
Nice to be here, and thank you for having me. And best of luck to everyone watching, and reach out if they have any questions.
Yes, absolutely. Thank you so much. And also Samuel, and then we had George who had joined us. Unfortunately, the line was a little disturbing, but I still hope that, George, if you have any further questions, you can comment, because after the stream has ended, this is going to be published, and it'll be really nice to have you comment with your question. And I'm sure, Meagan, you can address that. I will I will put that up to you.
Yeah,
You do.
sure.
Yeah. Anything else you want to say to the folks out there with regard to the topic before we leave them? Because I feel like we're just ending it so abruptly right now.
Yes, where this is just the tip of the iceberg for the H2 world. I wasn't really able to dive in at a really granular level as far as what employers need to do, how long it takes.
Yes.
So I really just want everybody to know that it can be a long process, but with the right help, and starting at the right time, it doesn't have to be a painful process, as long as you start. But their timelines are critical for this program.
Right, right. Thank you so much for that hopeful note and an end note. Thank you, Meagan. And you have a splendid week ahead, and I'll see you soon.
You as well. Thank you.
Thank you. And folks out there, thank you so much for joining us on YouTube, LinkedIn, Facebook, and Twitter. It was really nice having you, and especially with your questions in the comments. So feel free to like, share, and also subscribe to our channel. Hit that bell icon so that whenever we have discussions like these, you are notified. And really, I'm also looking forward for Meagan to join us again in the coming week, because there's so much to discuss about H2 visa, and I'm sure you too have a lot more questions. So thank you so much for doing this today, and don't go anywhere, because we have more webinars and discussions lined up on immigration and job.
Hello, everyone, and welcome to Immigration and Jobs Talk Show. I'm your host, Sam, and before moving ahead, let me read out this very important disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. So, use of information is at your own risk. All right, after this important disclaimer, once again, welcome back everyone to Immigration and Jobs Talk Show. And today our topic is NIW for Indian nationals. A smart move. But is it the best path to a green card? So, today we are going to explore all the essential details that you need to know, from the exciting benefits to the challenges you might face along the way. And to help us explore about this topic, provide expert guidance, we have a very special guest joining with us today, Daniel Stephen Larson. Hello, Daniel. How are you? And
Hey,
yeah, hi, Daniel. How are you?
hey, I'm doing very well. It's
Thank you,
yeah,
Daniel. And
greetings
it's
from
a pleasure.
California.
Yeah, it's a pleasure having you, Daniel. So, Daniel, why don't you go ahead and, have this moment to introduce yourself and share a bit about your background and experience in immigration law?
Sure. Yeah, my name is Daniel Stephen Larson, and I founded Larson Legal, my law firm that's focused on self-sponsored cases for talented individuals from all over the world. So I primarily handle national interest waivers, EB1As, O1s, some TNs, and other categories that come into play. I've worked in the immigration law space for over 10 years. I was an associate attorney with the law office of Nathan Waxman in New York City. And I helped him work on, prepare the national interest waivers for years and hundreds of cases, hundreds and hundreds of cases. So I feel very comfortable in this space. It's what I primarily do. And yeah, it's something I find very rewarding. I get to meet individuals from or meet and clients in all sorts of different professions, all sorts of different fields, the diverse array of talented and extraordinary professionals and all from all over the world. So.
Wow,
Yeah.
that's great. That's a great intro, I would say. And Daniel, it's a really pleasure for us having you with us on today's show. And really, I'm really excited for today's episode. So, Daniel, before jumping into our today's topic, I would like to have your point of view, your thoughts about Trump's administration. So, according to you, what do you see? I mean, what will be the future of US?
Yes. So, of course, as I mentioned earlier in our introduction, that I am a liberal Democrat, have for my whole life, and of course, I have viewed Trump skeptically, and I remembered his administration the first time. I think that in the area that I practice in, these self-sponsored cases like national interest waivers, EB1A, also O1s. I think that the influence of Trump isn't necessarily going to happen on the in the adjudication of the cases. I don't think that the standards will change. I think that we will see some issues is backlogs of adjudicating adjustments of status, so that there's probably more likely to be a lot of vetting. That's what happened the last time Trump was in charge. That things like the public charge rule, there's going to be security checks, things like that of that nature. But the actual adjudication of the merits-based portions of these cases, I think, will probably be pretty much the same. I think that Trump is probably more focused on the border, reforming, or his plan for mass deportation, things like that, versus the self-sponsored cases that I work on.
So, Daniel, as also we all are very much aware about mass deportation. So, do you think that it is practically possible for Trump and for anyone, to have this mass deportation? Is it really
Well,
possible?
I'm not an expert on this particular area, but my opinion here in California, I think that I personally think that the American people, when they see these, if there is a real mass deportation movement, that it will disturb the American people, and when there's pictures of people being rounded up or something like that, that will cause a backlash, and they will stop, or that's my personal opinion about it. But I don't know. I think that it's the appetite that, at least from my perspective, there is it's unfortunate to me, because I find that it'd be very troubling if that happened, if there was a true mass movement. I'm hoping that doesn't happen, but
Well,
we'll
yeah,
see.
we all are just
Yeah.
looking for it, and we are just hoping for whatever happens for the best. So I don't know
Right.
how Trump is going to have his another Trump 2.0 era. Well, anyways, thank you so much, Daniel, for your answer. And Daniel,
Yeah.
we also
Oh,
share. Yeah.
sorry. One thing that I really would like to say about Trump and things. A lot of people, assume that Trump can just change the law automatically, very quickly. That's not the case at all. The regulatory to change the immigration laws as they are set is a very, very complex process.
Yeah.
Of regulatory reform, a regulatory change, and the Trump administration. If you note that, the first time they were in, they had a hard time doing things like they were trying to remove work authorization for H4, with approved I-140s. That never happened because they were too slow, and the process was too complex. So I think that they're probably going to have more experienced people now, but the actual process to change the way the law works in the United States is very, very arduous and complex, and I think people should remember that when they think of Trump. We are still a country of laws, and yeah. But these executive orders, I think that it does that's the area where there could be
Right, right.
lots of.
All right. Correct. So, Daniel, what can you say for NIW? I mean, obviously, we all know that it's a smart move. That could be best part to a green card. So, do you think that if Trump is going to handle everything and if he is taking everything under his control, so there might be a chance where he would, limit or stop the NIW?
Well, I think as I was discussing, there's been a massive in the last couple of years because of the perm processing times. There's been a massive boom in national interest waiver filings because people want to avoid going with the Department of the DOL, the Department of Labor, and skip a step. So with this huge boom in cases, I'm actually very worried that the adjudicators are flooded with inappropriate cases or cases that historically would have never been filed for national interest waiver. Things like a yoga instructor or a teacher or all these professions that we wouldn't normally think of as being nationally important and they're now utilizing because of the huge delays in the perm cases. So that's the part that I'm actually concerned about, and it's already happened a little bit, that the way that the cases are adjudicated, in my mind, I've gotten some requests for evidences where there's a lot of focus on like the economic impact of the individual petitioner, and usually that's not what NIW is about. It's not a business visa like an E2 where you have a business plan historically. But things have been changing recently, and so that's I've been seeing more of that.
Exactly.
Yeah.
So, Daniel, how many clients do you usually get for NIW, especially for?
I have probably a caseload right now. I have about 30 or 40 NIW cases in the pipeline. Like at various stages.
Right.
And I have to ask my client, my assistant, the exact count. But the cases, I don't have an extremely high volume office. I have I would say like a medium volume, and the NIW is a very, very collaborative process with the client. Each case is different. Even though you can, like some of the researchers, you can just present it in a very formulaic way. You really need to understand what's going on with the case and their accomplishments, and to see what's the best angle for NIWs. The narrative. These cases are very narrative. Based on narrative, like what you're telling a story. What is the client's story, and how do they benefit the larger field?
Right, absolutely. So, Daniel, what can you say? Let's begin with our very first question of today's topic. That is, what are the primary benefits of applying for a national interest waiver under the EB2 category, especially for Indian nationals who might face long wait times in other green card categories?
Well, one of the biggest benefits that I can think of for Indian nationals to file for a national interest waiver is a national interest waiver is a self-sponsored petition. You can control that you're not under your employer's thumb, and it's completely your petition. So if you get the national interest waiver approved, you can preserve the priority date, and then at a later date, if you are eligible for EB1A, B, or C, you can apply. You can use that date, that priority date, and you're locked in, and you can hopefully file your adjustment. So that's what's happened for me in several EB1A cases that my clients have had approved I-140s before. So if your employer is wavering on their on whether to sponsor you for a green card, you can just do it yourself, and you can get that. You can lock in that date. That date is tremendously beneficial, and it's so wonderful that you can take that priority date and use it for a subsequent case, so that you're not, stuck in a,
Yeah.
yeah.
All
Also, the another thing is like I tend to my Indian clients tend to be married, and their spouse. If you have an approved I-140, the spouse can get work authorization through with the H4. Generally speaking, a lot of my clients are on H1B, and then their spouse maybe has their own, or they might want to consider if they change employment, to go on the H4. There's so those are the big benefits that I see. Besides,
right.
yeah.
All right. Okay. Thank you so much, Daniel, for your answer. And moving ahead, I would also like to ask, if we talk about the process of applying for NIW. So how does the process of applying for an NIW differ from the traditional employer-sponsored green card process? And what are the time-saving advantages?
Okay, so here's how the NIW works at least when I handle the cases. I usually ask the clients to fill out questionnaires about, describing their field, and then potential lists of supporters, and trying to isolate the nexus between the supporter and the client. When we file the NIW takes, I would say, from when I'm retained to when it's filed, it takes 1 to 2 months to send out a case, maybe longer, maybe shorter, depending on how interactive and how engaged the client is in this process. Most of the time is spent working on the letters of support. The letters of support usually are 1 to 2 pages long. I usually submit between 4 to 7 letters of support in each case. And then, I gather all of the clients' documentation that they have. They show that they've influenced the field in some way. So like if they've published papers, if they have given professional presentations, if they have... if they have relevant work samples that show the complexity and the importance and impact of their work, I will submit those. And then, each one of the wonderful things about national interest waiver, which is completely different, and it's much more liberating than some of the other standards. With EB1A and O1, you have set evidentiary criteria, a list of, things like you have a high compensation, you've made an original significant contribution to your field, you have publications, set evidentiary criteria that they use. But for national interest waiver, there's no such things like that. It's all based on the Donasar case. So I think that how this differs, it's just much more free. You can take almost any relevant evidence and submit it to show that you've made an impact on your field, to show that you've made an impact in your field. How this differs, this is very, very different than the traditional perm process of, getting, the wages and the Department of Labor, and which is a very passive process, where the company, and then the advertising of the company with recruitment and advertising, where the client isn't really involved at all. It's usually the HR and the immigration attorney are working through this stuff. And with the NIW, it's very client focused, that it's all about that client. So we're constantly talking to them to see if there's other relevant evidence, if there's somebody else we can get, and stuff like that. Yeah.
Right, absolutely. So, Daniel, as you also mentioned about the evidence. So, my next question would be with what types of evidence are typically required to support an NIW application, such as an expert advisory letters, awards, and publications? How can an applicant strengthen their case with this?
Okay, so it depends on what type of client you're dealing with, but I tend to look for almost any evidence the client has told others about the importance and impact of their work. So if they publish articles about their work, I want to gather that. If they have done professional training, training of others, like they've created training programs, and they've given. I've had many cases based on that, and so. And if they have, professional presentations at major conferences in their field, I'd like to document that as well. The idea is that, like, whatever evidence shows that your client is not just impacting his employer, impacting his things, that he's impacting the larger field, larger field. That's what drives these cases. So, like, you can, depending on the client, you could have a client that has it doesn't have to be publications. They could be TV interviews or YouTube interviews, there's just a million types of evidence that you could use, So I think that, like, in general, I usually submit, as I said before, I submit 4 to 7 letters of support, but that's not the case in every case. You can submit 2 letters if you have a strong case. You could submit. I think it's redundant after 7 letters to things, but then I gather these publications, whatever evidence they have that shows that they've worked outside of their that they've benefited a larger field, and I try to divorce my clients from. A lot of my clients are employed, and I try to divorce them from their employer. That they could be, they could work on a national interest waiver, completely outside of, like the whoever their employer is right now. That's not, yeah.
All right, that's great. And Daniel, also, I would like to ask that, can you explain the 4 main requirements to qualify for an
Oh, okay.
EW?
Yeah, so this is how it works. So when you file a national interest waiver, the first thing that you do is that you show whether you are an advanced degree professional, meaning that you have a U.S. master's or foreign equivalent or above, or you have a bachelor's degree and 5 years of progressive work experience. Okay. If you show that that's the first thing. And most of my clients from India tend to have a degree. Usually they have a degree. But you don't have to have a degree. If you don't have a degree, you have to go through the exceptional ability standards, which is a little bit harder to go through. With a degree, either a bachelor's or a master, either a bachelor's and 5 years of progressive experience. It's like checking off a box. You can just submit that information, and then you're good to go. You don't have to do a lot of analysis. Exceptional ability, you need to show, like, for example, you show that, like, they're in distinguished organizations, and it's a pretty arduous test. I haven't done it recently. But most of my clients meet the advanced degree professional test.
So, Daniel, what about the bachelor's degree? I mean, obviously we know the master's and the PhD, they will get a good thing. I mean, easily NIW. So, what's about the bachelor's degree? And if they have significant work experience, then also they are able to qualify for NIW?
Yeah, absolutely. If you have a bachelor's degree in a related field to what it's things, and you have work experience, that's enough. That's to be an advanced degree professional. It's the same as if you had a U.S. master's or a PhD. One thing I want to stress to a lot of people is that, like, people ask me, like, do you need to have a PhD? Do you need to have, like, a degree awarded? No. It's not all that relevant. It's more documenting. It's a flexible standard so that, like, we can have people all sorts of talented individuals apply for this. But you need to show that you've impacted the field. That's the key. Yeah, and then you have to go through the 3 Donisar prongs. That's the we do the exceptional ability, advanced degree professional. That's the first part, and then you go the 1, 2, 3 Dhanasar prongs.
All right, all right.
Yeah.
So thank you so much, Daniel, for your answers. I think these are very clear and very to the point answers. So moving ahead, I would also like to ask Daniel that how have recent changes in immigration policies, like availability of premium processing for EB2 and IW applicants,
Yeah.
impacted application process and timelines?
So the rise of I welcome premium processing in the national interest waiver space. I think right now probably about 80-90% of my clients use premium processing. When I tell, and I just had a couple clients recently who said, you know what, who waited for 10 months for a case to be approved they got the money together and for the premium processing.
Mm-hmm.
I tend to I appreciate that it's available. I don't think these days it's I haven't seen many cases without it, so it's a little bit hard to say if premium processing makes a difference for the actual adjudication of the case. I don't think or if there's a more likelihood of a request for evidence. I never, I don't believe that it does, result in more requests for evidence. But that's anecdotally. I don't have firm data either way.
Okay.
But in premium processing, it's what the clients expect and want right now these days.
Right, right. Okay, so Daniel, as we move ahead with Form I-140, I would also like to ask that what are the steps involved in filing an NIW application from submitting Form I-140 to obtaining a green card? And what are the typical processing times for each?
Okay,
Yeah.
so here's how it works. So you fill out Form I-140, and then there's an antiquated form called ETA 70B. It's an old Department of Labor form. It's not been updated, but it's mentioned in the regs. So you need to file. You can file that one. It's an easier form than the 9089. And when you submit the national interest waiver, you gather the whole case together. You get your letters of support. You get your evidence that the client has made an original significant contribution to their field, or evidence that they have influenced their field, so publications, citations, presentations, maybe relevant work samples. I usually get also, in addition, I will get a personal statement or a professional plan of their future endeavor that outlines what they're going to be doing. And I like to outline, I like to direct it when appropriate to have my clients say that they're going to continue to do research. That tends to be an easier direction if that's what they truly want to do, versus when the ones that say they want to start a business, that opens a can of worms of it makes it more like an E2, which is a business oriented case. And I just think that it's most of my clients are not actually ready to do that, ready to start a business. They're employed, so I tend to shy away from that and focus more on research when I can. So you send it, you gather all the case together, you send it all in one big package. You use premium processing. What happens? You wait 45 days until, if you use premium processing, you wait 45 days. If you don't use premium processing, you wait maybe 10 months, 11 months. You're either the next step is that you'll either get an approval or a request for additional evidence. The approval, and very, very good cases. I just want to say this, I wish I could just control if you get a request for evidence or not, but we try to avoid it. But it's just part of this practice. It's part of the business that the service just arbitrarily issues requests for evidence, in my opinion. It's just you gotta be ready to respond if you do get a request for evidence. Usually the response entails getting letters of additional letters of support and any media that wasn't mentioned or projects to explain the case. Yeah.
All right, all right. So I can see that Daniel has so much information to deliver it to our viewers. So I think that's great. And Daniel, also we have few of our viewers who has joined today's episode. So
Sure.
thank you, Geeta.
Hello. Uh-oh. Hello.
Yeah, I'm here.
Okay. Cool.
Oh yeah, I'm so sorry. I don't know. Maybe some internet issue might be there, but I think you can hear me now, right?
I
Properly.
can hear you perfectly.
All right. All right. Okay. So, yeah, Daniel, I was saying that, there are so many people who has joined us, Geeta, Amzad, then Santosh, Ansa also I can see. So, okay, let's take up first question from Ansa.
Okay.
So, Ansa is asking that does a master's degree holder need 5 years of experience to be qualified for NIW?
No, a master's degree. If you have a U.S., if it's determined by an eval the agency to be equivalent to a U.S. master's, you can just go from there. You don't need 5 years of work experience.
All right.
You're already an advanced degrees professional, and then you can move on to the 3 Donasar prongs. Yeah.
Okay, all right. So, Ansa, also, if you have any follow up or any question, you can please go ahead and post. And I think you have posted one more, so I'm taking this one as well. And Ansa, another question is Daniel that I completed a master's degree in the US in clinical mental health counseling, completed OBT, and I'm on H1B with the same company. How soon can my company apply for a green card on my behalf?
Well, they could apply for a green card. They don't have to use a national interest waiver. They could, they can apply right now. For you. Actually, that's one of the things that one of the reasons why I get cases for things is that there's a lot of employers that are hesitant to file a perm case because it's expensive, it's time consuming, and maybe they don't even know how to do it. That's a huge issue.
Right.
So there's so many companies in America that they have no idea anything about immigration. They don't know nothing, and so or they've never hired an immigrant, and now sometimes they will, and so one of the reasons why I get business is that often my clients are at an employer that is inexperienced, so they don't know how to do it, or they don't feel confident in their their lawyers that they're working for them. I work on the client's behalf, not on behalf of companies. So it's a different kind of orientation. Yeah.
Exactly. Okay, so thank you, Ansa, for your question. And next up, Daniel, we are going to take Geeta's question. So
Sure.
Geeta is asking that how does the processing time for an NIW compare to a regular EB2 application? Could pursuing both simultaneously improve my chances of getting a green card faster?
Excellent question. Yes. Okay. So one of the major questions I get is, can an employer sponsor my green card using the PERM process, the EB2 process? And could I also have an NIW simultaneously? The answer is yes, you can. They're not the petition. The NIW is your personal petition. I actually it doesn't have to be, but I like to make it the personal petition. Whereas the PERM is, initiated by the company. They own that, that petition, and then you are the beneficiary of the petition. I would say that I think, I don't handle that many perm cases, but my understanding is that it's taking 2 to 3 years these days to get the to get things through the process. Whereas an NIW, you can get an I-140 approval, in 6 months or 3 months, like depending on how good of a case you have, and so it gives you that benefit of the things. Now, again, you're still subject to the backlog. Everybody in the world is now, but and Indian nationals have the worst backlog of any group, but it's still like you get that I-140 approved very quickly, relative to the other methods.
All right. So, Daniel, I just want to ask that what is the average approval rate for EB2 and IW applications?
Okay, so historically, I would say it's been shown. I saw it at the AILA conference. It's a 90+%.
Wow.
For NIWs. It's a great category, and there's one of the reasons why people love it. To use it because it actually works. Now,
Easiest way.
but there's a problem. I would say that right now, there's been so much a flooding of the cases that I was having discussions on LinkedIn with other attorneys, and I think there's been a little bit more. We've seen aggressive requests for evidence, where maybe the service wants to see the economic impact of the client, and I think that maybe in the future that high approval rate will not be, with my current batch, I'm not so sure anymore. In the last year, I've been taking cases that I would historically have considered marginal cases, somebody who has maybe only 1 or 2 publications and a couple citations. Now I'm a little bit uneasy about taking those type of cases. I think I would have to think about it for a little bit to see if it's fits into a good NIW narrative. But it's a great. I just want to say it's a great category, and I hope that it will continue to be this way.
Well, we can't say anything if there's Trump's administration. Anything can happen. But still, we hope, and I think NIW, it won't be end so soon because
I don't think so either. No.
It's very important, and it's not that easy, to end any policy just after your administration. That too. Okay.
Right. The change in the law. I still have to stress it. When I started immigration law, 10 years ago, it was, or when I was a little junior attorney, people were saying, "Oh, premium processing is going to come in the beginning, and everything is going to be digital, and the whole thing will be different."
Yeah,
didn't happen that way. It's still going on. It's still a thing. The only thing that really happened is that the big boom in Dinosaur came in in 2016, and then the huge boom in filings in the last couple of years.
Right.
Huge changes.
Exactly. So, Daniel, let's move ahead. And, as you also mentioned that there's 90+% people, who gets NIW approved. So I need to ask that once an NIW is approved, how does it impact the applicant's ability to change job or start their own business compared to traditional employer-sponsored?
Well, one of the wonderful things about national interest waiver is, again, it's if you go with me, it's your petition, not your employer. So there's no danger of it being withdrawn or or even threats of that. So if you lose your job, it's unfortunate. You still most likely, if you're here in the United States and you're on H1B, you still have to abide by to find an employer for yourself, but you have your green card locked in. There is no way that your employer could retaliatorily withdraw the petition or anything like that. So I think it gives a lot of the clients peace of mind to know that they have this, that it's their own case. They don't have to worry about it. The employer's whims or things like that, and it'll follow you wherever you go. So and it often most of my clients are here in the United States, but like a lot of clients will, I have like international jet setter types that come in and come out. And, I think it's reassuring to have that, that the thing in place.
Exactly. So I think we should agree that NIW is a smart move, and I think it's the best part for a green card, right?
Well, I would, yes. Oh, I love NIWs. I want to promote it as much as I can. But I do, it's still, the backlog. It doesn't get my clients a green card. It gets them in line that they can control it. They get they get a ticket so that they can keep that for priority date for a future event. And who knows, life happens. And some of my clients, they got their NIW and then they become a huge success. Others, things change, you never know. So I think it just helps to have that in there.
Exactly. Completely agree with your points. And also, Daniel, as you also mentioned about denial. So, for example, if there's an applicant, whose application got denied. So, what are the options for appealing or reapplying? And yeah.
Well, that one of the biggest questions I get is people ask me this: what happens if you get a denial? Not much.
Exactly.
I would strongly recommend, unless there's a clear legal error on the part of the service, to refile the case, make adjustments accordingly. If you think there's something could have been done better, but the appeal process with the AAO, the body that does it, the denials most cases are denied. For the appeals. And when the appeals bodies, the AAO gets to review the case de novo, meaning that they get a fresh look at the case. So if the case was denied on a silly reason, they can look at the whole thing again and say, well, actually the service didn't really, maybe they shouldn't have given these points. And they tend to deny the case. I think that it's a much better option to just refile the case. They don't hold it against you at all. Or I haven't had the experience of them holding it against you. I think you obviously have to change, you have to get new evidence. You have to change the presentation. But you can even just be very forthcoming about it, that like, hey, I think I got an examiner, we think that the original case should have been approved, but here's a new case.
Yeah. And also, Daniel, when might it be advisable to file a new petition rather than appealing? Sorry.
I think that when do you really need to, an appeal? I would use the appeal to, the only real value that I can see is to preserve that early priority date, because the appeal process, I think it's I have to check the filing fee for AAO, but it's about $700. It's about the same price as filing another I-140. So I haven't done an appeal in years now. If I get a denial, and denials do happen. I don't want to overstress this. It's part of this business that you will get a denial here and there. If you send in these cases, and usually the answer is refile the NIW from, redesign it, refile it.
Absolutely. Thank you so much, Daniel, for these questions. And I would like to take one more question from our viewers, and after that, we will shift to another part. That is from Santosh. So he's asking that how does the EB2 NIW compare to other green card options such as EB1A in terms of processing times, eligibility requirements, and benefits, and which option would be most suitable for my specific situation? Given the current, given the current green card wait times exceeding decades for Indians like me under the EB2 category.
Okay, so as I mentioned to you, the differences between so with EB1A, you get an adjudication with use premium processing in 15 days. You either get a request for evidence or thing. National interest waiver, it's 45 business days. So that's one difference. NIW EB1A has set evidentiary criteria, a list of evidence, and so it's very structured. It's very this is my list. I hit 3. You have to hit 3 out of 10 criteria, and you move from there. NIW is not that way. It's very freewheeling. You have to argue under the 3 Donasar prongs. The proposed endeavor has substantial merit and national importance. The applicant is well positioned to advance the proposed endeavor, and it would be in the interest of the United States to waive the job offer and labor certification requirements. So you have to meet those 3 prongs, and you make an argument for that. I usually focus on prong 2, but so like it's more. I would say that the NIW is freewheeling, more narrative focused in general. It's more flexible for. I've had it for peace activists. I've had it for artists. You can use it for almost any conceivable field. Whereas EB1A is a little bit more regimented. And like if you're it's EB1A, India is tough to get approved. It's a harder. They're not easy cases. I think that like the big benefit though is I tell my client is it's having that I-140 locked in, the date, the priority date, and then it's like a stepping stone that you can build up your profile for a potential EB1A, or maybe more realistically an EB1C, a manager or an executive. That's one of the principal ways that my Indian clients have gotten a green card through employer spot is through the EB1C mechanism. So I think that it just it's good to get that date, and then you can move forward with one of the EB1 types of cases if it's applicable.
Right. Okay, so I think Daniel, after this episode, I think there will be so many people who are going to have for NIW, because
I hope so. Yeah.
There are so many advantages, and it's also very much beneficial too. So I think it's a very great option for anyone. I think it's a great thing, guys. So any more questions you have, please go ahead and share it with us. And Daniel, here we have a Facebook question that that I would also like to ask. So let's begin with this. What is the difference between a personal statement and a cover letter? Yeah.
So the personal statement is a statement by the client saying this is my opinion. Remember, you can assemble these cases in many, many different ways, but I usually try to get some kind of statement from the client that outlines in their own words, they summarizes their career accomplishments, and then outlines their proposed endeavor. So I am coming to the United States to continue my research, just like Donasar. Or I'm coming to the United States to start a consulting company. I'm coming to the United States to work with policy makers on a particular issue. I am the owner of a company, and therefore I cannot file. I cannot use the traditional perm process. Therefore, I'm using this national interest waiver to get sponsored, stuff like that. The cover letter is for me, and it just is like an outline of the case. I usually tend to, in today's age, I think that there's so much bloat with the rise of ChatGPT and like free AI services that you get these cases that are hundreds and hundreds of pages long. I don't like to do that. I like to keep it like a cover memo, 10 pages, 15 pages, 10 pages, something like that. And then, keep it real simple. Keep it like a succinct package. Succinct, clarity. That's what you want,
Exactly.
You want them to understand the case very quickly.
And, applicants, they fill so much in their file. They think that, giving extra details will make them understand it better. But I think it should be straightforward, and
It should be straightforward. We should take a page from our corporate, the wonderful companies here in the United States. Like they do when they do these pitches, when VCs do pitches. It's not a pitch. This is like a pitch. It's like you don't have a 50-page document outlining the whole thing. No, you have like a 2-page summary. Here, this is what we're doing. This is what we're going to do, and like hopefully the examiner can understand this right there from the get-go, from that page. I just want to I took a tour of the Texas Service Center about 10 years, probably about 8 years ago or so. And on that tour, you get to see what the officers do. And like, they told us that like, these cases are usually hundreds of pages long. They're about 500 pages each one. But the officer maybe adjudicates the case in 20 minutes or less.
Right.
So you want to come in there with a quick, succinct presentation, just so that like, you know what, we're just going to hit the approval button, we're done, move on.
Exactly.
Yeah.
And I think 15 pages are more than enough, right?
Oh yeah, for sure.
Right. Okay, thank you so much, Daniel, for the explanation. Moving ahead, I would also like to take a few more questions.
Sure.
Yeah, like this one. So, when writing a proposed endeavor, should I target a broader audience or a specific state? The state which has the highest number of cancer patients. My proposed endeavor is liver cancer and regenerative therapeutics.
Well, I think that like I would say that like I can't think of any time where I've targeted a specific state. Like, hey, I am going, but you could have a case where I'm going into disadvantaged areas, and I'm going to help with cancer patients, or rural communities or something like that. Yeah, I mean, I think if I had a case like this, if it depends on, you talk to the client, but like if the client says, like, look, the state of Louisiana, the state of Utah has a special program to help things, and I am actively doing it, and this is a model for other states, I would definitely focus on that state if that's what you're truly doing. But, I think that it's like the concept that you have to lock into one might not necessarily be true. I think you should, just tell them the truth. Like, this is what I'm doing.
Exactly. That is how it should be.
Yes.
Oh, okay, great. So, Daniel, let's take one, I think few more questions we take.
Sure.
So, yeah, this is the question.
Okay.
This is quite long. So, should we take it? Are you okay with it?
Oh, yeah, I can take it. That's fine with me.
Okay, great. So, he's asking that I'm writing outside the USA. I recently completed the documentarily qualified stage with my wife in my NIW process. Now I'm waiting for immigrant visa processing, and I have
Right.
had a newborn baby since then. I have submitted a request through the public inquiry form to add my baby along with the required documents. I have a couple of questions. So, firstly, am I on the right track with submitting the request via the public inquiry form to add my newborn?
I think so. I don't actually, the consular processing, I don't have all that much experience with it, but this is what I do is usually, when I have a NIW abroad. By the way, you can file for an NIW anywhere in the world. You don't have to be here in the United States. Most of my clients are here in the United States, but I take international cases all the time. I think that you contact the consulate and let them know that you have a newborn baby, and that to release the DS-260 for the new kid. And then you just follow their directions. I think you submit the birth certificate and stuff. It's pretty. You just follow whatever they're saying. You say, I need to do this, and they'll tell you how to do it.
Absolutely. And Daniel, there's also a second question, that how long does it take typically for the NVC to review and respond to such updates?
Well, I had this is actually a pretty standard scenario that like the client, The client, I've had a lot of cases in China with, they have a kid after the NIW is approved, or, yeah. So, it usually doesn't take too long. It takes like maybe several weeks. You get an email and then you provide them the copy of the relevant documents, whatever they need.
Oh, wow.
Yeah.
Great. Okay, and the last one is that which NVC email did they respond my query? Has anyone gone through?
I don't know.
Yeah.
I don't know.
Exactly.
Yeah. Again, the consular processing is highly specific to the post. There's general patterns and how you do this stuff. But in general, like I have most of my clients are here in the United States. I do have some abroad, but so I have a lot of consular experience with China, Guangzhou and things, but not so much on the on Indian clients for NIW. Yeah.
Okay. All right.
Yeah.
So let's take up. I think. Okay, let me take another one. Yeah, this one we can take. That I got EB2NIW approval as
Yeah.
priority date moving slowly. Do you suggest to file EB1A with PP for fast processing?
Well, that's a good question. Okay, in the scale of cases, all right. I think the national interest waiver is, a little. It's much easier than an EB1A, much easier, and it's even. I think that the national interest waiver historically is easier than an O1 case. So if I have a client who has, getting the NIW approved, it's this wonderful avenue and all this stuff. But in the scale of things, like, I think that, like, well, if you have a O1 approved, that's a pretty good sign that you might be eligible for EB1A. Whereas an NIW, I'm not so sure. You have to look at each case,
right,
as in an individual level. And I think it's very important to be frank with the clients. The demand is so high for EB1A, because of rightfully so, because of the priority dates, that, so many clients want to build up their profile for EB1A. And, does it work? Yes, but it's a lot of people have ambition, but it's not, to actually apply that to get it done it's challenging to get to that level.
A lot.
Yeah.
Of course. And also, Daniel, there's a continuation with this question that then immigration demanding 2,500 to 3,100 USD fee plus 1015 petition fee and PP 2,800 USD. Is there any other reliable US firm with less rates? Is it true EB1A has more chances of RFE?
EB1A definitely has more chances of RFE. The 1015 is just the filing fees. That you can't do anything about that. And petition 2800 is also the things. I don't know, that price seems. I don't like to talk too much about price, but that tends to be that seems like a pretty low fee to me. For NIW for things in general. Like I think that I charge anywhere. It's going to be $5,000 to $6,000 usually for these cases. But it depends on the client. I don't know. Yeah, EB1A definitely has a higher chance for RFE. No question about it.
All right. Okay. So we are definitely going to, share these information. And Daniel, here we have one more question that my EB-NIW case approved from USCIS and my PD is 18th March 2024, while I have received first notice of information from NVC and they mentioned my PD 18th May 2024. For correction in PD, I sent 2 times inquiry to NVC. They replied The correspondence submitted is currently under review, and appropriate action will be taken once this review is completed. So her question is that I want to ask how much time I should wait for the correction. Is there any other way to contact NVC, or should I inform USCIS also that my PD is wrongly delivered?
I think that it sounds to me that on the I-140 receipt notice, the original submission, I'm assuming that the correct date was there. The 18th of March. For the PD issues, I think that what they did for the review sounds reasonable. Letting them know that there's a problem, and just showing them the receipt notice from the original one and then the approved case with the number should be enough. One of the things, if you use premium it's hard for me to say how you do it on state side, with consular processing. But if you have a problem with this if you have premium processing, one of the wonderful things that you can do is you can call the premium processing phone number, and you can speak to an officer and just say, hey, my date's wrong. Can you correct that for me? This is a clear error. And usually they're okay with it, making these kind of minor things, they note it and move on, Yeah.
Absolutely. So I think, Daniel, let's take one more last question.
Yeah.
And I think, let me take,
Sure.
This one. So, Daniel, is it mandatory or recommend to use USA address in I-140, and especially which section, EB2 and IW?
Oh, this is a very good question. Actually, okay, so national interest waiver is not based. You should put a U.S. address where you intend to work or things. So you pick a state. I am, if you're abroad, and you say, I intend to work in New York City. I intend to work in Texas. I intend to work things. A lot of clients ask me. The way that they adjudicate these cases, it's done, geographically. If you live in one, the Nebraska Service Center will handle it, or the Texas Service Center will handle the national interest waiver. And people ask me about form shopping, should I move? Should I have my address so that the Nebraska Center adjudicated my case versus the Texas Center? I tend to say no. You shouldn't do that. You should just have a true where you intend to work in the United States, or where you think, or the most likely address. It is important, though. If you have the mailing address that you put on that I-140. Try to make that a stable address, because I've had over the years, one of the most annoying things is that sometimes I have, the green card will go to the original address that was, submitted on either the 45 or the I-140, and the client has subsequently moved without telling me, and then, it's like a mess. Once I had a client had to go from New Mexico to Indiana to pick up his green card, it was at the post office. And it's like, if it gets messed up, it's really expensive and hard to get them to correct this stuff.
Absolutely.
So be careful of those addresses. Yeah.
All right. So I think we are done with our Facebook questions, and we are almost come across for 1 hour too. So, Daniel, I think it's time for us to wrap up the session, as we have already covered 1 hour. So, Daniel, first of all, you tell me, how was your experience to Immigration and Jobs Talk Show?
Oh, this is great. I love talking to an international audience and talking live. It's a lot of fun. I hope to spread the word of the wonderful benefits of using the self-sponsored cases like a national interest waiver. I do handle other self-sponsored cases too, like EB1A and things. But it's always a pleasure to talk about this stuff and to talk about the cases and where things are going.
No, and that too, we can also see you were so energetic and full of information. So I think
Yeah.
not only we, our audience also loved your insightful session, and it was so great to have you. So, Daniel, any last message that you would like to give to our audience?
Well, I would like to, one of the things that I'd like to do is to encourage people to have confidence in themselves and confidence in their abilities, and that these cases are possible, that it isn't something that you are beholden to, an individual employer, that you can take control of your own situation. Now, I know I am fully aware of the backlog and all the hardship that has caused, and the things. But I still think taking ownership of your status is a wonderful thing, and it's empowering. It's great, and I hope that clients take advantage of this and use an expansive view of these things.
Correct.
So,
And I think that's a very positive message. So thank you so much, Daniel. It was
sure.
great. And to our audience also, guys, if you want to ask anything, any question related to NIW or anything about immigration, so feel free to reach out to attorney Daniel Stephen Larson on the given details. That is 415-520-1474. You can also
Yes.
email him at contact@larsonlegal.com, and surely visit his website, that is www.larsonlegal.com. So, all right, guys, thank you so much. And thank you, Daniel, to you too. It was a pleasure having you, and it was great, to host
Yeah,
with you.
it was a
Yeah.
tremendous honor and pleasure to be on your show. On
Me
the
too,
show.
me too.
Yeah.
Same here. Okay, guys. So thank you so much, everyone, for joining us today. To all our lovely viewers and to Attorney Daniel Stephen Larson. Don't forget to like, share, and subscribe to Immigration and Jobs Talk Show. I'm Sam, signing off for now.
Thank you so much. Take care.
Thank you. Yeah. What is the process for obtaining a J2 visa, and how does it depend on the J1 visa holder?
Everything that applies to the J1 applies to the J2 visa holder as well.
Is the length of stay for J2 visa holders directly tied to the J1 visa holder status?
Correct. The J2 visa status is directly tied to the J1's visa status. So if a J1 is issued for 4 months, the J2 would also be for 4 months.
Like, can J1 and J2 visa holders study in the US? And if yes, then what are the specific requirements?
There's definitely a lot of benefits to
Hello and welcome to today's episode of Immigration and Jobs Talk Show. I'm your host Sam, and today we have a very special guest with us who has joined us for the very first time. And before announcing that, I would directly go to our important disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. So, use of information is at your own risk. So, viewers, I would like to say that today it's going to be a very special episode. The guest who has joined us today for the very first time, and I'm thrilled to introduce Attorney Poonam Gupta, who is a renowned immigration attorney with 25 years of experience in the immigration field. And let me tell you that she also has experience in intellectual property and litigation. So, Poonam, first of all, a very warm welcome to Immigration and Jobs Talk Show. And I would say that it's really an honor to have a show with you. And thank you so much for being a part of Immigration and Jobs Talk Show.
Thanks, Sam. Great to be here and looking forward to an exciting discussion.
Of course, sure. We would definitely have a very insightful and exciting discussion. Poonam, as this is your first time on our show, so I would like to know that how you're feeling right now.
I'm feeling pumped, great, and excited to help people understand more about immigration.
Wow, that's great. So, as this is your first time, so could you please take a moment to introduce yourself and share a bit about your background and experience in immigration law?
Sure. I grew up in India and then moved to the US. I practiced in India for a few years and then moved to the US. And I've been here 25 plus years. And I started in immigration went down to do some litigation, and then came back to immigration about 14 years ago. And I've been doing immigration, US business immigration, exclusively for that time. And in that time, I have advised clients in all industries, all sizes, all stages of their development, from starter to startups to multinational Forbes 50, Forbes 10 corporations. So I've seen the entire gamut and pretty much everything there is to see on the US business immigration side. But US immigration being what it is, there's always things that we learn, even today, even after 25 years. Every single day, there is something new to learn. There's some nuance that is, we haven't seen before, and we see again and again. So it's always exciting.
Wow, that's so good. So, Poonam, as an immigrant, was it challenging for you to shift from India to USA, or was it easy for yourself?
Being an immigrant is never easy. Immigrants face a lot of hurdles, face a lot of challenges, and it's an emotional roller coaster for most immigrants because they're leaving behind things that they grew up with, things they're comfortable with, into a completely unknown culture, completely different culture. And in US, it is even worse because compared to what we grew up in India, coming to the US is a culture shock in some ways, but in other ways, the nuances of the society, the etiquettes and so on, are very, very different. So it was a challenge, but I think I've assimilated fairly well and become fairly comfortable. And my goal is to help other immigrants and ease their journey as best as I can. That's why I'm in this business and I'm doing what I'm doing.
Yeah, I was about to ask that only that because of these challenges that you face, that's why you decided to become an attorney to help others, and you answered that.
Yes,
All right.
definitely.
Yeah, well, that's a great start, I would like to say. And our viewers also know you, and that's really great. So I hope that this is just a start of many more great conversation together.
Yes, for sure.
Of course. Okay, all right. So, Poonam, I would like to just directly jump into today's topic. That today our session is about, can J1 and J2 visa holders legally work in the US? Explanation by none other than attorney Poonam Gupta. So let's directly ask our first question. So, Poonam, let's start with the basic understanding of today's topic. Like, can you please explain what are the key differences between J1 and J2 visas?
Sure. J1 is the primary person who's being sponsored to come to the United States, and J2 are any of their dependents. Dependents under US immigration law are defined as spouse and children under the age of 21. Dependents are not parents, uncles, aunts, or any extended family or grandparents. It's simply spouse and kids under the age of 21. J1 holders, depending on what they are coming to do in the US, and there are several categories of J1s. They could be working, studying, any of those things. And J2 have to be individually sponsored by the J1 sponsor as well. Unlike some of the other categories, like for instance in H1 or L1, the dependents can apply for their visas simply on the basis of the principal applicants or the principal immigrants' documentation. For J2s, that is not the case. They need to be sponsored separately, and they need their own separate DS 2019.
All right. That's great. So, Poonam, let's move ahead with our second question that I would like to ask, that what is the process for obtaining a J2 visa, and how does it depend on the J1 visa holder? What can you say on that?
Absolutely. As a dependent on the J1 visa holder, everything that applies to the J1 applies to the J2 visa holder as well. As I said previously, each J2 dependent has to be sponsored separately by the J1 sponsor. they have to, the J1 sponsor has to issue a Form DS 2019 for each J2 applicant. And then the J2 applicant applies for a visa at the US consulate directly. And they apply, they can either with the J1 holder or after the J1 holder, like most other categories, it's directly dependent. So whenever the J1 status ends, the J2 status will also end.
Now, I would like to talk about program duration and stay. That how long can J1 visa holders stay in the US? And does this duration vary by program type?
Absolutely. So there are many different program types. J1 is one of the most versatile programs the US Department of State administers. It could be for as short a duration as a couple of months. For camp counselor or summer work travel, the maximum is 4 months in those cases, up to 5 to 7 years if someone is coming to do research or be a physician in the US. So depending on the program type, the length could be a few months to a few years. And I can go into those details if you want later, but that's the broad brush.
All right. Okay. So, Poonam, what can you say? That is the length of stay for J2 visa holders directly tied to the J1 visa holder status?
Correct. The J2 visa status is directly tied to the J1's visa status. So if a J1 is issued for 4 months, the J2 would also be for 4 months. And the critical thing to note here, similar to F1, when the F1 or a J1 enter, or J2 for that matter, enter the United States, their I-94 document will not have a definite end date. It will say D/S, which stands for duration of status. The end date on their application of their stay is actually on the Form DS 2019, and that is something that defines the period of stay that is permissible. So the DS 2019 is the controlling document for the J1s and the J2s.
So, Poonam, what can you say about work and study opportunities? Like, can J1 and J2 visa holders study in the US? And if yes, then what are the specific requirements?
So the J1, depending on what they are coming to the US to do, that will dictate what they're permitted to do, whether they are studying. If they're coming here to do a university program, for instance, then obviously they're coming here to study, and they can definitely study. Can they work alongside it? If they're coming to study, then potentially they could work. Their the J sponsor would be able to guide them on what the parameters are for their work in the US. So they could engage in academic training, which is similar to the optional practical training that F1s have. And the academic training could be during their course of study, it could be after the course of study, and the duration of that would change. Moving to J2s, J2s can study part-time, full-time while they are in the US, and they can also work while they are in the US. And the only requirement, unlike some of the other visa categories, is they need to apply for an employment authorization document from USCIS before they can work. But they can study without anything further, just by basis of their J2 status.
All right. So, Poonam, as you mentioned right now about the academic opportunities and academic journey, I would like to ask from you that I noticed that you started your academic journey with a BSc in zoology from Delhi University, right? But
Correct.
later you pursued an LLM from New York University. So I'm really curious to know that how you shifted your zoology, career from then to LLM. What was the journey? Was there some experience or incident happened that changed it, or what it was?
Sure. So I had my heart set on going to med school in India, but as you know, med school is extremely competitive. And I wanted to be in the cutting edge of technology, whatever it was. I finished my zoology degree and enrolled in the master's program, and realized that very quickly realized in my master's program that that was not how I wanted to spend my life. I could not see myself in a lab working with, working on experiments in isolation. For me, helping people and being out there and doing things with people is important. So I pivoted to law. My dad's a lawyer, and I got his advice, and he'd never pushed me to pursue law, but he was pleasantly surprised and happy that I thought about law. And I went into law in Delhi. I did my LLB in Delhi and then practiced in Delhi. I practiced intellectual property law at a top firm in Delhi for many years before I came to the US. And then in between my law in Delhi, I went to Cambridge on a full scholarship to do a master's there. And then when I moved to the US, I got a scholarship to study at NYU and did my master's to take the New York bar. So, and then when I came to the US, the immigration piece just pivoted and changed everything for me. And I found my true passion in immigration.
That's really great. Finding your passion gives you so much happiness. And that's so good to hear it from you. I must say that. All right. So, Poonam, I would just like to share with our viewers that, guys, if you are navigating the intricacies of visa applications or facing any legal challenges or simply need just guidance on the latest immigration policies, then please contact attorney Poonam Gupta. You can also email her on info@summit-legal.com. And for sure, visit our website www.summit-legal.com. All right. Now, moving ahead, and if I want to talk about career impact and opportunities, then how can holding a J1 visa enhance the career prospects in the home country after completing a program in the US?
There's definitely a lot of benefits to doing a J1 in the US. One is international experience and exposure to a US work culture and practice, which is a very professional environment, unlike a lot of countries, not all, and definitely not in the Western world, but some of the other countries where even though the environment may be professional, the US work culture is very different. So getting exposure to that is a huge plus in my view, having worked in India and in a very professional environment. The level of professionalism in India compared to the UK, where I also worked, compared to the US, I would say the US has the most professional of all environments among the three. So that I think is a huge plus. And then the second is in this global economy, having a global network, coming to the US and connecting to people from different backgrounds is invaluable, invariably. And no matter what you do, there are ways in which you can leverage your connections in different countries and in the US to grow in whatever industry you are in when you go back to your home country. And obviously, because you're coming to the US on a J1, there are some skills or some knowledge that you're seeking to gain by coming to the US. You'll obviously gain those as well. So depending on the motivation behind that J1, those are the top three things that come to mind.
Thank you so much, Poonam, for your detailed answer. And let's move ahead with my another question that I would like to ask. That is, how can J2 visa holders leverage their time in the US to build professional networks or gain work experience despite restrictions?
So there are actually limited restrictions on J2. J2 is one of those categories where they are allowed to work as soon as they receive their employment authorization document from the government. The only restriction they have is during the time that they're waiting for that work authorization papers to come through. Once they have that, they can do whatever they want. They can start their own business. They can work for anyone for as long as they want. They can work for multiple employers. There are no restrictions on that. So obviously, applying for work authorization is great because working in any industry or any area gives you the leverage and the experience that simply being on the fringes does not. So I would encourage all J2 holders to, and that is only spouses. The kids cannot work on it as a J2. Only spouses can work as J2. So they should definitely leverage their time and apply for work authorization. While they are waiting, they can definitely enroll in some schools. And these days, networking opportunities abound. No matter what city you are in the US, there is some group, some event, networking event that you can be a part of. So I would highly encourage everyone to go out and network and find people who share your passion that can help you grow together. And it's always beneficial. Last but not least, they can volunteer. I recently posted on LinkedIn about volunteering and the pitfalls surrounding those. So I would encourage everyone to look at that. In summary, volunteering is something that is for an organization or a role that is purely a volunteer role. It is not a role that is meant to displace any paid work. So those are just some opportunities, some options to keep in mind. But the world is open to J2s.
Right. Okay. So far so good, Poonam. Now, moving ahead with the next question, that I would like to talk about work authorization for students on J1. So, can you please explain that what work authorization options are available to students on a J1 visa?
Sure. So as I mentioned earlier, J1 visa holders are eligible for work authorization. Most of them, and again, depending on what visa category they're coming, what program they're coming for, most of them are for work or getting trained while they work. So somebody who's coming in as a college or university student, they have ability to work on campus or during their coursework, after their coursework, as part of their academic training. If they are coming in as a researcher or a scholar, again, those are work study or working options, and they would be working and being trained accordingly. Then the interns and trainees also are programs where somebody's coming into the US to intern at a host company and work at that company, or trainee will train at a company. So they will be working. Work is part of what they are getting, and they get trained while working. So the only category of J1s that need work authorization are the students and the academic training. Most others are working and training simultaneously.
Great, great. Okay, so how can J1 students apply for work authorization while maintaining their student status? What can you say on that?
Sure. So J1 students go to their J1 sponsor and seek work authorization. It is an endorsement on their DS 2019. And sometimes they may require an employment authorization document from the government. But any work authorization has to be approved by the program sponsor. For scholars, that is, for J1 students, that would be the form of academic training. And that academic training can be before they complete their program or during their program. sorry, when I say before, I meant while they are in their academic program, or they can do it after, at the end of the academic program, similar to optional practical training for F1 students. So they will need authorization from the program sponsor in summary.
All right. Thank you, Poonam, for your answer. Now, let's move ahead and shed our lights on visa extensions and transitions. So, what can you say, Poonam, on this? That what is the process for extending a J1 visa, and under what circumstances can an extension be granted?
So most programs have a limited duration, and the program sponsor, and if, say, for instance, for trainees or interns, the maximum duration is 12 months to 18 months. If the program is completed in that time, then great. If there is additional time required, then the program sponsor is the only one that can decide whether or not they will grant that extension. So if the host company requests that they need additional time for that additional program to be completed, they apply for, or the J1 applicant applies to the program sponsor with supporting documents and explanation for why they need additional time. Then the sponsoring organization will issue an updated DS 2019 indicating the extended period. Most of the time, when a person is extending their J1 program, they do not need authorization from the government, from USCIS. They simply need an updated DS 2019, and that is sufficient. But if they're going to switch from one visa category to another visa category, so say from an academic J1, they want to switch to a research J1, then that is a different category, and a different program sponsor will approve the J1. In that case, they will need to go to USCIS and request that extension and update. But if they're simply extending, the program sponsor's issuance of a new DS 2019 will suffice.
Great. So, Poonam, my next question to you is that can J1 visa holders transition to another visa type, such as H1B or a green card?
Technically, yes, they can. The big restrictor for most individuals is if they are, whether or not they're subject to the 2-year home residency requirement. How will you know whether you're subject to the 2-year home residency requirement? There are two places to look. One is your DS 2019. Program sponsors will mark on the form on page 1 whether or not you're subject to the 2-year home residency requirement. Or when you apply for your visa at the consulate, on the visa itself, there would be an annotation subject to 212E, 2-year home residency requirement. If you have either of those, and sometimes there are mistakes, sometimes you're not subject, but the officers may make a mistake. But if you have any of those annotations, you are subject to 2-year home residency requirement. What is the 2-year home residency requirement? It means that you have to go back to your home country for at least a period of 2 years cumulatively. It doesn't have to be together, but over a period of time, you have to go back home for 2 years cumulatively before you can come to the US in H1B, L1, or a green card. So that is critical and important. And can they transition to other visa types? Yes, there are lots of options. They can transition to F1, H1, L1, O1, E1, E2, green card, from family-based or whatever. But depending on what the criteria is and whether or not they're subject to the home residency requirement, whether they can switch to that status will be dependent on that annotation.
All right. So, Poonam, my next question to you is that are there options for J2 visa holders to change their status to another visa type while in the US?
Yes, they have the same options as a J1, and a lot of them do all the time. They are also subject to the same home residency requirements as the J1 because they're dependent of that J1. So, for instance, an Indian national is subject to a home residency requirement, but a German national may not be. So, an Indian married to a German, the German gets a J2, they will be subject to. If they had applied for a J1 on their own, they may not have been, but because they're applying as a dependent of an Indian, they would be subject to the home residency requirement. And until they complete that, they would not be able to move forward to that. So, same restrictions, same options, same everything. Just be mindful of that.
Okay, thank you so much, Poonam, for your answer. Now let's talk about two-year home residency requirement. So the two-year home residency rule can be a major hurdle. So what creative solutions have you seen for J1 visa holders wanting to stay in the US longer?
So, most people think you can apply for an H1B after a J1. USCIS does not like that. USCIS wants the J1 visa holders to go back to their home country and apply the skills that they've learned in the US in their home country. One option is to apply for a waiver if waiver is available, or switching or doing consular processing. So, I mean, you cannot switch to an H or an L from within the US or outside the US if you have a home residency requirement. But if you have a home residency requirement, you can apply for an O1 outside the US. You can go to the consulate, apply for an O1, and come back. But if you want the green card, before you are able to get the green card, you have to go back home for 2 years or get a waiver for the 2-year home residency requirement before you can get the green card.
And how does the waiver process for the two-year residency requirement work? And what compelling reasons can support a waiver request?
So there are 5 statutory bases for a waiver. The first is a no objection statement. So the home country for the J1 applicant has to provide a no objection, that they have no objection to granting the waiver. And if they give that no objection, then the person can apply for a J1 waiver with the Department of State and then, if needed, with the USCIS. If there is a US government agency that is interested in the work that the J1 applicant is doing, then they can request a waiver to keep the J1 person in the US in the public interest. Number 3 is persecution. If the J1 visa holder would face persecution on account of race, religion, or political opinion if they return to their home country. I imagine if that is the case, then they would also potentially qualify for or apply for asylum. Then the 4th is extreme hardship to the US citizen's spouse or child. And if they're married to a US citizen or a lawful permanent resident, then they may also have other pathways open to them, but they would still need a waiver. And the last is the Conrad State 30 program. This is for J1 physicians who work in medically underserved areas for a specific period of time. And then the way this works is, the most common way is requesting a no objection certificate from the government, from the home government, and using the documents, including the no objection certificate and any other documents that the Department of State requires, including the form DS3035, and submitting it to the Department of State once the Department of State approves, they send the recommendation for the waiver to USCIS. In some cases, there may be a need to file the Form 612 with the government, but in most instances, it is not required.
So, Poonam, after learning so much, why don't we shed our lights on the future trends? So, what can you say that with this evolving immigration policies, what changes do you foresee for the J1 and J2 visa categories? And could we see more leniency or new opportunities in this?
Sam, this is an election year in the United States. So, depending on which administration is in power next, we could see an immigration-friendly administration or an anti-immigration administration. And depending on where they are and what their priorities are, for an immigration-friendly administration, we could see efforts to simplify and expedite the J1 visa process, reduce the bureaucratic hurdles and processing times, potentially expanding the program categories to include high demand areas like STEM, or updating the 2009 skills list, enhance support for waivers, and so on. There are a lot of areas they could do good in. Or they could remove the requirement for J2s to require an EAD. This is just one example. But on the flip side, if the administration is not immigrant friendly, then we could see heightened security and denials. There could be increased scrutiny of J1 applications, more rigorous vetting processes. There could be reduction in program categories that could be restricted or eliminated. And I would think the interns, trainees, or the au pair programs may be reduced or eliminated. There could be stricter enforcement of compliance. There could be limitations on waivers, increased processing times, and so on. So immigration is very dependent on the administration and administration priorities.
All right. So, Poonam, as you mentioned about the election, now my next question would be like this only. Now, do you think that there really will be a mass deportation, as Trump says about it?
It's a soundbite. Whether it is something that can actually be enforced and whether the government has the resources to execute on something like that remains to be seen. I remain skeptical, but we don't know the extent to which any government will go in promoting the anti-immigrant sentiment. So I can't say anything more than that. I think it's just wait and watch.
Yeah, because Trump is completely unpredictable. You never know with him, right? What he does, what is his next step? Completely unpredictable.
Correct.
So, Poonam, do you think that the J1 visa program will expand to include new industries or sectors, especially with the rise of remote work?
Again, I think this is dependent on the administration that's going to be in power next time round. It could, but the remote work is actually being curtailed in the United States more and more. More and more companies want their employees to be back in office full time, similar to pre-pandemic. But we'll see.
All right, all right. So I think we have covered great amount of questions till yet. And Poonam, one more last question that I would like to ask from you: that have you encountered remarkable cases where J2 visa holders successfully transitioned to their own independent visa status, and what made their journey stand out? Please tell our viewers about this.
Yes, actually, I do have one. So I had a client who was the head for a nonprofit organization. She was on a J2 status and was able to transition to an H1B and has made her life in the United States and is successfully charting new territories in the United States after pivoting to H1B and getting her green card. It's just for me, seeing women come out of their from behind their dependent status and building on it and making something of their professional journey and not delegating their professional journey to their spouses and their partners is always inspiring and empowering. And I like to support as many as I can in that sense. So this J2 holder was, it's the story is really near and dear to my heart, and I am very proud of her.
Wow, that's so good. I mean, but I would say that after hearing these stories, many of the people are going to inspire from you and they are definitely going to keep you as an idol. So it's really good to hear these things from you. So, Poonam, it was really great having you. But before wrapping up, I would like to ask that any last message you would like to give to our viewers about who are applying for J1 and J2 visas?
I would just say be mindful of the 2-year home residency requirement and work around it and plan for it. There are people who come from India who come just for the summer program in high school or in college because they want that experience of being in the US and don't realize that they're stuck with a 2-year home residency requirement. So please read your papers. Please read the immigration documents carefully and educate yourself and be proactive about your immigration journey. Don't let somebody else dictate it for you. It's your life. Take charge of it. Thank you.
And also to our viewers, I would like to say that, guys, please contact Poonam so that doesn't matter that whether you are just applying for the visa, but even if you're navigating the intricacies of visa application or facing any legal challenges or just simply needs guidance on the latest immigration policies, then please feel free to contact attorney Poonam Gupta on the given contact details that I would like to read out. Her email ID is info@summit-legal.com and her website is www.summit-legal.com. So that's all I would like to say. And finally, Poonam, I would just want to say that it was truly appreciating you having on the show, and it was so good. And I would love to have more and more shows with you. It was so good. And anything that you would like to say to our viewers?
No, I think this is great. You're doing a great service to all immigrants in helping them learn about themselves. And as I said, no two immigration cases are the same. So please do not try to apply anything that you hear in any video to your situation. It may seem like it's identical, but it's unlikely. It may be similar, but it's unlikely to be identical. So please, to the extent you can confirm with information from the government website, great. Otherwise, consult with an immigration attorney that you trust and go forward and take charge of your immigration journey. Good luck.
So thank you, Attorney Poonam Gupta, and also to our viewers. And I would just like to say that in case if you have any questions or want to connect with Poonam, please feel free to contact her on the given details. And also stay informed by liking, sharing, and subscribing to the Immigration and Jobs Talk Show for more updates. Thank you so much, everyone, for joining us. And I'm Sam signing off for now. Thank you.